Your Lordship, kindly leave to mention one very urgent tender matter, Lordship, to move tomorrow, Lordship. The urgency is that the person who has been selected does not have the credential. I have given the detailed representation without considering they have issued work order, which will be given it on online from Monday, Lordship. Kindly, Lordship, take up
Work
tomorrow.
order already issued.
Work order issued, Lordship, but work has not started because I am still there.
When the tender was open,
Lordship, tender 24th, Lordship.
then
And then selection was done 25th, Lordship. And today's Lordship 27th, Lordship. So, Lordship, kindly to Monday they will give an effect, Lordship. Can you take up tomorrow, Lordship? Otherwise, it will be
Milord,
much obliged.
leave granted to affirm and be listed tomorrow as an urgent motion.
Much
Milord,
obliged.
may I have a kindly to mention to Lordship, my lord, it is the disconnection of electricity without notice, and the senior citizen, we have paid the money. My lord, I have filed the matter, my lord. I mentioned the matter before Lordship, my lord, yesterday. I have filed the matter yesterday. Let the matter be heard, my lord, because I have served tomorrow.
Let the come on the list.
Huh?
You filed only yesterday.
Yes.
So what is the urgency?
Urgency is this, my lord. I am having the premises without connection.
So many persons are there without electricity.
Lordship, kindly consider because there are physical element, heart patient.
Huh?
Heart patient.
When the electricity was disconnected?
13th.
13th. Then
I have issued the notice. I have made payment. Matter sent back by the special judge Malda to National Lok Adalat. It was settled within the parties. I have paid the money.
Okay. Okay, listed on Monday.
My lord, may I be permitted to mention, my lord?
As urgent motion Monday.
I'm get full, my lord.
One extension for interim order, my lord.
May I have my lord's kind leave to mention a matter, Milord?
Listed as an application to be mentioned for extension of
One urgent
electricity, there is no urgency.
May I have my lord's
education of the children badly affected, my lord.
When the exam is going on?
Last week, my lord. Last week, my lord.
Last week exam started.
Yes, my lord.
When the electricity was disconnected?
Last week. Date is not yet received, but electricity connection has been obtained. We have placed for restoration.
When the electric connection was disconnected, sir?
In the month of November, first week.
You are the advocate on record. You are not having the date when the electric.
5th November, my lord.
5th November. So 20 days. What? Let me wait for the 2 day, 1 week.
I have my lord's kind.
Let it be listed, my lord.
It will be listed. No motion will make you.
May I have my lord's kindly to mention a matter for to be listed as urgent motion, but the scheduled date in the presentation form was yesterday, minute. The matter did not appear. The urgency is, minute. There are stalls and trolleys at the railway station by the policy of the government of the railway board, minute. Both were made having distinct entities. But all across the country, all the divisions are making it distinct entities and not making it co-terminus, except for the Kharagpur division, which is under Southeast Railway, minute. Other stations of Southeast Railway are making it distinct. Only this division has passed an order saying that they are co-terminus and you have to, despite my trolleys being in existence, the contract being in existence till 2026, they have not terminated my trolleys. So taking that as a cause of action, I have instituted this writ, made this appear, because if my trolleys, despite the contract being
Tuesday to be urgent motion.
May I have
Tuesday.
Your Lordship, may I mention Your Lordship, may I mention a matter?
May I have your lordship's leave to mention one matter relating to a senior citizen, my lord. She is 86 years of age. I have filed this on the 7th. It was scheduled to appear on 18th, my lord. It is not.
What is the matter?
Lord,
What is the urgency?
The urgency is, my lord, she is in a state of dementia. She is in a vegetative condition. The petition has been filed by her daughter seeking certain reliefs for her on her part.
For what relief we have asked for in the writ application?
Means that she be appointed as a guardian in respect of her mother, because she is unable to take any decisions in respect of herself. That is the urgency that I'm seeking. That is the only prayer that I'm seeking. I'm not asking for any other relief. This is the urgency. And she is in a state where anything can happen any day. That is the only urgency that I'm seeking. Let it be listed at your lordship's convenience anytime next week.
Wednesday urgent motion.
May I have
your Lordship, may I mention a matter?
Item number 276 of the days list. But I'm praying for 276. but I'm praying for upgradation. The matter is this, I am a leaseholder. The Jila Parishad, the Hooghly district, the entire agreement with me, they provided lease for 2 years. And the lease tenure expired in the month of April. But beforehand, I approached them for renewal of the lease because there is a clause for renewal. But they have not, but one plea or other, they are saying that they are processing all these things.
Till April it is valid.
But I am there in the position, but now the development is this. The public is now started disturbing. Your Lordship knows in the village area, they have all the knowledge.
What the report will do with
I approached them, let there be the direction to
what you have prayed for in the writ application.
But I prayed for a direction upon the Jila Parishad to consider my approach to them for renewal, because they are.
When it is going to be completed?
It has completed during the pendency of my approach, but they have not decided.
When it was completed?
In April 2025.
So there were no April to November, there was no urgency. What is the urgency now after the 8-9 months?
Till date, the Jila Parishad has not issued any notice.
Correct.
They have not alleged anything, but the public is disturbing my peaceful possession. Because
what the court will do with the public?
Court can ask the authority, since there is a renewal clause.
For extension
But
of
Your Lordship kindly fix any date.
extension of interim order, Your Lordship.
Your Lordship, may I mention an unlisted matter for listing, Your Honor?
For inclusion in the list, there is another.
New motion, inclusion, restoration, give the all documents.
Your Honor, may I make a mention of unlisted mentioning for
Yes.
listing of a matter, Your Honor? Your Honor, there's an urgency in the matter. I am challenging the arrest and illegal custody. Your Honor, I have to surrender back on 6th of December. Your Honor, I have to come from Delhi. I'm
For the
asking for
inclusion of
listing
this.
on 6th, Your Honor.
What-
Your Honor,
what-
the writ Your Honor, I'm asking for a listing of an unlisted mentioning. I'm doing for listing of an urgent writ petition, whereby I've challenged my arrest and illegal arrest and remand orders that have been passed. Your Honor, the writ petition has been filed. It's numbered as 27195.
Illegal arrest, police non-action. Why before this court? You go to the other court. This court is
Your-
not having the determination with regard to the police action.
Your Honor, I'm also challenging the remand orders passed by the court. All the
Correct.
consequential proceedings, Your Honor.
Correct. If you're, it is a police non-action or inaction, you go to the other court, madam. This court is not having the determination.
Your Honor, but as per the list, the writs have to be listed before Your Honor. The only remedy lies is a writ petition before this court, Your Honor.
Writ petition, I am not disputing, but not.
Your Honor, I'm
before
only
this-
writ.
this
Your Honor, I
court is-
filed a writ petition only. I filed a writ
That's
petition
correct.
only.
But this court is not having determination of the police inaction.
Your Honor, but the writ petition for the arrest and remand orders, original writ petitions is writ in the nature of mandamus lies before this court.
Go to the
That's-
other court, see the determination and mention before the appropriate court, madam. Yes.
Lordship,
Please,
may
Your
I
Honor.
mention two electricity matters, Lordship petition.
No electricity.
Lordship, entire building is without electricity, Lordship.
No problem when the matter will be.
Lordship, may I be permitted to,
Electricity on the matter is not.
Lordship, in extreme urgent condition, Lordship, I am mentioning.
I am paying, Lordship.
Every day you are having 2 or 3 matters.
Lordship,
No problem.
one matter, Lordship, I am
Lordship,
paying without
that
electricity,
the
Lordship. only-
petitioner has
When
some
this was
allegations.
disconnected,
Lordship, not disconnect, a new electricity connection applied for.
when you applied for.
Lordship, in the month of November, Lordship, thereafter they went for inspection,
Ah.
the private respondents objected, and the petitioner's premises is without electricity. Lordship, I am paying one matter we have uploaded, Lordship.
Thursday roko, next Thursday.
Under compelling
Wednesday
circumstances,
roko. Urgent motion.
Lordship, under compelling circumstances, I am mentioning, Lordship, the matter was filed against the CWC, Lordship, that the child in question, Lordship, he was aged about 5 years. Now, Lordship, what happened? The allegation against the wife, and subsequently in another connecting case, Lordship, the wife has been arrested. Now, the child is under the when the wife was arrested, Lordship, child was taken under the custody, Lordship. He is
Was
now
taken
in
the custody.
that the concerned police, Lordship, then
CWC.
after no CWC, Lordship,
Ah.
that the police has taken custody of the child along with the mother. Now they are lying in the Alipur Correctional Home, Oman, Lordship. I am the father.
Wife is in the correctional. Where is the child?
Child also with her Lordship. I am asking the direction to CWC to take care of the child, Lordship. I have already filed this writ application
When
in
she
early
was
on.
arrested.
Lordship, day after yesterday, Lordship. Yesterday that produced before
Day
the
after
no, Lordship, yesterday, Lordship. He was arrested and produced before the concerned Chief Judicial Magistrate, Lordship, that is in Ulberia. Subsequently, the direction has been given by the concerned Chief Judicial Magistrate to for 14 days custody, Lordship. Now the child has been also taken into custody, Lordship. I am asking for a direction to the CWC to take care of the child, Lordship. I have filed the writ in the earlier, Lordship, with all
the
these
order it
allegations.
is mentioned the child will be remain with the mother in the correctional home.
No, Lordship, that happened. It's a subsequent development, Lordship. My
Who has
request was
taken, how the child has gone with the mother?
but
without the
child was with the mother, Lordship.
Mother is in the custody.
Is in the custody.
So how the child has with the mother? Without the order of the court or without the order?
That is my question, Lordship. Lordship may direct, Lordship kindly
So how the court can ascertain whether child is with the mother?
Lordship, I will come up with a supplementary affidavit, Lordship, fixed on Monday, Lordship. I will assist your Lordship on that aspect, Lordship.
Pleading is not complete. You have mentioned. Why you have
No,
mentioned?
Lordship, my writ petition is pending since long, Lordship.
File the supplementary affidavit.
The Lordship, that subsequent development, that is not in my writ
File that
application.
you mentioned.
Lordship, that kindly list the matter, Lordship.
Lordship,
Lordship.
my matter is of a tender matter, and the urgency is that the matter has been filed in August after the termination of getting the termination notice. But after filing the writ petition, when they get the service notice, they have violated the terms and condition, and they have changed it to the SOCAS notice in the month of September. And after that, they haven't cooperated with us. They have made any payment after July, and after that we have filed a can application. And after filing that can application, they have become totally non-cooperative. They are not allowing us. They are neither making any payment. They are neither.
Go to the civil court for
Lordship,
the
my lord,
Kindly be allowed to mention, Lordship. Lordship, may kindly be allowed to mention matter, my lord, item number 250 of today's list. My lord, on last 18th, Tuesday week earlier, I mentioned before your lordship under the compelling circumstances and considering the gravity, your lordship directed the matter to come under urgent heading today.
What is the urgency? What is the urgency?
My lord, grave urgency is I am without any egress or ingress to my property. And my small shop, which is the means of my sustenance, that has been closed by use of utter muscle power, my lord, and political influence, my lord. Your lordship considered the urgency and directed the matter to appear today under heading urgent motion. But my lord, it is coming under new motion, my lord, at item 250, my lord. Kindly fix it up.
Tuesday, Doctor.
Lordship, may I be permitted to mention one matter, my lord?
And all parties have been served, my lord. Even the advocates have been served.
Tuesday, urgent motion.
Lordship, may I be permitted to mention one matter, my lord? My lord, this matter is a National Highway Act. My lord, the petitioners are deprived of the basic remuneration, the basic compensation from the government for the past 13 years now. By an order dated 27/9/2012, the government acquired my land. They took the land, but for the past 13 years, they have not provided me any compensation whatsoever. We have been communicating through letters, notices to the concerned party, but they have the petitioners have been deprived of any sort of means from the acquired land that the government has taken, and that was our sole source of income, lordship. And the government has not been providing us with anything, and the item is running as item number 268 in today's cause list.
What is the urgency?
The urgency, my lordship, the petitioners are deprived.
2012, now 2025, 13 years you have waited.
Yes, lordship,
that
the urgency is that we have been trying to communicate through various modes, but then the government is not adhering to any sorts of communication, neither responding to us or paying any sort of compensation whatsoever. And that was a sole source of income for the past so many years.
Whether affidavits completed?
Yes, everything is done, my lordship, and the service is also made, and the advocates of the opposite party has also received it.
Wednesday adjourn motion.
My lord, may I be permitted to?
Wednesday adjourn motion.
My lord, may I be permitted to mention a matter for upgradation? My lord, this writ petition has been filed challenging an order of reappointment of a public prosecutor who was previously removed on the ground of misconduct in my trial. My lord, the matter is fixed on 6th of December.
What you have prayed for?
My lord, what happened? The public prosecutor, he conducted trial without receiving any CD. So we made a complaint before the ALR.
Trial without any order.
My lord,
conducting prosecution case without any order.
My lord, no. I'm the de facto. I'm the de facto. What happened? A public prosecutor was appointed.
Correct.
That public prosecutor was he was conducting the trial.
Correct.
Without receiving the CD. Certain allegations were raised against him. My lord, the complaint was made before the LR. LR changed the public prosecutor. A special public prosecutor was appointed. He conducted the prosecution for a few years. But in the meantime, what happened in recent time, that public prosecutor who was removed on the ground of misconduct, he has again been appointed, and he is commencing the trial. My lord, the matter is fixed on 6th. My lord, kindly fix any date prior to that. I'll be prejudiced if he conduct the prosecution.
Wednesday.
My lord, if your lordship's mentioning one item 327, this is simple matter. My lord, I took some loan from the Tata Capitals. I am ready to clear the dues, but in the meantime, they have taken possession of my four-wheelers, but that is my lorry. When they filed an arbitration case in New Delhi, the court said, arbitration said that you approach the High Court, if you're ready to pay, they will release the vehicle. 327. Kindly writ appear on any day, my lord.
So what is the now what you prayed before this court?
My lord, my prayer is that they have forcibly taken possession of my.
So what has happened to the arbitration?
Arbitration said that if you are ready to pay, you pay in the Calcutta, and they would consider, the honorable court would consider. So we are ready to pay the clear the due.
Why the writ court?
Writ court because, my lord, here the authorities, my lord, the Tata Capital and their associates have forcibly taken possession of my. It is in their custody. I am suffering loss for last 2 months.
So have you informed that you are ready to pay the total loan amount?
We have offered, but they have not accepted. Well, they are asking that if the court directs, we shall accept. 327 on any day, my lord. 327 age.
4 तारीख को रखो
4 तारीख
4 तारीख अर्जेंट मोशन
बड़ो करे दो अच्छा ठीक है आई एम ग्रेटफुल माय लॉर्ड
For non-prosecution.
Inclusion.
Declared as
Inclusion.
the construction has been declared as void by this honorable court, my lord. But without plan, the construction has been built, my lord. The honorable court has directed that, and my lord, the matter is referred to the SDO, and my lord, the SDO is currently in session of the matter. Now, my lord, very well knows, my lord, in consonance with the medical rules, my lord, the CMO is ought not have granted permission when you do not have, when the building does not have any sanction. Now, my lord, we have made a representation to the CMO is, my lord, the CMO is not acted on our representation, my lord, the hospital building is running, my lord. So, my lord, any day without any sanction, the hospital building and any day the building may fall. That is the urgency, my lord. So, my lord, I want just CMO to consider my representation. That is the urgency.
4 तारीख
my lord
अर्जेंट मोशन
Your lordship.
अर्जेंट मोशन 4 December.
To mention this matter, which was supposed to be, as per my lord's direction, it was supposed to be listed today. The matter is not listed. I am suffering because this is related to a passport, renewal of passport. My client is a merchant navy officer who needs his passport for selling. Now, because of the representation made by the wife, estranged wife, and writ petition filed herein, the passport has been withheld. Renewal is necessary, my lord. Kindly consider.
5 तारीख को अर्जेंट मोशन.
Your lordship, if I may mention item 24 of your lordship list. Your lordship had heard me before on this matter. Lordship pertains to the adoption of my child by CWC. Lordship, since there is no stay, lordship, the adoption proceedings are going on. My only request.
Today I will take 24.
Subject your lordship.
My lord, may I be permitted to mention a matter? Your lordship's direction was for the matter to be listed on the 6th of November. However, my lord, it's still running as item number 139. There's some urgency because my license has been cancelled wrongfully by the excise authority. So I'm not being able to carry on my business.
What license?
My lord, the license to deal in dry fruits and poppy straw. However, my lord, I had a valid license, and despite that, now there's a criminal proceeding initiated against me.
EC Act.
My lord. So, my lord, that is the urgency because my license has been wrongfully cancelled without giving me any notice.
3 तारीख को अर्जेंट मोशन.
May I have your lordship?
Kobe?
3rd December.
my lord
May I have your lordship?
I'm grateful, lordship.
अर्जेंट मोशन.
May I have your lordship?
I'm grateful.
My lord, in this matter, my lord, the marriage registrar has solemnized the marriage, my lord, and has granted a certificate, my lord. Now, my lord, when that, I do not know, my lord, I am the husband. My lord, I do not know that the marriage has been solemnized. My lord, when that,
You are the husband, you are not having knowledge with regard to the marriage. And you are claiming himself as a husband.
my lord, I am not claiming myself as a husband. That is the whole point, my lord. I do not know that that marriage registrar has issued a certificate and has recognized a lady to be my wife. I do not know, my lord. Now the lady has initiated a false, has started a false 125 proceedings and is giving that certificate on trial, my lord. Now, my lord, the address, my address, the witness's address, everyone's address is false, my lord. And my lord, I have on that day, my lord, I am an advocate.
So what the writ court will do?
To cancel that certificate, my lord.
How the writ court? You go and challenge the certificate in the maintenance proceeding and prove your case. It is a false document.
No, my lord, maintenance proceeding, how will the
Why?
maintenance court is only
That's why the maintenance court will consider whether the certificate is genuine or not. If it is not genuine, automatically court will have that it is not genuine.
the marriage certificate was issued from Calcutta.
Sorry. Yes.
Yes, may I mention, my lord, item number 83, my lord. I had mentioned this earlier, my lord. Your lordship had indicated that your lordship will take it up and fix a date for hearing of the matter, because I'm led by, my lord, for someone from Delhi, Dr. Justice Murli, the retired. So, my lord, I'm praying, my lord, if this matter could come up
Item
under
number?
83, my lord. If it could come under to be mentioned, subject to your lordship's convenience, we'll just take a minute, my lord. In the presence of the other side, we can fix a date for hearing.
Tomorrow other side will be available or
I've
Monday.
already given them notice. I'll again give them notice.
Tomorrow to be mentioned only for fixing date.
My lord, similar prayer, my lord, item number 270, my lord. It's an urgent matter because, my lord, my wife is, my lord, very much, my lord, cancer patient, my lord. I need money, my lord. My amount is pending, my lord, for the government.
Pay the money.
Government, my lord, state of West Bengal, my lord. That is pending for last 4 years, a huge amount, my lord. And also bank loan, my lord. Kindly take it up any date, my lord. 270.
Which matter?
Item number 270, to this list.
270.
Yes, my lord.
Fourth का adjourn motion में कर 270 20.
This is the new 70.
Fourth that's adjourn motion. New motion, urgent motion.
I'm making one minute.
Deeply obliged.
Huh?
Motion. New motion.
Your Lord.
This is the
Your Lordship.
This is the new
Petitioner obtained a home loan minor 2021. Already paid 4 lakhs, already paid out of 7 lakhs. We made an application for settlement. But the petitioner did not close to.
So if they are not coming to the settlement, what the writ court will do?
Settlement, there were direction, kindly bank.
Yes, call the list.
Your Lordship, on the ground of maintainability, it is urgency that you should hear it first, my lord, at least once.
Yes.
Continuation of the inspection is complete. Okay. So previously it was appearing to Honorable Justice Motion. It was to appear on 12th of November, but due to change of determinations, kindly listed under head of motion.
Lordship, to mention the matter, Lordship, for the urgent motion, Lordship, the matter is pending before the ombudsman for the last 6 months. There is a certain change in the interest rate of loan. Lordship, I am lodge a complaint before the RBI ombudsman, and for the last 6
What is your prayer?
Lordship, kindly it is making including an urgent motion. It is item number 265. 265.
Your Lordship,
Urgent motion.
Your Lordship, please, on the ground of maintainability.
No further mentioning. Call the matter.
Tender matter, my lord.
Call the matter.
Extreme urgency involvement. It's a tender matter, my lord.
Yes, call the matter.
Grateful. For the state. Appearing on the student.
The petition is dismissed.
Obliged.
Yes, next.
I'm for the petitioner, Your Lordship.
The respondent number 2 and 3 are directed to provide electricity connection to the petition within 4 weeks on compliance of all formalities. Yes.
Number 3.
3 to 12.
3?
4.
Extension of interim order, and if your lordship invite more trouble, fix it for hearing.
None appears. None appears on behalf of either of the parties.
Fine.
You are not appearing.
I am appearing.
Absurd.
Then I must send the honorable judge for the eye specialist.
Yes.
I am for the state respondent.
Affidavit completed? No.
No, they have not filed.
Twice extension granted. I think there is nothing.
Twice
in
not
affidavit.
there. So many times it was extended, Lordship. I am not opposing the extension, but kindly fixing up the date for hearing.
For hearing.
Order.
Without, I
Order
thought you
12
will not use affidavit.
Order 12.6 apply, allow the petition.
You will not file affidavit. Can I record and I will extend and I fix the date specific hearing? Tell me, it is your option.
Or within a week, I filed the.
Sure.
Yes.
For the last 4 months, 6 months, you have not filed.
Yes. As per the instruction is
22,
concerned.
Not 6 months.
It's a 22.
22
Yes.
matter. Landed senior is saying too many times it was extended. So many times it was extended, Lordship.
Counsel for the petition prays for extension on the interim order. Counsel for the state prays for a week time to file. Prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed by 9th of December 2025. Reply, if any, there to be filed by 16th of December 2025. This is the matter on 18th of December 2025. Interim order is extended till 23rd of December 2025. Or until further order.
These are sweet appearance. Once given labor, getting the fruit.
Yes,
No,
next.
it was not within my domain. I heard because so I have learned from him. Next matter is his for same reason. He is sitting here.
But I am for the respondent. Lord, an arbitration proceeding before the learned MSME, Lord, has been put to stall by an order of stay passed by this honorable court. Affidavits are exchanged in this matter, Lord. State has also filed a report. I'm not opposing to the extension, but I only beseech your lordship because an arbitration proceeding is in question, Lord. Date may be fixed for us.
What do you want?
But I want let extension be there. I am for the private respondent pursuing the arbitration.
The hearing?
Yes, Lord, I am requesting
Date
for
is to be fixed for hearing.
No problem. We have some idea, Millard, of months to wait. If it can, Millard, be a shorter date, that is my only request. It is only, Millard, we have faced it for 2 years, Millard.
Advocates are knows when the date will be fixed.
But since it is arbitration, that's why my only request to your lordship.
So I am extending and I am fixing a date. As per what is the convenient date of yours?
So any day it's not in the month of January. In December, I will be busy. In the month of January.
Counsel for the petition prays for extension on the interim order. Counsel for the respondents prays for fixing the date for hearing. Due to the interim order, the proceeding of arbitration proceeding has been installed. In view of the submission made by the counsel for the parties, let the matter appear on 7th January?
7th January.
7th January at 2 p.m.
My junior has some difficulty and then after second week of January.
Then 13th January? 13th January at 2 p.m.
Extension till?
Interim order is extended till 16th of January 2026.
Well, interim order will be extended until further orders. When every time you have to come and get extension, that is irritating for both of us.
Lord, I really thoroughly enjoy appearing before your lordship of this time, Lord.
16th of January 2026 or until further order, whichever is said. Yeah. Let come on, the hearing will be taken then automatically.
No problem. It is taken up, now the difficulty.
I'm deeply up.
Hearing. At 2 p.m. Huh? Yes, next.
Well, I appear for the petitioner for extension of interim order. The interim order was mainly rested on the order of the division bench, where the issue is being tried whether a ST certificate can be cancelled by the SDO or by the State Vigilance Commission in view of the judgment of the Supreme Court in Madhuvi Patil's case. But that matter is pending, issue is pending before the appeal court, but they have not used any opposition to this as yet. Well, I will be requesting my learned friends to use an opposition to my factual aspect of the matter and legal matter that should be decided by the division bench, as not in me.
Lordship, we are me with Shomik the junior, Lade junior, appearing for the state lordship in this matter. The matter, lordship, disposes because extension of interim order expired on 7th November.
No.
Lordship.
No,
Thereafter,
which order? 28 November.
after extension, lordship, I am pleading. Extension of interim order, they are asking, but lordship, everything is over because affidavit exchange is over. We have filed the report, lordship.
Giving a wrong,
filed the report, lordship. In the last occasion, lordship. Reply also they have handed over, lordship.
They have filed a report.
Lordship.
So you
report in the form of affidavit, Lordship.
So you will rely this report only.
Lordship.
No further affidavit you will file as per your submission. Correct.
Lordship, it was over. That is every point we have discussed in
Correct.
the
That I'm
report.
telling, you
Lordship.
file the report
Lordship.
by way of an affidavit.
Lordship.
It will be treated as an affidavit.
Lordship.
And they already filed, so it is to be fixed for hearing.
Lordship. Lordship.
Well, it is before the Honorable Division Bench. The order of 13th of April, if your Lordship pays a look to 13th of April. Order passed by this Honorable Court.
13th April.
13th April 2023. The initial order passed on the motion stage.
13th April order. It's court.
So 2023. First order.
It's court. প্রথমের দিকে থাকে।
দাঁড়া না, চুপ কর না। কথা বলছি।
বলবো তো।
No,
আমি
13 April, 19 December 2024.
That
19 December 2024.
and that was the order, my lord, of the 13th April passed by the division bench where this issue is
Division
pending.
bench.
আমি বলি, Lordship.
So when the matter is fixed before the division bench?
The division bench, my lord, matter is not with me, my lord. That is another set of advocates are appearing. So, my lord, I do not know, my lord, but this issue is pending.
Lordship disposes the matter. Lordship, they are suppressing the material facts.
If the similar issue is pending before the division bench, how this matter can be taken up by this court?
Lordship,
My lord, if I may, my lord. My lord, he is claiming to be a scheduled caste tribe, my lord. My lord, in fact, if it's on fact, my lord, he is not a scheduled tribe, my lord. The issue over there is whether SDO can cancel or not. But the entire case of this is based on suppression of facts.
In the report, we have
In
detailed.
this case, your case is that he is not a scheduled tribe.
No, my lord.
No.
That is why it's
1990
But who has cancelled?
by SDO has no
That's
jurisdiction.
different thing. If it is not, if at all, if it is not, he is not a ST, whether the SDO have a right to cancel
Yes.
or the concerned authority, that is to be decided.
You should also come with clean hands, subject to your lordship.
That is different thing. But the one issue is pending before the honorable division bench, how this court can be taken up for hearing. Okay, I am extending and I am fixing a month in the month of January.
In the meantime, the petitioner will retire, Lordship. She is in service.
No, we
In the meantime, for that, they are urging most, Lordship.
Or I am sending this matter to the division bench. Let this matter be heard by the division bench.
And along with that matter.
Along with this appeal.
That's we agree, Lordship.
But interim order is limited, my lordship. That will
That's we
continue.
agree.
I am extending.
Yes.
Until further orders.
Yes.
Later your
Or your lordship, keep it
That's
after
we
3
agree.
weeks after vacation. Let me see what happens in the division bench.
The petition placed for extension of interim order. The respondent says that they have already filed the report by way of affidavit. The petition also filed a reply. Accordingly, she prayed for fixing the matter for hearing. Learned counsel for the petition submit that the similar issue is pending before the honorable division bench, and as such, the matter is to be adjourned. In view of the submission made by the counsel for the respective parties, the interim order is extended till 22nd of December 2025 or until further order, whichever is earlier. Let the matter December.
Lordship, keep it January.
Let the matter appear on 18th of December 2020
Lordship, deeply obliged.
and not 18th. 17th of December 2025 under the heading adjourn motion.
Much obliged, Lordship.
Yes, next.
Order this petition. Order. May I take back the order?
Yes, take. Next.
Appearing at mine. Appearing at mine.
I am for the respondent, my lord.
Extension of
For
extension of interim order.
Before hearing, my lord, it is almost ready, my lord. Everybody with opposition and reply, my lord.
Not almost, it is
Your
ready.
lordship, you kindly fix the date. Any date, my lord, January, my lord. We are ready to argue this matter, my lord.
Counsel for the petition placed for extension of
Yeah,
interim
January
order. Counsel for the respondent submit that readings have been completed
Handout থাকবে।
and to bring for fixing the matter for hearing. In view of the submission made by the counsel for the parties, interim order is, let the matter appear on 7th of January 2025 at 2 p.m. under the heading is specific matter. Specific matter. Interim order is extended till 9th of January 2026 or until further order, whichever is.
2026.
Instead of 7, my lord, you can take it up 9th, my lord, Friday, my lord.
Friday, no. Friday is the criminal matter. I will take, that's why.
8th, my lord.
Why 7th is problem?
7 some problem.
Then 12th.
12, my lord.
12th, correct. Then 12th at
12 is a holiday, my lord.
January.
Yes, Swami Vivekananda Janmadin.
13th is already fixed. No, one matter.
14, no problem. পেছনে কিছু বলবেই না, কিছু বলবেই তুমি আমাকে না। এরা নয় তুমি
13th January. Our entry model is 16 January.
Very good.
13 January.
13 January.
13. Great. Simply apply. But 13 January, another matter is there.
No, that has been shifted to 16. Na?
16. Deeply apply.
Item number 9.
Well, the jaggery or molish.
What has happened?
Original টা এটা original
আমার পিটিশনটা কোথায়?
Well, I am for the petitioner in this matter.
यार ना 8 क्या हुआ?
Under molasses control order, my lord, that was considered by Lordship on the other day. We, according to us, my lord, it does, that control order does not apply to us.
And according to me, my lord, the criminal court has already taken cognizance of it. It should go before the
But the jurisdictional question can be taken by your lordship, my lord, whether it comes with the jurisdiction of the authority to interfere or intercept in the issue.
Yes, where is the report?
That the side, the other side.
এটাতে কপি দে।
Just some of the relevant pages I show. The incident had taken place on 15th September. I'll take 2 minutes.
Well, I would be requesting, my lord, let me come on next week because let me look into it. Man, he has just given it to me.
There is no urgency.
No, urgency. I cannot read it today. You are not expecting me to go into it today.
State has filed
Well,
report.
এটা
After
দেখে না
serving the copy to the London
রিপোর্টটা দিচ্ছে এরা আর উল্টোপাল্টা আর্গুমেন্ট করলে হবে না
with the record. Counsel for the petitioner praying for.
Keep it on Monday, my lord.
In the next week, let the matter appear on 2nd December.
2nd December, my lord, liberty to take the exception if required.
2nd December under the heading adjourn motion.
But it's a general report. I have not filed any by way of an
petition is liberty to take exception to that.
But if exception,
only with regard to the
no exception, my lord, let a copy be given me.
Yes, naturally.
তুই যেমন অ্যাডভান্স দিলি আজকে আমাকে
মামলার
Next.
চলো গ্রেটফুল টু লর্ড
Item number 10.
लोग को था इसको भेज दो चैम्बर में।
My lord, first is service.
Yes.
My lord, first, government of West Bengal is a party.
No, government of
Yes.
Government of Microsoft.
That is government of West Bengal, Directorate of Micro, Small and Industry. Then, my lord,
Have you, sir?
yes, my lord, chairman of the MSME, and of course the private respondent who had invoked the provisions of the MSME Act and initiated facilitation proceeding before the council. So these three are parties. I don't see anybody. Now, my lord, the urgency why we mention the matter, if your lordship will kindly straight away come to below the impugned action of the council at page 617, which would be
Your service
the
mail
by mail.
নোটিশ দিয়েছি 4 বা 3 বার মেনশন করতে আপন নোটিশ
And all, I am told, my lord, the mentionings were also done upon notice.
Okay. Yes, what you are paid for?
I'll tell you, my lord, if your lordship first kindly come to page 617, which is volume 5.
617.
My lord, 617, volume 5.
Yes.
Here your lordship will find
it is a notice referred to both parties. L&T Engineering Company is the buyer. I stand corrected, was the supplier and we were the buyer. We are the port authorities. Termination of conciliation process as per section 18(2) of the MSME Act. Initiation of arbitration proceeding as per 18(3) of the MSME Act. The conciliation process as in the referred matter duly held by West Bengal Micro Small Enterprises Facilitation Council has been terminated without any settlement between the parties. Now the council is hereby initiating the arbitration process. It is also stated that as per 18(4), then it continues. Now, my lord, what we are aggrieved of, as my lord, if your lordship kindly come to page 200, the previous page, 616.
This is
My lord-
interim order.
My
You
lord.
challenge this.
Yes, yes. My lord, why I am challenging this, my lord, I'll just take 2 minutes of your lordship's time. My lord, we had issued tender. My lord, tender for works contract. The nature of the works contract is not in dispute. Now, my lord, the person who was the contractor could not perform it properly. Now, I have a claim against him to the extent of almost 8 crores. Now, he says that he has a claim against me. Very well. There is a separate arbitration agreement in the contract between the parties. Now, he issues notice and invokes the provision of the MSME Act. So, when I appear before the MSME Council, I say, I take a initial preliminary objection regarding jurisdiction. We say that, my lord, the MSME Council has jurisdiction only to entertain claims of a supplier arising out of supply of goods or supply of services. Works contract does not come within the purview of the MSME Council. So we gave a few judgments. But what the MSME Council did, MSME Council referred to a division bench order of this honorable court and said that in view of the division bench order, we will proceed. So and naturally there was no settlement, we had either party had claim. So they said that there is no settlement, referred it to arbitration. Now the question is, now this is the only issue here. Well, now before I take your lordship to the division bench order, which is the part here, well, kindly have a look at the previous page 616. I showed your lordship 617. Well, kindly take a look at page 617. 616. But this is the Port Authority's advocate writing to the council.
After conciliation here.
Yes. So, my lord, the objection that I raise, and I say that the matter is now pending before the Supreme Court. Supreme Court, there's an order of stay. Nothing is considered.
Which order is stayed?
I'll tell you, lordship. Now, my lord, if your lordship will see, now, my lord, there is no minutes.
Yes.
There is no reason in my lord, page 617.
Yes.
So, my lord, I have to tell you, lordship, my lord, what happened, what transpired there. My lord,
Ashok Kumar Jina is the arbitrator?
no, is the advocate of the port authorities.
Okay.
I have
এটা ভালো বলেছে কিন্তু Now, my lord, kindly see where it starts. Now, my lord, if your lordship will kindly take first the order of the division bench, which they rely upon to say that they have jurisdiction to proceed. My lord, kindly come to the division bench order at page 564. This should be in volume 4.
Yes.
Paragraph 2. The facts in a nutshell are that the appellant writ petitioner, NBCC, a Government of India enterprise during a time such and such had issued 4 work orders of different values, awarding to respondent number 4 such and such for undertaking the same. Then, my lord, next paragraph, on Atho, the respondent number 4 registered itself as a small enterprises with MSME. Among the 5 work orders undertaken by the respondent number 4, 2 have been terminated for breach by the respondent number 4, and the work order has been taken up by new agencies at the risk and cost of the respondent number 4. However, 2 projects are still continuing and 1 has completed. Further, some disputes and discords have arisen between the appellant and the respondent number 4 in connection with the aforesaid 5 contracts, out of which MSTC Limited project work has already culminated into a commercial suit before the Commercial Court at Rajarhat. Respondent number 4, in connection with the aforementioned 5 projects, had lodged a claim before the respondent number 2 hearing. The chairman of the Micro and Small Enterprises Facilitation Council under the MSME Act, to which the appellant objected on the ground of maintainability, and also made representation for recalling of the order of reference on jurisdictional grounds. However, on the receipt of the claim, the authorities took cognizance, and on failure of the conciliation sought to initiate statutory arbitration.
Yes.
Identical, similar situation.
Yes.
Then, my lord, 22nd September 2021, respondent number 2, which is the council, issued a notice fixing the first date of arbitration under the MSME Act, referring disputes such and such under 5 several contracts to such and such. My lord, this is the quoted portion of what the council said. Then, my lord, however, para 5, the appellant again objected on some elementary issues, stating that the respondents cannot proceed under the MSME Act. And further, on the date of awarding the 4 contracts, the respondent was not registered. My lord, this is the other point which was taken. Then, my lord, the writ petition prayers are set out at paragraph 6. Then, my lord, kindly come to para 7.
Yes.
After hearing all the parties, the learned single judge passed an order on 16th December 2021. Thus been agreed by the order of the single judge, modified by such and such the instant appeal. The appellant raises a preliminary objection regarding the jurisdiction of the Facilitation Council and the maintainability of the entire proceeding under the MSME Act from the very inception. The appellant has categorically taken his preliminary objection that no proceeding is maintainable before the Facilitation Council constituted under the MSME Act, so far as the works contract between the parties is concerned. Lordship kindly makes a note, my lord, works contract between the parties are concerned. It was contended that MSME Act has no manner of application apropos works contract, since neither section 11 nor the Public Procurement Policy 2012 envisages a composite and distinct category of contract such as works contract. Then, my lord, Kone Elevator has been referred, which is the absolute law so far as works contract in India. It was held in Kone Elevators that works contract is an individual contract, but by legal fiction is divided into 2 parts, one for sale of goods and the other for supply of labor and services. As held by the principle of such and such, the Supreme Court upheld the Gujarat High Court judgment on the interpretation of Section 18 of the Act. The High Court held that since the Act is a special legislation and has an overriding effect, the parties governed by it are bound to follow the mechanism provided under Section 18 of the Act. It was further reiterated in Macintosh Burn, reported in 2020. Then the learned single judge observed that previous one, that Manni Bhai brothers and, my lord, the Kone Elevators is only what is a works contract. And the next one, that Section 18, well, there are 2 issues here. I had also raised that issue, but right now I am on the works contract. That if there is an independent arbitration agreement, you have to take recourse to that agreement and not the arbitration contemplated under the MSME Act. But, my lord, with respect, my lord, I candidly submit, my lord, this has been settled by the Supreme Court. Supreme Court says that MSME Act will override. So the arbitration has to happen under this Act. But works contract issue is the issue now. So I cannot agitate that point before your lordship, and it has been settled now. Now, my lord, kindly take paragraph 10. The learned single judge rightly observed that, my lord, within quotes, without prejudice to any of the rights and contentions of the writ petitioner, the petitioner shall participate in arbitration, and that the tribunal shall decide on its jurisdiction on inter alia the question raised by the writ petitioner before entering into other questions. So, my lord, a authority which does not have jurisdiction is being conferred by the High Court in exercise of powers under Article 226. Because I say inherent lack, works contract outside the purview, then, my lord, we are not interfering with the order of the single judge, and the appeal is dismissed, all other applications. So, my lord, Supreme Court, this is carried to the Supreme Court by NBCC. Now, my lord, kindly come to page 571, immediately the next page.
This is an appeal.
Your lordship will see NBCC was the appellant before the Supreme Court. So, well, the order that I just read out for your lordship was the judgment and order of the division bench of 18th May 2022. That your lordship will find was under challenge before the Supreme Court. Right on top, your lordship will see arising out of the impugned final judgment.
18 May, yes.
Yes, in APO 11 of 2022. Then, my lord, kindly take the judgment. Mr. Such and such accepts notice on behalf of respondent number 4. Hence, issue a formal notice of the respondent dispensed. He also seeks time to file vakalatnama, such and such. Rejoined the event. Then, in the meanwhile, the proceedings, said to be pending before the Facilitation Council shall not be precipitated any further. So, you cannot proceed with the arbitration till this is decided. Then, my lord, kindly take the next page, page 572, 13th October 2023. This interim order is continued until further orders. Now, my lord, then, my lord, at page 573, what happens is this civil appeal is referred to the larger bench. Conflict of two judgments on not on this point, interestingly on the other point, because both points are involved here. So the point that whether the Arbitration Conciliation Act 96 will prevail, or if there is separate arbitration agreement between the parties in the contract,
whether the facilitation will continue
or facilitation will cancel. That is the issue. There is conflict judgment between Shilpi Enterprise, Mahakali Enterprise, between 2-3 high courts. There are two conflicting judgments which is referred in this judgment. So Supreme Court says that best decided by a larger bench. So this has been referred. So this is the situation. So we bring all this to the notice of the Facilitation Council, which your lordship will find at page 516. Notes of argument file, all judgments given, and we've given the other judgments also of the other courts, which specifically has held that works contract is outside the purview of the Facilitation Council. So, but they proceeded on the basis of the division bench.
Page 563.
No, 516.
516.
They've recorded our submission. Recorded.
516, my lord, just before the impugned
Order. Yes, got it.
No. Here your lordship will see, we say, with utmost respect, we submit that on conciliation hearing before you.
516.
Yes, my lord. 616. I stand corrected.
Yes, 616 that you have pointed.
Correct. So we specifically said that we submit on conciliation hearing before you, we on behalf of such and such challenge the maintainability of the proceeding subject matter dispute relates to works contract, which is beyond jurisdiction such and such, and written objection. We saw dismissal of it is submitted on behalf of the council intelligence that one matter of the Honorable Division Bench of the High Court passed in NBCC matter, and accordingly council took a decision that council is accepting all matters relating to works contract. In view of thereby humbly request you to supply me with the copy of the minute or the order dated 25th June 2025 in the aforesaid conciliation proceeding and the decision of the council in continuing with the matter concerning works contract. Till date not given to me.
Instead of this 6.
Instead, what happens? This 14th August is served upon me. So after the hearing, when we raise the objection, take the maintainability point, file my objection, file my notes of argument, I take the point and I show the Supreme Court judgment and the other judgments. They sit over it, they don't give me their own minutes, no order, nothing. So that will be evident from my 26 June letter, which was duly received. My lord, kindly see the received stamp at the bottom of the letter at page 616.
26 June letter?
My lord?
26 June letter, which page?
616,
No,
which I just read out.
616 is their letter, 26
No,
June.
it is my letter, my advocate's letter.
26 June.
Yes,
You are
2025, Ashok Jena.
Yes, yes.
So
Okay.
he is my advocate. Kindly see, my lord. কোথায় লিখেছেন my client এর নাম আপনি who's on whose behalf you are writing কি করে বুঝবে লোক Madam Lordship will kindly see the stamp.
Yes, got it.
30th June. So when I say you don't give me a minute, you have not decided the point.
Yes.
So I can understand that you are saying that I have jurisdiction, I can proceed. So facilitation fails, you are going to conduct the arbitration under section 18. You have the authority. Now you decide my point and do it. I am showing you the Supreme Court where Supreme Court has stayed the arbitration. So that till the point is decided. So, my lord, this division bench which they are referring, that is under appeal before the Supreme Court. So, my lord, our limited prayer at this stage is that, my lord, the arbitration, that same order that Supreme Court said, no further steps should be taken in the arbitration proceeding under section 18. And their proceeding, statement of claim has been filed by the buyer. My lord, if your lordship will kindly take, my lord, the prayers of my writ petition, it starts at page 26.
Yes.
E. Let Supreme Court decide. I am not saying if Supreme Court decides the issue that yes, it can, it can. So, my lord, in any event, my lord, the dispute has to be adjudicated, whether in a separate arbitration proceeding or by the facilitation council. So, but when the jurisdiction is under challenge that you cannot even receive complaints relating to works contract, how are you proceeding?
Yes.
Well, this is my limited prayer at this stage.
The
affidavit
service filed by the petitioner. In spite of service of notice and absence from the above. The petitioner has addressed of interim order. Petitioner floated several tenders, plus e-tenders of the work contracts. The respondent number 1 issued a notice to the petitioner as well as the respondent number 3.
Facilitation
cancellation. The respondent number 3 filed an application with claim before the Micro and Small Enterprises Facilitation Council, West Bengal under section 18 Act 2006. In terms of the direction dated 9th November 2022 by the conciliator, the learned advocate for the petitioner submitted a written objection on behalf of the petitioner.
না না এটা 523 and যখন facilitation
On 24th June
apply করলো
2025,
first
a notice
notice
a notice is received by the petitioner from the facilitation council to appear in the virtual hearing in respect of the facilitation proceedings on June 25, 2025. In the virtual hearing, the petitioner was represented by the advocate. and raise the issue of maintainability on the fact that the cancellation proceeding under the MSME Act cannot be taken out with respect of the works content. Full stop. On 25th of June 2025, the Learned Counsel for the petitioner also informed the West Bengal Micro and Small Enterprises Federation Council that the Kolkata protest challenge the maintainability of the proceeding as the subject matter relates to the work contract, which is beyond the jurisdiction of the council existing conciliation authority under the MSME Act. And he has relied upon the judgments passed by the Honorable Supreme Court and requested for dismissal of the proceeding as the facilitation council is not having the inherent jurisdiction to continue the facilitation council in respect of the works order. In spite of the request made by the petitioner, the West Bengal Micro and Small Enterprises Facilitation Council issued a notice on 14th of August 2025 informing that as per section 23 of the Arbitration and Conciliation Act and as per 12 of the WBMSEF 2016, the supplier unit is requested to submit the statement of claim before the council within 15 days from the receipt of the letter and requested the buyer to submit the statement of defense before the council within 15 days after receiving the statement of fact from the supplier unit. And the counsel for the petitioner submits that the authority have continuing the arbitration proceeding on the basis of the order passed by the division bench of this court in the case of NBCC within bracket India Limited versus the state of West Bengal and others dated 18th May 2022. 18 May 2022. Learned counsel appearing for the petitioner had drawn the attention of this court to the order. The Learned counsel for the petitioner submit that the order passed by the Honorable Division Bench of this court is challenged in the SLP being special due to appeal within bracket civil number 15098 of 2022 and by an order dated 25th of August 2023, the Honorable Supreme Court has stayed the order, stayed the proceeding before the facilitation council. And subsequently, by order dated 13th October 2023, the interim order was extended. The matter was taken up by the Honorable Division Bench of the Supreme Court and by an order dated, by a judgment dated 10th of January 2025, the Honorable Supreme Court had referred the matter to the 3 judges bench and the matter is still pending. And the counsel appearing for the petition submit that all the facts have been brought to the notice of the respondents, but in spite of having the knowledge that the matter that the order passed by the division bench of the court on the basis of which the arbitration proceeding has been initiated has been stayed by the Honorable Supreme Court, and now the Supreme Court has referred the matter to the three judges bench. Thus, the authority cannot act on the basis of the order passed by the Honorable Division Bench in the case of NBCC India Limited Super. He submitted that without considering the legal position, the respondent authorities have passed the impugn order dated 14th August 2025. Had the learned counsel for the respective petitioner perused the impugn order and the judgment passed by the Honorable Division Bench of this court as well as the Honorable Supreme Court. This court find that the petitioner has raised the issue that the work order cannot be a subject matter of the facilitation council. And the order passed by the Honorable Division Bench of this court has been stayed by the on the basis of the order passed by the Division Bench of this court, the proceeding on the facilitation council has been stayed. And now the matter is pending before the has been referred to the Honorable Three Judges Bench. In view of the above, this court finds that the petitioner has made out a prima facie case and balanced the convenience and inconvenience in favor of the petitioner. This court also finds that the matter is pending before the Three Judges Bench, and the Honorable Division Bench of the Supreme Court referred the matter to the Three Judges Bench, and the same is pending for adjudication. Thus, this court is of the view the order dated 14th August 2025 is required to be stayed till 16th of December 2025 or until further order, whichever is earlier. Let the matter appear on 16th of December 2020. So the 16th January interim order. No, December, sorry. 16 December. 16 December. 16. 16.
Kindly give it 2 extra days of interim order, in case again we have to bother you not to mention.
Let the matter appear on 16. Interim order is till 19 December. Till 19.
Similar matter, I mentioned several of them.
You have tested?
No, I have mentioned both the matter. Although last year you mentioned it will attack in this matter. But this is in respect of Haryana. Haryana resolution.
Monday Rakha. Monday Rakha. Yes, call the next matter.
Lordship, I appear on behalf of the Union of India, Your Lordship. I am seeking some time to seek instructions, Your Lordship. On the face of it, Your Lordship, they had an alternative remedy, Your Lordship, to approach the state forum. This is a writ against an order of the consumer forum, Your Lordship, the district consumer forum. Now, as per the statutory appeal provision, Your Lordship, they had to deposit a 50% pre-deposit.
No,
Mandatory pre
against the order of the state forum.
The district forum.
District forum.
Yes, so they had a statutory appeal.
Why the state why are not?
Section 41 of pre-deposit, mandatory pre-deposit which is beyond the capacity of the petitioner, whereby increase the right of the petitioner to access.
File an application for leave.
No, my lord, there is no provisions of the
Statutory appeal provision is there. He has the right. He just wants to evade paying that amount.
Come back with the report, my lord.
What do you have prayed for before the district forum?
My lord, we were, my lord, the opposite party over there. We were opposite party over there, my lord. The private respondents, my lord, filed a consumer complaint, my lord. My lord, there is a purely commercial transactions, my lord, it is and resale, my lord.
Who are you?
My lord, I am the opposite party, my lord.
Who are you?
Here he is the writ petitioner in the.
You are the company?
No.
Yes.
We are the facilitator.
So
we are the facilitator.
Actually, so how it is maintainable?
It is not.
That's why your lordship, the Harbansal judgment is there.
Effective, efficacious alternative remedy is available, Your Lordship.
Well, there, despite the remedies there, well, there where the commissions pass an order judgment, well, beyond the jurisdiction, well, the writ petition is maintainable, well, even well, we also.
Yes, show me how it is maintainable. Show me.
Well, I'll satisfy with what happened.
Yes, so satisfy the today's fix. You mentioned that it is fixed as urgent.
This has come at my instance because I am suffering with the execution proceeding.
You are the private respondent.
Due to pendency of the writ petition.
What happened, Malad? It was running in the monthly list, Malad. My brief got misplaced, Malad. Somehow I managed in the morning, Malad, to prepare this brief, Malad. Malad, I don't even know, Malad, all respondents were served or not, Malad.
All respondents have been served. There are,
State respondents must be there, Malad. State respondents.
if 2 respondents have been served, then I'm guessing the
State respondents is not.
So virtually he has challenged.
His challenge is your challenge is district consumers forum order. So who is the petitioner before complainant before this could be is appearing? Your
I'm for the union. I'm for the union, for the department.
Let my brief, my brief got misplaced, Malad. Allow me some time, Malad. I'll satisfy.
Your Lordship,
I will come up with judgment, Malad. I'll satisfy.
may I make one submission? Now, he has challenged the vires of Section 41 of the Consumer Protection Act, which mandates a pre-deposit, Your Lordship, 50% pre-deposit for a statutory appeal. Now, Your Lordship, if, as per my instructions, Your Lordship, if a vires is being challenged of a particular section, you need to serve the Attorney General. They have not made the Attorney General a party, Your Lordship.
What? First, you satisfy this court first.
I'll satisfy you, Lord.
Yes. Only by challenging the virus you can admit the writ petition can be admitted. You satisfied?
I'm not, Malad. I'm not sick.
District forum passes an order against you and you file a writ petition challenging the provision of the act.
Malad, keep it, Malad, on any day, Malad, after a week, Malad.
What is the ground of the virus? Show me. What is the ground of the virus? 41. The court has passed an order. You have to deposit.
Malad, this is the mandatory deposit. The beneficial legislation, Malad, and the judgment was passed, Malad, in that fashion, Malad, the issue even not decided, Malad, the issue raised before the Malad, before the district commission, Malad. Malad, it was not decided whether the opposite party at all. Malad, the
Order starts at which page?
Have you adduced evidence? Have you adduced evidence before the trial, the district forum?
Evidence was logo.
On the basis of documented, what is the compensation awarded?
In excess of 12 lakhs, Your Lordship.
12 lakh 67,000. It appears at 118.
50%
Operative part of the order is 117 and 118 here.
commercial transaction, but I cannot satisfy the consumer.
That point is to be decided by the state forum, my lord.
So you can take the plea before.
Efficacious alternative remedies available.
What says Apex Court? You can file a writ petition challenging the order of the.
Despite there is an alternative remedy, in certain cases, the writ petition.
Correct. I also agree. I also agree. But here, what is your?
If the opposite party is not, when it comes under the purview of the Consumer Protection Act.
So you take that ground before the state forum.
Then, the jurisdiction of the consumer forum will always go, and such judgment without jurisdictions, they pass the judgment.
Okay, I will hear you. Subject to, if I find that your petition is misconceived, then further you what the award is being given, double amount is to be paid. Subject to, I will admit this. I will admit. I will fix a date for hearing on the jurisdiction, nor if affidavit is required, but subject if this court found this your application is misconceived, then what the award has been passed by the district forum, that will be doubled.
I have come up with a lot or challenge.
Go and challenge before the state forum. Again, I am telling. Please keep it in mind. I have opened my mind. If your petition will going to be dismissed, then the double amount is to be paid.
In order to withdraw.
So otherwise, all the state forum will be closed. All the order of the district forum will come to the High Court under 226.
Absolutely, I'm grateful.
No, I'm not seeking that.
Because the High Court is no work under 226. That's why we are calling from the tribunal's orders and the district forum's orders, all the forum's orders. Because the High Court is not having any work. No, it is pending.
We also challenge the virus of section 41 of the law.
I am admitting, but keep it in mind.
I have to
Tell me when it is to be fixed. I will fix it specifically by December. I will dispose of this matter. Tell me which date, as per your convenience, I will fix. But he will not satisfied and fine, then the double cost is to be imposed.
in order to withdraw this petition, even I have to take instructions. Otherwise, I can't find out.
I don't know.
Your Lordship can fix it tomorrow, Your Lordship.
I don't know. But you let's see.
Can you fix it tomorrow? I'll come back with the instructions.
As per the submission made by as per the prayer made by the counsel for the petition, let the matter appear tomorrow under the same heading. Next.
May it please your lordship, in this matter I am appearing for state, my lord.
Yes.
Lord, the issue remains. Lord, work order has been issued. Subsequently, I have raised the bill. Work completion certificate has been issued. Thereafter, Lord, the part payment was there, and ultimately P3, that is at page 20, Lord, the remaining balance payment has not been paid. So I have made the representation before the authority. That is at page 20. But if they connect identical issue, my lord has already passed this order, my lord, that is to be considered by the authority within a certain period.
Yes, my lord, we will consider the representation at page 20, my lord.
You all
which is-
persons and made the writ petition as a suit court, money suit.
So, my lord, within the period of limitation.
Period of limitation? When the last payment was made?
My lord, it was made, my lord, 2023. 2004, 24. 2024. It was made, my lord.
Where is the work order? All provisional work order.
My lord, work order, that is at page
19.
No, my lord,
page
17. 17.
That is a provisional work order.
Yes, my lord, 17 as well as 18.
Both are provisional work order.
My lord.
Then,
and ultimately, my lord, the final bill, that is at page 19, and it has been serial number 1 and 3. And ultimately, my lord, it has been paid. My lord, that is at page 20. My lord, the communication, it says the 5,89,000 has been received on 19th and 20th March 2024.
5 lakhs?
5,89,000 has been received. That is, my lord, get from the second paragraph, that is, my lord, address, my lord, communication.
Out of 34 lakhs?
Yes, my lord.
No, 28
no,
is pending.
Out of 34 lakhs, yes. Due and payable is 28 lakhs 84,190.
Petition submits that the executive engineer PWD Birbhum Electrical Division, Suri, had issued provisional work order to the petitioner on 18th March 2021. As per the work order, issued by the authorities, the petitioner has completed the work and raised the bill for a total amount of 34,73,190. Out of the total amount, the respondents have only have paid the part amount of rupees 5,89,000, and the rest amount is due. The petitioner has made representation to the authorities, but till date, the representation of the petitioner has not yet been completed. Counsel for the petitioner prays for disposal of the prays for an order directing the respondents for consideration of the representation of the petitioner dated 18th March 2025 and for release of the payment. Then a counsel for the respondents.
Number 8.
Respondent submitted that if a direction is passed, the authority will consider the representation of the petition. At the learned counsel for the parties, the writ petition is disposed of by directing the respondent number
8.
Respondent number 8 to consider the representation of the petitioner within 8 weeks, within 4 weeks, and within 6 weeks from the date of receipt of this order. And if the authority finds that the petitioner is entitled to get the amount, the amount shall be released within a period of 2 weeks thereafter. If the authority found that the petitioner is not entitled to get the amount, a written and speaking order shall be passed within 2 weeks thereafter.
I'm good.
The page disposal.
Much obliged. With your kind leave, my lord.
Yes. Yes.
My lord, these are, my lord, one of those matters, my lord, which strike at the very root of the rural India, my lord. Here, my lord, my lord, this is my affidavit of service, my lord. I've served upon all the respondents, my lord. And my lord, I also,
in this matter on behalf of Union of India, Lordship.
Okay.
my lord, I also have, my lord, a supplementary affidavit if Lordship will permit me to place that, my lord.
What is the supplementary?
And my lord, there has been a development after the filing of the writ petition, my lord, which had to be brought on record. And my lord, this is, my lord, a very short list of dates, my lord, for your Lordship.
What you have prayed for?
My lord, I will very briefly indicate what has happened, Lordship. There is, my lord, an integrated child development scheme, my lord, which incidentally, my lord, the birthplace of this scheme was in 1975 in West Bengal itself. Thereafter, my lord, it was started during the times of, my lord, late Mrs. Indira Gandhi, and it was for the, it introduced the concept of, my lord, including Anganwadi workers. Lordship is well aware of it. Now it is a pan-India scheme. Now, under this scheme, my lord, why we are aggrieved presently, the central government, my lord, has on 13th of January 2021, my lord, it issued a notification. My lord, the scheme has been revised time and again since 1975. It has introduced a system called, my lord, a Poshan Abhiyan. My lord, this Poshan, it caters, my lord, to the problems of malnutrition faced by women and children across the country. And it has issued a very long set of directions for all state governments and union territories across the country as to how to implement this scheme to ensure that, my lord, maximum amount of food, nutrition, healthcare, childcare is given to all parts of the nation. Under this scheme, Lordship, that scheme is at page 57. The relevant portion, my lord, why we are aggrieved, my lord, is that, my lord, kindly comes to, my lord, page 68. 8, no? My lord, page 68. My lord, I've indicated it in, my lord, that short list of dates for your Lordship's convenience. At page 68, my lord, that's a very long set of directions. 68, now, my lord, the central government wants to digitalize this scheme as well. So it has introduced a concept where, my lord, smartphones will be given to all Anganwadi workers across the country so that they can use this Poshan Abhiyan in the form of an app. It is now in an app. So, my lord, what they do is they go to each beneficiary. The beneficiary are, my lord, the children and the mothers and pregnant women, lactating women. So they go to these beneficiaries. They input their Aadhaar number. They take a picture of their profiles, and this app is then created. A database is created for every beneficiary in the country through this mobile phone, so that the government can keep a track of how, my lord, the food is being distributed. It is a,
You're sure? It's still in the village, the remote village.
yes, my lord, they are doing it.
Having the net connection.
Yes, my lord, they are doing it, my lord, doing it. My lord, they are doing it.
Sure, I am giving thousands of the village.
My lord, of course, there is a difficulty. There is a difficulty, but my lord, for
still your bank is not able to give, make the digitalize on the same day. For
I agree.
How this villager Anganwadi worker will
no,
operate
exactly, lordship. My lord, I am in absolutely ad idem with your lordship, which is why, my lordship kindly hears me for 2 minutes. Now, what happened, my lord? The central government has issued this notification, and in 2021 itself, they said that for the purpose of facilitating this scheme, they would disburse an amount of 8,000 to all states for the purpose of buying these smartphones. This was, my lord, initially it was the scheme had started. Then, my lord, they said 8,000 is not enough. We will increase it to 10,000. And finally, my lord, on 28th of March, lordship kindly comes to page 76, which is, my lord, where my rights are emanating from. 28th of March 2023.
26.
Page 76, my lord. Annexure P8.
Yes.
My lord, here Lordship will kindly read with me. In continuation of this ministry's letter dated 13 January 21, which is, my lord, the mother notification on the above mentioned subject and with reference to operational guidelines so and so, I am directed to forward herewith the revised minimum technical specifications of smartphones. These devices, my lord, kindly takes note of this. These devices are required to be procured through government e-marketplace, as per Rule 149 of GFR and applicable CVC guidelines. My lord, kindly comes to the next para, third line from the top. The ICT-enabled mobile application Poshan Tracker is one such technology intervention to enable efficient service delivery by Anganwadi workers. Accordingly, all Anganwadi workers are to be equipped with a smartphone for capture of data. In this connection, all states and UTs are requested to take necessary action for procurement as well as replacement, my lord, of these phones. So, my lord, this direction was given to the state governments all across the country. And, my lord, I have disclosed in my supplementary affidavit that it has been implemented as well by several states. What they are doing, my lord, the state governments, in connection with these directions, they are submitting a tender. What happened over here, my lord, is in our state, not only have this been complied with since 2023, which is why, my lord, I had filed the writ petition. The difficulty now is, my lord, in 2025, in August, my lord, that is, my lord, I'll indicate the notification. My lord, on 30th of May 2025, in furtherance of these steps taken under Poshan Abhiyan, it is at page 85, lordship. At page 85, my lord, in between, my lord, several notifications have been issued directing the state to purchase these phones. And, my lord, in May 2025, because the central government is thinking, my lord, that the scheme is being given effect to, they introduced a system called a facial recognition system, which, my lord, made it mandatory that a take-home ration, it is called the THR, the beneficiaries will be able to take home their ration, their entitled share of ration, only after a facial recognition system is being carried out through this Poshan app. It is all flowing from, my lord, the 13.
What is the facial?
Facial recognition system. So what they do, my lord, is they take a picture of the beneficiary, they link it with the Aadhaar, and, my lord, it scans the face of the beneficiary. It goes into the app. The app has a database of who all have been entitled or have received the ration. My lord, this is all to ensure and to streamline that there is, my lord, minimal corruption. My lord, it is the intention of the government and this.
After the AI, whether this will continue?
Well, lord,
After the AI.
well, these are very legit questions, my lord. After the AI, how they will do it. But, my lord, as on date, they are there. Now, my lord, I had filed, my lord, the writ petition, my lord, when this issue came up. The problem that happened is the Anganwadi workers in the state of West Bengal, firstly, my lord, they did not get these smartphones, which did not have the specifications as mentioned, my lord, in the 28th March notification. The smartphone specifications, lordship, I will
What is
just.
the prayer now?
Now, my lord, I am coming to that, my lord. What happened is the government, central government, directed the state government that you must, I am disbursing 10,000 to you. You disburse some more amount and you have to buy a smartphone,
So
which is.
how you can go by the this memorandum? You have to purchase the mobile phone from.
My lord, that is the difficulty. They have to purchase the mobile phone. What the state has done is they have deposited 10,000 rupees in my account. I am the worker.
But the memorandum dated this 28th of March.
Yes.
Just to the GM.
Yes, exactly. That is what they are not doing. Lordship is absolutely right. Lordship kindly comes back to that mother notification of 28th March at page 76. I will indicate the notification, the specification, and what the state is doing contrary to it. Lordship kindly comes, my lord, to page 77 is the specification. 77, Lordship. Revised minimum, my lord, kindly sees operating system Android version 11 or above. The RAM, internal storage, battery. And, my lord, now kindly comes to page 78 at the bottom. General clauses. This is very important for me. General clauses. All smartphones are to be mandatorily purchased on government e-marketplace as per rule so and so. There should be a provision, my lord. Now kindly sees annual maintenance contract, extended warranty, 2 years of standard device warranty, the state device manufactured must ensure availability of spare parts. Service centers, these are all directions given to the state, and these can only be procured through the government e-marketplace, because, my lord, ordinarily, if I as a layman go to a store and buy a mobile phone, nobody will give me 2 years warranty.
What is the state notification?
Yes, my lord, I will come to the state notification. My lord kindly takes up my supplementary affidavit at page 9. And it is in Bengali, lordship. I will read it out for your lordships. What they have done is, they could not, first violation is, my lord, they did not give me the smartphone. They have pressurized all these Anganwadi workers to complete facial recognition system through their own mobile phones. And these workers are, my lord, overworked, underpaid. They are pressurized at political as well as social levels by their supervisors. I have disclosed all WhatsApp messages where they have zero assistance, zero answer as to how to resolve the issue. They are working day and night. They are handling problems from various centers. So that, because the supervisors, my lord, are saying, I have directions from the above that you have to complete the facial recognition system. And these workers do not have the phones or the means. Now, my lord, kindly comes to page 9. When I filed the writ petition and they received copies, they realized, my lord, they are in trouble. I filed it before the vacation. My lord, the vacations came, the matter could not be moved. And, my lord, what they did was, they immediately, my lord, kindly seized the malafide. They deposited 10,000 rupees into their personal accounts.
No, where is the original?
Yes, my lord, at page 9 of my supplementary.
Page 9 is the subsequent. Where is the first they have directed to purchase from the local
My lord,
market? Where is that?
My lord, directed to purchase, my lord, from the
Local market.
My lord, look, there is no, from GEM, my lord. That is at 23rd, 28th March.
With regard to the ministry.
Yes.
So what is the problem with this?
My lord, the state is not purchasing that. The state has given money to my personal account at page 9. Page 9.
Page 9 is a supplementary. Why the writ petition?
My lord, initial writ petition was filed, my lord, because I was not getting the phones and I was being forced to conduct facial recognition system through my own personal phones, which is why I filed the writ petition claiming.
That's why I am telling where.
Yes, my lord, that impugn notification is at, my lord, page 82 and then 85. At page 82, lordship will come, is the first notification. My lord, sorry, my lord, not 82, my lord, 85, lordship. But kindly sees 85. Mandatory THR.
Correct, madam. These are the guidelines of the ministry.
Yes.
Government of India.
Yes, madam.
Your first grievance is that the state government is not complying with any of the memorandum by taking the mobile phone from the GEM.
First is, they are not providing phones
That's
only.
why they are
Yes.
not providing.
Yes.
They are not providing. That's why you filed this writ application for implementation of this memorandum.
Why, my lord? Because I was aggrieved by a notification of 26th of June at page 87. That was my initial cause of action.
That's why I'm asking.
Yes, my lord. Page 87. Page 87, lordship. I'm sorry, my lord. Page 87. Lord, kindly sees. This is to inform you that as per, this is issued by the Directorate of ICDS, my lord, in state of West Bengal.
That's why I'm asking, where is the government?
Yes, my lord. Mobile verification and Aadhaar authentication, second paragraph, my lord, Aadhaar authentication of the children as well as of mobile and Aadhaar so and so are to be done first for all beneficiaries attending and receiving hot cooked meals for switching over to FRS from the present system of making attendance to the Poshan app. And this had to be done, my lord, by the end of this month, my lord. Kindly see, my lord. This is where by 1st of July, this had to be started. So the workers, my lord, were completely.
Who are you?
Lord, I am representing the workers, my lord. I am representing one society, my lord. It has about 30 to 40,000 workers. But, my lord, it caters to the interest, my lord, of all workers throughout the state of West Bengal.
Before this court, if it by way of public interlitigation.
No, my lord, I am directly, my lord, I am not representing all workers throughout the state. This is only this society. Petitioner, my lord.
Go to the bill. How? You are not.
My lord, this is only in respect of my society that I am aggrieved. My lord, the petitioners are not, my lord, it is not a public spirited citizen. My lord, it's a center, it's called, my lord, kindly comes to, my lord, the first, it is a registered society, my lord. I've annexed it. My lord, at page 41, I've annexed it's a society, my lord. The society itself is aggrieved. It is not, my lord, a case of a public interest litigation. My lord, I have taken care of that, my lord, at the beginning, lordship. Now, my lord, kindly sees what has happened after that. The blasphemy has started even after the writ petition was served upon them. They have now understood that, my lord, this is before the notice of this honorable court.
Okay. Then
My lord, kindly comes to the supplementary ones, my lord. Lordship comes to page 9.
after 87, what has happened?
Yes, my lord. After 87, my lord, there was vacation. They realized, my lord, they cannot do anything. They did not pressurize the workers any further. But they have now, my lord, deposited 10,000 rupees into the account of all these petitioners, telling them that you go and purchase a mobile phone. You meet the specification that the central government has asked me to meet. And if your mobile phones do not meet the specifications, I will debit that 10,000 rupees from your account. And that, my lord, that has to be done by 30.
You have to file the translated copy.
My lord, I will have it filed, my lord, by the end of the day, lordship. But lordship, I shall explain, lordship, what they have done. My lord, it is written at the end.
Cannot read.
My lord, may I translate and read it for your lordship, my lord? My lord,
Bring the translated copy tomorrow.
Lordship,
my lord, kindly gives me.
I have not received the copy of the supplementary affidavit, Lordship.
My lord, I thought they will be here, my lord. I would have given it. My lord, I can
Lordship,
have it served upon their office immediately.
Lordship, they should have handed over the copy in advance, Lordship. We have not
Well,
gone
let's
through with the copy.
It's a supplement. Well, I will serve. My lord, kindly keeps it at 2 p.m. Lordship. I will bring the translated copy.
Petitioner has filed the supplementary. Petitioner had argued the matter at length and filed the supplementary affidavit
Yeah.
disclosing the letter dated. What is the letter dated?
My lord, this 17th October 2025.
2025. But the same is in Bangla language. Accordingly, petition is directed to file the translated copy of the letter dated 17th October 2025. Learned Council appearing for the Union of India submit that the supplementary affidavit has not been served upon the Union of India. According petition directed to serve the supplementary affidavit to all the respondents and file affidavit of service. List the matter on 3rd December under the same heading.
Oblige, Your Lordship.
The difficulty, my lord, is they have indicated in this letter that it has to be purchased by, my lord, 30th of November.
What can be done? You
My lord, kindly gives me protection till 3rd December, lordship. My lord, my writ petition becomes infructuous.
You file the either you.
My lord, I will file it, my lord, today afternoon. My lord, I'll give the translated copy. Lordship.
Madam, when you file the supplementary.
My lord, I apologize, lordship. My
supplementary,
supplement.
when the court
My lord, the translated copy, my lord, I understand, my lord. My lord, kindly gives me some protection, my lord, till 3rd.
The matter has come on the understood notion, and now you're telling that you will take file.
My lord, I beseech your lordship, my lord, if there is no protection till 3rd, my lord, this
You could have been
notification.
understood before filing of the supplementary affidavit. You are relying upon the Bangla language document which the court is not understanding. How the court will interpret that document? You could have been understand when filing the supplementary affidavit.
My lord, I apologize, lordship. Kindly, it grants me, my lord, leave to file the translated copy, my lord.
Because tomorrow already all the other matters are
Then
fixed.
till 3rd, my lord, give me.
Lordship, tomorrow is not possible because, Lordship, I have to take instruction as well, Lordship.
How you will be affected? Union of India is also supporting your notifications. How you are affected?
I'm not affected. I said.
Why you are asking the time?
My lord, till 3rd, my lord, let there be some protection to these
You're not
workers,
filing
lordship.
matter for the half an hour.
No,
He is
Lordship.
supporting your notification.
Lordship.
My lord, at least, my lord, my lord, I apologize, lordship. One prayer that at least till 3rd, no coercive actions be taken against these workers. My lord, these are all very poor women from all across the West Bengal, my lord.
All matters are fixed, madam.
My lord, let it be taken, my lord. Only no coercive action be taken, my lord. Money is lying in their account, my lord, from the state. My lord, they are petrified of what steps will be taken against them, my lord, if they do not comply. Lord, my only prayer, my lord, it is entirely, my lord.
Let the matter appear tomorrow. Tomorrow at the top under the heading on this urgent motion. Yes. Next.
Oblige, Your Lordship.
Grateful, lordship.
Grateful. Your Lordship. On a
मैटर नहीं है.
हाँ, Your Lordship, there is a fixed
Fixed matter
matter.
है कि नहीं है?
Item number 3 fixed at 2 p.m.
12.
12 p.m.
Then tell him to have it.
ঠিক আছে আমাদের হচ্ছে ডাকলে দাদা ওয়ান সব 1 ঘন্টা তো চেষ্টা করছি 1 ঘন্টার আগে ছেড়ে না
Yes.
My lord, I'm really shocked.
Have you served the copy?
I'm for the respondent.
I'm really shocked for these reasons, my lord.
Day before he has extra my importance to remind your lordships. Every time we are coming and disturbing so many matters, extremely important to remind your lordship. Day before yesterday, I mentioned this matter. Realizing there is some urgency, my lords fixed today, in spite of so many engagement. 12. What they did, my lord, I intimated them in writing. They took certain step, purposely motivated. It's total malafide. I'll place everything. Now, kindly take trouble. Well, what is actually happening? In short, let me explain. My client, well-reputed contractor.
Only
Till
thing before my learned senior friend commences, but I'm led by the learned advocate general. He's in Delhi, my lord, for a matter. But could my learned senior friend submit today? We will give the reply tomorrow, my lord, if your lordship can be perfect.
That is up to them, my lord. Your lordship, because earlier, Mr. Advocate General appeared, then order was quashed. He has every right to oppose me. Since he is not available, it is their headache. And if the my lord oblige them, then they will come. But let me finish, my lord, so that. So, my lord, the reputed contractor, the huge amount involved here. Now, what has actually happened?
I appear for the state respondent, Miller. Kindly permit me to address online, Miller.
Advocate General, what is saying tomorrow?
He will argue the matter.
I know he is arguing. The earlier question also appeared and he opposed strongly. He is better the order of citizenship. But anyway.
May hear it today.
Your junior is here, I'll argue.
Yes, Mr. Dutt. Mr. Datta, let me complete. You have any difficulty, then I will hear you tomorrow. Or if you want to argue today, then you can continue with that. There is no problem.
Very good. But let Mr. Banerjee conclude today.
I'll try, Mr. Datta. I'll try.
No problem. Yes.
So, my lord, a tender was floated. So, this NIT notice inventory tender was floated. And the jobs to be carried on, my lord, construction of my lord embankment is a huge construction, my lord. So, I thought I'm competent enough after going to the papers. So, I participated in the tender. After considering everything, there's several. You are qualified. There are two stages, my lord, technical and the financial. Financially, you are sound. You are qualified. 2 or 3% that is qualified. It is not my headache. Qualified. After some time, my lord, certainly there is a no based on a complaint that you have suppressed something. That's why you are cancelling. And some condition was, a penalty was imposed. Everything was ex parte.
Penalty was imposed.
Everything was ex parte. So I challenge during vacations. Let us first read, my lord, the reaction of your lordship's court during vacations, my lord, which is at page. Follow. I did not read the entire order. 5. There are several volumes, my lord. I cannot carry your old man. How can I carry all this paper? 540, volume 4. Kindly take trouble to come volume 4, my lord.
Yes.
Yes. 540.
Yes.
It starts from 540.
Yes.
Have you got it, my lord? Sorry.
Yes.
The petitioner is agreed by an order dated September 1625 passed by the Chief Engineer Irrigation and order is directed whereby penalty for forfeiture of the earnest money to the tune of 50 lakhs is not mentioned. Debarment for a period of 6 months with effect from such and such. Then case of the writ petitioner is also details. I'll come later on, my lord. Then feeling aggrieved, next page, paragraph 6. I'll give writ petition. During the pendency of the aforesaid writ petition, the said tender process was cancelled by later decision on the ground, the number of qualified bidders less than, well, very material. So before cancellation, I was disqualified. Once the tender is cancelled, that goes everything. First thing to be taken in considerations. Then, pendency of the aforesaid writ petition, the said tender process was cancelled by later decision on the ground, number of qualified bidders was less than 3. Certainly, they can do that. Subsequently, the petitioner was served with an order Kali marked is very relevant. Subsequently, the petitioner was served with an order dated September 16, 2025, whereby penalty for forfeiture and debarment was imposed. And it is this letter which has been imputed in this present order. Mr. Such and such appear for the writ petitioner has taken this court through the order dated such and such and submitted that the said order has been passed without issuing any show cause and without hearing the petitioner. It is submitted the same ought not to have been passed, inasmuch as the same has been effect the putting the petitioner out of business for a period of 6 months. Learned Advocate General for the state respondent has taken that pen. I'll place all these things, my lord. Provision has been there. Violation of the tender condition, but has also submitted documents containing false information. I'll place it, my lord. In order to buttress the contention, he took us to the certificate regarding summary statement of yearly turnover of business. That is the only thing.
Yes.
Point is whether GST to be included in my offer or not. The document appearing for 80 and such as turnover document only for the purpose of crossing the turnover threshold. It is further submitted so many heard the learned advocate, paragraph 12, appearing for the respective parties. The certificate and such and such petition which was submitted by the petition initially, along with this bid, prior to notice that is such and such, being issued to him, shows that the petitioner has concluded his turnover by treating GST component as part thereof by including the GST. Kindly pause there for a moment. As we know, my lord, when a NIT, notice of tender issued, whatever his condition is there to be followed. Neither the person who is participating in tender nor who invited the tender, they cannot deviate, they cannot change. Correct. So I can assure you, lords, my lord, nowhere in the, if the show that that's a different thing. Nowhere in the tender notice, it is mentioned that whether it is included and excluded. More interesting, till today, my lord, all I participated in so many tenders under that department. Nowhere, every time, my lord, including GST, and all participants, I could have understood. One participant was deprived, and I was benefited, and discriminations. All the participants, including GST, they find it. GST component as part thereof, including GST component. It is apparent that the certificate annexed as the page answer was furnished by the petitioner under cover letters and such, whereby the petitioner ought to explain as to why the petitioner has included the GST component in the turnover. The petitioner's explanation as prepared by this letter, this uncharged may or may not be correct, but then the respondent ought to have been considered the same prior to issuing the order of imposing penalty for forfeiture and debarment. It is well settled that no order having civil consequences can be passed. Well, these are the Supreme Court judgment. My lord is very much aware. I need to still also evaluate repeating. Then the order impugned September 16, paragraph 15 has been passed without issuance of show cause and without hearing the petitioner. The submission of Mr. Dott to the London Advocate General that no difference, Kali marked it, my lord, is very interesting. No different conclusion would or could be reached, even if the petition is hard, fails to impress the court, inasmuch as the order is answered as impute in the petition does not show. As how the petitioner's clarification. But it's honored. Before it is decided, it's in close mind. They already decided some or other Mr. Banerjee should be kicked out from the race. Even if the opportunity of giving, even everything is considered, fate will be the same. He is a condition which is dismissed.
Yes.
So, my lord, concession that turnover should be inclusive of GST component may or may not be correct. But then the reason as to why such explanation is not acceptable would definitely be required to be furnished if it's the order of imposing penalty for such. It is equally settled that none of the ways of natural justice is self prejudice. And my lord, Kapoor's case is there. The advocate tried his level best to convince the court. No, forget about Kapoor or anything. We'll do that. In such matter, the order imposed on such, these orders shall, however, not prevent that obviously, my lord, pass the opportunity of hearing and pass an order. When the order is passed, logically marked it, my lord. I am really surprised. I was also first GP of this government, as the first AG. I am shocked seeing all these things. What is going on nowadays? 9th, 540, 9th October 2025. This order is passed. Page 540. At top on right side, left side.
Yes.
After that, my lord, there is a show cause. And show cause, formal show cause, nothing. But I do their attention in some cases. Kindly. Yes. 551 is a show cause.
Yes.
I've never seen such a cryptic and small. 551. And date is 13th October 2025. No problem. During final technical evaluation was as such, the work, anti-erosion work to the right bank of the river Padma at Ewar, such as renewed for a total length of such and such. This is such and such. You have only declared professional tax, but no declaration regarding GST was found there. Moreover, in the clause 40 of the said forms 3 CD, it was found that the total turnover was shown inclusive of GST. Such submission in tender is treated as concealment of information such and such. As per the direction of the Honorable High Court, the representation and such in context your petition 26 August is present. So, put a chamber and judge and chairman tender, central tender units and such. This is the so-cause. Such a cryptic. So that is the main allegation. I have concealed, I have committed gross irregularities, but they failed to produce any scrap of paper to show that, well, even in the NIT it is specifically mentioned GST to be included and to be excluded. And up till that day, in all, kindly take note of it, serious, up till that day, all the tenders, even I filed, including tender GST, that has never been turned down.
Yes.
Page 552. Right. Sorry, my lord. Page 552.
Your reply.
This is a clarification.
Yes.
My reply. ENIT Sanchar anti-erosion. Sir, we have the honor to state that the aforesaid memo has since been received by, and we have carefully gone through and examined the contents of the same. Our response to the imputation content in the said memo are stated in the preceding paragraph. The threefold imputations alleged in the aforesaid are as follows. In clause 26 of the Form 3 CD, only professional tax has been declared, but there is no declaration of GST. In clause 40 of Form 3 CD, total turnover was shown, inclusive of GST. Then, such submissions, next page, such submission in tender is treated as concealment of the information to such and such. Unless I am asked to disclose this information, the question of suppression, omission, non-disclosure, all these are useless. Our response, therefore, is restricted to the aforesaid threefold imputation as exposited in the memo of such. The fact germane to the issue in question are on 12th July 2035, an END tender for the subject work was floated and we had submitted our bid on 3rd August 2025 along with all documents as were required under the tender condition. On 18 August 2025, the TBO technical bid was uploaded by the authority comprising the super engines and such and engine declaring us as qualified. So at the first instance, they are satisfied because they know I have done nothing wrong. Subsequently, 26/25, the Suvarno engineer advised for providing a report of the chartered accountant containing gross turnover, excluding GST for the years, and that how they can introduce, I do not know. But they say, no problem. GST for the years and the zone of consideration of the said NIT for the financial year such and such. It was further stated that the statement was to be provided in a letterhead of the chartered accountant having such generated acknowledgement with supporting documents if required. It has been further stated in the said letter that on the basis of the said certificate, further course of action would be taken and the required documents as sought for the wash of the exercise. But if the
Yes.
If the law says, law is very clear, offsprings of the law, if they are guided and controlled by any provisions, they cannot travel beyond that. Very well-known principle, my lord. So here they must follow the NIT. On 26th October, we had furnished the required data and the report of the chartered accountant duly signed and authenticated. In the said report, specifically certified that the statement showing the summary of the audited balance sheet, which was arrived from the contractual basis and for the 5 consecutive years. The said certificate of the chartered accountant was forwarded under cover of your letter dated such and such, wherein we had inter alia stated that as per the NIT minimum eligibility criteria B, financial eligibility, we had duly submitted the gross annual turnover, 30% the amount put to tender, which is inclusive of GST amount, It has been further stated that in the NIT, the authority have also followed the same procedure of the inclusion of GST amount while arriving at the amount put to tender. In the light of the said submission, we believe that while uploading the technical bid, the authority declared us as qualified considering the same basis of the inclusion of the GST amount. Moreover, all the tenders processed by the department were done with inclusion of GST amount, both in the tender value as well as in the turnover value. The IT department also accepted the balance sheet increase of GST value as filed along with the EIIT test. Pause here, Kali moment, my lord. Suppose income tax says something. Now, if I flout or violate any terms of the law of the income tax, they can proceed against me. But if they want to introduce that, they must borrow this and incorporate in the NIT. Nowhere it is stated. So it cannot be relied on. Then, on 1st September 2025, the chief engineer and the chairman Central Trade Unit declared that our bid stood disqualified with the observation since annual turnover value is considered excluding GST as per 5 to 50 guidance note on tax audit under section 444AB of income tax, and the GST component are separately added on expenses side under different names as well as on the income side within the contractor bill value in the trading account and profit and loss account to show the sale value as inclusive of tax in the balance sheet under the current liability, separately liability shown for the GST liability. On the same day, that is on 1st September 2025, we had registered our objection to such wrongful observation and also for declaring us disqualified. In the said letter, we had literally stated that nowhere in the NIT it is mentioned that the financial eligibility criteria would be valued excluding GST. It's very relevant. Nowhere it is stated. In all tenders under the irrigation water loss directors, Government of West Bengal, the financial eligibility criteria have consistently been considered, including Kali marked it, very relevant. In all tender. So this is a solitary instance when they thought they would be able to kick me out. Raise some point. More interesting. No further response has been received from the authority in this regard. Being agreed by such HON'BLE petition, we had filed a writ petition from the facts and how it is evident that the point of controversy on 22nd August after declaring us a technically qualified has been whether or not annual turnover route includes the GST or excludes GST. In our letter dated such, we had very categorically stated that there was no specific provision in the NIT, Kali marked in minor, as to whether gross annual turnover was to be calculated exclusive of GST. If they borrow something for income tax, they must incorporate it. Laws is that you can do. Even in municipal act, my lord, sometimes it has happened. How municipal corporation? There's a problem. Naturally, Calcutta Municipal Corporation, they borrowed the provision of the Calcutta Municipal Corporations. We had very categorically stated there is no specific provision in the NIT as to whether gross annual turnover was to be calculated exclude GST. Conspicuous to note that the obvious reasons amount to put to tender includes the element of GST. My lord, Kali marked in my lord. It includes the element of GST, and for obvious reasons and by implication, the gross annual turnover should also include GST. Thus, the qualifying criteria that was an amount put to tender should be the minimum gross annual turnover. The bid submitted by us includes the PLR accounts and balance sheet for all financial years within zone of consideration, which indisputably contain the GST paid amount. Thus, there cannot be any attempt to conceal the GST amount so paid by us. So unfortunate. However, in disregard to such this clarification, as well as furnishing the certificate of the chartered accountant, our bid was declared disqualified by the chief engineer September. If the said memo, the ground for declaration, our bid has also been the issue, the average annual turnover, and that too on the basis of a competent receipt from the Kali market, which is very really relevant. So whatever they have done based on the complaint of another person. And my lord is surprised to note that another person, if it is that lack of something, she has been accommodated. I'll come later on. The serious allegations. Money talks. Now is the problem ours. Now, Kylie, the ground, again I'm ready. Just the ground for declaring our bid as disqualified has also been issued of average annual turnover and that too on the basis of a complaint received from another bidder. No other ground whatsoever was considered as the basis of declaring our bidder disqualified. Then who is pulling the sting, sitting with the sting? That person's. He or she has to be obliged. And in order to give her an accommodation, some or other they are trying to kick me out. The ground relied on the authority. And this complaint was never been given to me. It was never been served. What is the complaint? I must know.
Yes.
The ground relied on by the authority for declaring our bidder as disqualified was not only unjust and unfair, but also suffer from serious illegal infirmities. In any event, the tender was subsequently cancelled on 12 September 25 on the ground that technically qualified bidders in final technical evaluations has been less than 3. The decision to cancel, there also that ground was not included. Very interesting. And that the EMD such and such, it is also
Okay, these are your reply.
details reply, my lord, details, so that they may not take advantage. No, nothing is the answer. I should not disturb your lordships.
So what has happened further?
I've just, paragraph 13, I've just read, my lord. I will not detain in paragraph, kindly go to paragraph 13. Have you also gotten, my lord? 558 page.
Yes.
In this regard, it is pertinent to mention that we have observed from the bid submitted by two other bidders, Kali marked is very, very relevant, by two other bidders, namely Messrs. Adhunik Construction Company and Chakraborty Construction, that both of the said bidders did not include GST separately in clause 20. This Chakraborty Construction, they have been obliged, Kali marked in minor. That will come later on.
Yes.
Now, my lord, one thing is very clear. They may say, why did not make her a party? Make him a party. And why should I? I don't have the allegation against everybody. I have got the allegation against you. Knowing fully well, whatever position you have initiated is based on the Chakraborty's complaint. Why did you not serve me a copy of the application? And you have obliged the Chakraborty. I'll come later on, my lord. Mrs. Adhunik Construction and not included GST separately in clause 26 as well as clause 40 of form 3CD. We also have definite information that no punitive step as per clause 11G or of the NIT has been initiated against either of the said bidders. These obvious the conclusion that the non-inclusion of GST separately in the form 3CD and clause 26 is not an attempt on concealment of information of influence, the outcome of the illegal steering in the tender process. So similar circumstances, they thought based on their allegation, you are disqualified, but it's so irony of fate that that person is selected.
Yes.
Kindly come, paragraph 18 is a summary. For your lordship convenience, 559, paragraph 18. From the aforesaid exposited fact, it will be evident that all disclosure as warranted in the NIT have been furnished by us, which are necessary for declaring us technically qualified. And I was technically qualified earlier, based on the allegation of another persons, I was disqualified. There is no concealment of any information which might influence the outcome of the eligibility screening in the tender process, inasmuch as pursuant to the authorities letter dated 26/25, we have furnished the CS certificate showing the GST separately. In any event, all the financial information are available in the profit and loss accounts and balance sheet, and no new document is necessary to substantiate the QR. The disclosure in the form 3CD, clause 26 and clause 40, which is part of the IT return, has no bearing for the purpose of determining the QR, and hence there is no concealment. It has nothing to do with that. Hence, the imputation that such submission in the tender is treated as concealment of information to influence the outcome of the eligibility screening in the tender process is not justified and hence observed to be dropped.
Yes.
So this is the order to the my lord, kindly take trouble. I'm sorry to disturb your lordships, my lord. 561.
Yes.
My lord, here I specifically mention and 562 The document which I supplied, 562 I given. What is the concealment? I was not even aware that it is not excluding. And in case of others, this will consider. They have also filed their tender with including GST. Ki cholche, huh? Then kindly take out of para 3 of 561. However, in furtherance to our responses and such, and as specifically stated therein, we are annexing copies of the undernoted document for substituting our case and contentions. Kindly see, my lord. Where is the suppressions?
Yes.
And I have got the refund from the income tax that is accepted. Actually, difficulty is if the action is taken on the basis of someone else, who will be ultimately obliged, then they will commit so many mistakes. Somehow or other, my client should be kicked out from the race.
Yes.
Kindly come to 564. 66 onwards. I've got the refund. Huh? Income tax is accepted. Anyway, the next thing is this, my lord. It is পড়া হয়ে গেছে 493 টা কি ছিল আপনাদের মধ্যে 750 after hearing what order has been passed, kindly take up.
Where is the impugn order?
My lord, volume 5, it is volume 5, 750. Volume 5, my lord, Roman 5.
Yes.
Have you also got it, my lord? I'm grateful. Mr. Abdul Matin, a registered partnership firm, participated in a tender process initiated by the Irrigation and Waters Department, Government of West Bengal, for commissioning anti-erosion work to the right bank of the river Padma, such and such, in block number such and such. The notice inviting tenders bearing number such and such was published by the Irrigation Department, Government of West Bengal on July 12, 2025. Mr. Abdul Matin, hereinafter referred to the bidder, suppress material facts. Again, my lord, suppress material facts and particular in the bid document for the purpose of being selected in the tender process initiated by the Irrigation and Waters Department. Kindly pause there for a moment, my lord. If it is suppression from the right from the beginning, so it was available when I was declared as qualified, then they didn't bother. As soon as they get a complaint from another person, who is a favored person, favored child, they say, no, you have committed these suppressions. Then, as a result, pursuant to an order such, the bidder was debarred for a period of 6 months on the form and from September 16 to the end was even directed to deposit 50 lakhs. The said order was passed in terms of the clause 11GA of the tender condition of NIT. I'll place that later on. The bidder challenged the order dated September.
High Court order.
My
You
lord,
are mentioning about the High Court order.
yes. Now I can skip over, my lord. Paragraph 5.
Yes.
Paragraph 5, my lord. The bidder suppressed material facts and documents at the time of submission of his bid in the tender process initiated by the Irrigation and Water Department. The next, my lord, volume is very thin, like me, my lord, not healthy one, like my junior friends, my lord. They are all healthy persons. কোথায় গেল?
Thin, but that the main is there only. The thin only, the main is there. 751. 751.
I'm making 2 minutes. আরে দাও 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 আমার এখানে যাবে তো I'm making 2 minutes time, my lord. এই যে এইটা বোধহয় এটা volume 6 তো then কালি go to volume 6 page 751.
Yes.
What was Department Government of West Bengal in terms of clause 7 Roman 5B of the tender terms, the bidder was required to indicate whether average annual turnover from its business is any 3 financial years within the zone of immediately processing the 5 financial years as stated in clause 1 such of the tender terms was at least 30% such as nothing more, nothing less. If there is a lack of supply of the information, I can understand. Everything is covered. Nowhere it is mentioned. And in supplying that, you must show that is excluding GST, not including, nothing.
So that is the only point here.
My lord?
That is the only point.
That's the only point.
Whether the clause can be interpreted, it include the GST or exclude the GST.
And apart from that, my lord, there is a very serious aspect. Under similar circumstances, the person at whose instance they started proceedings.
That is one suspect.
And he has been obliged.
Okay.
He suffered from the same problem, if at all it is a problem. In the present case, it would appear from the tender documents that the amount put to the tender is 75 lakh 46,000, 75 crores 46,000, 65 so many taka I am confused. I am a poor man, I cannot understand. 75 crores, 46 lakhs, 65,000. In order to establish the eligibility, the bidder was required to provide the average annual turnover in terms of clause of the tender committee of NIT. In the present case, though the bidder provided the annual turnover, however, the average annual turnover of the bidder was submitted including GST of component. Average annual turnover also referred as an aggregate turnover excluding central tax, sale tax, inventory tax, tax also. Average annual turnover according to the guidance note on tax or such and such. If really that is so, why did you not take step in all other cases? Why you allowed so many years? That means it doesn't apply. To penalize me, they have started all these things. It doesn't apply. Could not have been included GST component. Turnover would signify the aggregate amount for which sales are effected or service rendered by an enterprise. If GST of any other tax is included and or calculated in the sale price, no adjustment in respect thereof should be made for considering the quantum of turnover. This is not specifically categorically it is mentioned. Turnover. Trade discount can be deducted from sales, but not the commission allowed to third parties. If, however, GST on any other indirect tax recovered, credited separately to GST or other tax amount being separate account and payment of the authority are debited in the same account, they would not be included in the turnover. However, these are all their brainchild. Now they are introduced all these things. Turnover. However, sales of tabs shown separately under the heading miscellaneous income will have to be included in turnover. Thus, from the above, there cannot be any out of doubt that the turnover for a business enterprise cannot, in any manner whatsoever, includes the GST component. They have come to a conclusion on that basis. Very peculiar, my lord. What prevented you to disclose all this in your NIT? Why did you not do so long? In fact, during the tender process and during the course of submission of the requisite forms related to financial criteria, the bidder submitted from TCD, despite there being a specific provision in such form which mandated the bidder to state whether sales tax, goods and service tax, customs tax and such, or any other direct tax was passed to the profit and loss account. The same was not indicated by the bidder. In fact, this is also not correct. In fact, the bidder clandestinely and only in order to suppress relevant information, only disclose the quantum of professional tax that the bidder incurred. That apart, despite there being a specific provision for providing details regarding turnover, gross profit, or the previous proceeding, yes, relevant information was not shared. The capital. I am really surprised, my lord. If really that is so, on what basis you declared me qualified? Everything was done. Even if it is not done, how that will affect? Because does it appear from the NIT? Then the aforesaid information was purposely bidder only to show that the bidder has a high turnover. Moreover, the GST component in the average turnover was included only for showing the enhanced amount of turnover. In those circumstances, it would be evident from the above that the bidder has not provided the required information. The bidder concealed and suppressed relevant information, suppression of relevant information, and even concealment of material facts result in a first degree offense in terms of relevant DI of the tender condition and NIT of NIT. Very marked in my law. My dear sir, did you ever mention in the NIT? How can you say it is suppression? But there are aspects: suppression, omission, and non-disclosure. Suppression is serious, non-disclosure, but omission, even if it is so, because there is every chance of confusions. Since you have allowed others, so naturally, even if it is so, that means then due to cancellation of the above mentioned, the issue of forfeiture earnest money has not been insisted at this stage. Why? If I may commit a serious mistake or wrong, punish it. Why you do this? The grounds mentioned by the bidder in the representation dated October 2025 are untenable. The issue regarding the complaint, if any, made by a third party against the bidder and other past is not relevant. Bah, chamatkar. Kindly marked in my lord. Matter of convenience. The opening of the proceeding based on that complaint. And now they say it is not relevant. The bidder has been debarred on the basis that a first degree offense has been committed as per the tender conditions. The bidder has not been debarred on account of a complaint lodged, but for reasons mentioned on what basis he came to learn. Then why did you allow me in the first instance? As soon as you got the complaint, what is the complaint? Who have lodged the complaint? Get me a copy of the complaint. Nothing is there. Income tax department accepting the balance sheet of the bidder, wherein according to the bidder, GST component has been included in the turnover, will not have any bearing on the, in case of interest not bearing. In case your case it is bearing. Component has been not bearing on the decision taken by the irrigation waters department. It has already, they are relying on the income tax. This is not bearing. It has already been discussed in the previous paragraph of this order that average annual turnover, turnover cannot include any sale tax, cannot include any sale tax, central tax, unit tax, immediate tax. Says very well. If it is not, I am not giving. It's not penalty. Yes. No, nothing wrong. No suppression. If it is include or exclude, not include. Can you mark it, my lord? Turnover includes, cannot include any, cannot include any.
Cannot include any sale tax, tax, Indian territory tax.
That are not done. What is the wrong in it? The case is accordingly disposed of in terms of the order of the Calcutta High Court. As well. So this is the order which is under challenge. Finally, take trouble to come 86 page, volume 1. Actually, this is NIT. It starts from HON'BLE Corona. Just have to shunchen, HON'BLE Corona.
Yes.
It starts from earlier pages.
86.
72. Start from 72. I will not disturb your lordships by reading everything, anything. 86.
86. Grounds for suspension and debarment.
Yes. A bidder who has disqualified by the competent authority of the irrigation orders department, what is Bengal? No. G. Oh, sorry. D. Ground for suspension of department. I'm sorry. I'm being unconditional apology. D. Capital D. Submission of eligibility requirements containing false information or falsified documents. Documents are all genuine. I did not use any false document. And no question of false informations. Whatever is there, that is there. Now you have invented something which does not reflect from your own NIT. So you are doing mischief. You have committed wrong. Now, my lord. My lord, did it start from procedure, page 85, 11, procedure for suspension and debarment of supplier contractor. There, my lord, page 85, yes. 11, A, scope.
Yes.
So it's not that, 87, my lord, can take trouble. G. बोले दे, okay, बोले दे. Then G, my lord.
87G.
87.
Penalty for offense.
Penalty for offense. For committing first degree offense, any of the cases referred in clause 11D1V. Just now I have just pointed out, my lord. 1180 page 86. Kindly come once again. 11
Yes.
D1.
Submission of eligibility requirement
Four.
containing false information.
Yes. Have you got it, my lord?
Yes.
I'm grateful. Then, forfeiture of earnest money and debarment of a period of 6 months. If the offence is deleted during technical evaluation, if the offence is detected after award of the contract, if the offence has happened to be a agency selected for work and such selection is made due to oversight. Now, very interesting, my lord. I could have understood why I have committed a mistake. There I missed it, oversight I have to say. No, based on a complaint they have started. You can't say oversight. So in order to put me in trouble and kick me out from the race, you took the help of persons who suffering from the same problem, my lord, or same technical fault, if at all, and she has been selected.
But in the final order, they have stated that no, they have not taken the decision against the in terms of the complaint only with regard to the document which is submitted.
Very interesting, my lord. In order to avoid these particular obligations, it's a fundamental principle, my lord. There's no doubt about it. If any proceeding initiated on the basis of the complaint, the person against whom the allegations are level is entitled to have this complaint and to justify. My lord, now conveniently they say, no, he is no matter. Then why you have started? Ignoring? Why you have started? Tell me. On what basis you started? Who do that admission? Nothing?
Yes.
Then, my lord. Kindly come to a certain paragraph, my lord, is very relevant. Page 4.
Page
4. For the convenience of the court, my lord. Para 6.
Of the writ petition?
Writ petition, my lord. I'm grateful. Sorry for your loss of trouble, my lord.
Yes. Para 4.
Page 4, para 6.
Yes.
On and about 12 July, this one, two, this one in the session, inviting office offers, anti-rosers. I've already explained, my lord. Financial eligibility, person.
Yes, that is the same.
I've already placed you. Then page 5, para 7. Page 5, para 7. Have you got it, mine?
Yes.
Page 5, para 7.
Yes.
Your petitioner states that the words amount put under as stipulated in the clauses of the NIT would appear from the aggregate value of the bill of quantities BOQ being part of the said NIT. It would appear from the said BOQ and clause 12 of the said NIT that the total value of the aggregate value of the work to be executed under the said tender arrives at the such and such, should be 75 crores, 40 lakhs and such and such, which includes GST.
Yes.
So what's wrong? What's suppression? I've annexed this document. A copy of the said BOQ is annexed here is annexure B3. Have annexes. Annexure 3.
What was the amount required for the tenderer?
30% of the?
Because if you have included the GST.
Yes.
If the GST is not been included, whether your client, the petitioner is not been able to participate in the tender.
That is very pertinent question, my lord, put me this, my lord. Kindly appreciate, my lord. If that is a spirit, I would not participate. Once I found that is including GST, naturally there is no bar. But it is perfectly right to ask the questions. Suppose 30% GST is excluded. Will be able to participate in that? But Lord, if it is so, naturally I cannot. But Why did you not disclose in the NIT? Why should I take the trouble?
No, because their whole contention, you have disclosed the GST, including you're not excluded. The
That's
GST. That the court will interpret whether
yes,
it is required or not. So, if suppose
I followed.
So, what would be the effect?
If the GST is excluded, what will the amount?
That's right. What would the amount?
I'm bringing 2 minutes. Percentage are you 30%.
Where is the tender? What the tender?
495 page. What part of that? Very pertinent question. Bala very rightly put this. So I expected, my lord. That suppose GST is excluded, will be able to participate in the tender?
That's what I'm telling.
496. Volume 4. And very peculiar. I could have understood that they adjudicated on this point. Nothing was done. They said the suppression straight away. So there is no scope for me to explain what you are saying is not correct. Even if they excluded today, it is following by my lordship. I'm grateful. I could have said that, well, even if it is excluded, that will not change and alter the position. 496.
496. It is your document. 24, 25, the total value 27. GST 4 crore. Then it will come 32.
That is close. I did not suppress anything. I may lose, I may win. But I should not leave the court with that impression. My lord.
So this document 496 included in the tender document?
No, it is subsequently disclosed.
Is it disclosed in the tender document?
Yes.
Is the financial bid?
No. Because that location was never announced. Had it been a case, they say, unless you disclose that, excluding GST is the opportunity, Mr. Banerjee. If we find that, well, excluding GST, your amount is covered. No problem. They never ask me this question. They never inquire. Their whole intention is somehow to put that particular trap that you are actually suppressed. Today, my lord is asking very rightly.
Yes. Yes.
Very interesting, my lord. Penalty is imposed on false informations. And I disclose what? Suppressions. They are not sure what step to be taken because they are biased.
Yes. Next.
Kindly take trouble to come. I'm begging 2 minutes time, my lord. Just a minute. My lord, if your lordship kindly take trouble to come, page 9, para 15. No, before that, I'm extremely sorry, my lord. I may be page 8, my lord. Para 13, my lord. Page 8, para 13. I'm sorry, my lord, for your loss.
Yes.
Your petitioner states that Honorable Sajan, the respondent for the Chief Engineer Sajan, issued a letter stating that the bid submitted by your petitioners to disqualify on the ground that the average turnover Sajan 3 years with a zone of 5 preceding years was less than mentioned PQ such criteria. Mentioned in PQ criteria in the NIT. It's not correct. They must answer to your losses, my lord, because they are, when they're relying on the NIT, they must rely as a whole, whether their condition is there or not. In the said letter, it has further been stated that the annual turnover value is considered excluding GST as per 5.2 and 5.5 of guidance note on tax audit under section 44 capital AB and income tax and such. It is further stated The GST components are separately added on expenses side under different names as well as such and such. Next, paragraph 14. Your petitioner states that the ground chosen by the respondent in declaring your petitioner's disqualified is per se bad in law, inasmuch as firstly the condition stipulated in the NIT does not specify as to how the average gross turnover would have to be considered. That is whether it would be inclusive of GST or exclusive GST. It's very close to the root of this case, my lord.
Yes.
Secondly, the object and purpose of calculating the average annual turnover under the Income Tax Act is not similar to the purpose and object of calculating the average annual turnover for evaluating the financial ability of a bidder. There's an answer of all these things. Then paragraph 15, your petitioner states, in terms of the NIT, a bidder shall qualify in financial criteria only upon satisfying this average annual turnover 30% of the amount put to tender. Amount put to tender. Nowhere in the said NIT is specifically stipulated that such average annual turnover should be exclusive of a GST. Interestingly, the amount put to tender is inclusive of GST 30% of the said sum. For obvious reasons, includes GST. Thus, determination of average annual turnover excluding GST is not only a product of afterthought, but also not justified. Then paragraph 16. Your petitioner states that all along, the same procedure of including GST in the average gross annual turnover was being followed in evaluating the financial eligibility and had never been objected to, which will be evident from the credential document, that is work order and completion certificate, etc., which have been submitted by the petitioner along with the bid.
Yes.
So all manufactured afterthought. How to kick my client out?
Yes.
Then my lord, page 18, my lord. No, page. I'm being half a minute time, my lord. Tag me down. Page 21, para 35.
Yes. Para
35.
yes.
Your petitioner says that in the meantime, the sworn engineer Sansaj issued a fresh show-cause notice, Sansaj. Your petitioner wherein following imputations inter alia were alleged against the petitioner in clause 26 of the professional tax has been declared, but there is no declaration. But it's already placed, my lord. I've already placed it. Then show-cause notice. Then was 23. Now, my lord, I have specifically page 23, my lord. Just 5 lines above Roman 5.
Yes.
1, 2, 3, 4, 5 lines, my lord. It starts with the moreover. All the tenders previously floated by the department was with the inclusive GST amount, both in the tender value as well as in the turnover value. The IT department also accepted the balance sheet inclusive GST value. Much has been said about the IT, my lord. 494. 561. For the convenience of the court, my lord, it has copy আছে দাও দে না ভাই I've just put it in the for the lawsuit convenience, my lord, annexures and the first time notice all these things. Page আমার পিটিশনটাকে ওই তো দিয়েছে তো দেখ না ওই তো পিটিশনটা তুই পেয়েছিস তো আমি আনকন্ডিশনাল বিচার কি হলো রে ভাই যে বন্ধ হয় না আচ্ছা 561টা কি 561টা কি বলেছিলাম কত ভলিউমে আছে
Yes, next.
হ্যাঁ কাইন্ডলি কাম টু ভলিউম 4 ও দেখানো হয়ে গেছে না ঠিক আছে আর কি আছে বলো তো Now, my lord, very interesting. My lord may say, why you are using the supplementary affidavit for obvious reasons? Kindly see that matter of ID. At the outset, I do a lawsuit guidance. Day before yesterday, I mentioned. My lord is kind enough, consider urgency today, 12 o'clock. Immediately, my friend wrote a letter to them. This is the situation, so notice. Please, wait. Normally, when you join, that is a system. Once the petition is filed, normally it's a breach of trust. We say very well, since it is pending, the officer also says, since it is pending, we will not proceed any further. Let us wait and see what is actually happened. Immediately they say, on that is yesterday. Yesterday they passed the order.
Have you served?
I shall serve. Right now I serve. Because overnight I prepared. Oh, email me. আমি তো ওগুলো as a fair boy, looking fair, conduct is fair. Page স্বীকার করেছে. Kindly see their conduct.
Yes. So this is a new tender.
My lord, let's have the copy by email. It's a new tender. In the supplementary, my lord, I'm sorry.
Yes.
Page 22, para 12. Kindly see the date.
Page 22.
Page 12.
Yes.
P22, page 12.
Yes.
The order which has been passed by them, and kindly see the next page date 26 October. Today is 27. At 25th, we have given information. Kindly see the conduct. So, my lord, got it, my lord. Why is so urgent? Heaven will not fall. Heaven will never fall. But I'll go to hell because of their contact. Kindly come to chart, page 12.
Yes.
Name of the contractor bidder with the bid ID, whether qualified or not. Kindly see Chakravarti 2.
Yes.
Serial 2.
Yes.
Chakravarti construction.
Yes.
He was disqualified earlier. Now he is qualified. And for the same offense, he was disqualified. And now everything is erased. Now he is qualified. What is going on? Very difficult to understand, my God. Somehow or other.
Where is the rejection of the Chakravarti?
First time, huh? I'm begging 2 minutes. 4, ভালো করে check করে দাও 491 volume 4 491 volume 4
Not qualified.
Okay. Can you see 491?
Yes.
Chakravarti not qualified.
Yes.
And kindly see the last box. Brief reasons for disqualification rejections. Insufficient credential. Clause IIE of this NIT is not complied. So in their cases, they are obliged. Next time, second time, having the same problem. I should say suppression. I am disqualified. What's the reason behind of it? Maybe I'm an ugly looking man, but you cannot deny my papers. You cannot deny my conduct. What is this? Even if you do not like to see my face, you must look to my papers. And now for the first time, they are bringing income tax, other things, all things. I've just specifically mentioned in my petitions what is happening in earlier occasion, what is actually happening in income tax, and law very clear that well, different tax have different provisions. If one statutory authority wants to introduce something, he can borrow that particular provision from that other act. But that should be incorporated in the NIT.
Yes.
Then another very interesting. Copy দাও। হড়বড় করতে হবে না, আস্তে আস্তে হড়বড় করলে সবই গুলিয়ে যাবে। এই যে আছে আমার কাছে একটা, ভাই এটা দাও তো। First NIT on the left side. আর একটা দিয়ে দেন। Date kindly see 12 July 25. And got it, my lord. Bid submission date 4th August 25. All annexes are there. I am not saying anything off the record. Then first NIT cancel 12 September 25. Para 18, page 12 of the petitions. Then second call NIT 26 September 25. Then bid submission date 16th October 25. Now the game will start. Now, my lord, in the meantime, my lord course, Justice Rai, DWAT is removed, everything is removed. So there is no bar to participate in the tender. Tender was second bid, my lord, that was on 16th October. No, 29th September. And bid submission date 16th October. And Justice Rai passed the order 9th October, which is very interesting. So that's it. First corrigendum, 13 October, and just say extending bid submission date to 13 November, 3rd November, for administrative reasons. There is no administrative, only to accommodate someone. Then extend again, 3rd November, extending bid submission, 22nd November 25, for administrative reasons.
Yes.
And 12th September, department order is passed. 12 November, sir, 12 November. So that I cannot participate. See their attitude, my lord. Two corrigendum and extended. Why? Administrative reasons. What is administrative reasons? It's total malafide. It's very unfortunate. So,
yes.
At bottom, my lord, on the left side, from 12 July 25 to 12 September, 62 days, they waited. Then from 26 September to 12, 22nd November to 57 days. From 16 October to 22nd November, 37 days, on account of administrative reasons. What is the administrative reason, my dear friend? Only to accommodate that particular persons.
Yes.
কি আছে বলো তো? এটা কি ছিল?
Yes, next.
My lord, page 754. কোন ভলিউম আছে জানো আমাদের? Volume 6. Thin one. This is my
764.
754.
54, 64.
754.
Yes.
Very interesting. On the basis of the order passed by Justice Rai, my department is gone. In spite of that, my lord, kindly see the DWAT contractor list. Here my name is appearing. It's a dangerous thing. Continuously. It's very interesting. Unless there is a mal motive on their part, That was ninth, ninth, that was set aside. So no debarment. And continuously debart contractor, my name is there.
No, this their name, date of the order of the cease.
Equal to
16. When it was published?
13 October onwards. See their malafide attitude. I could have filed a contempt application, but I didn't do so. I don't want to quarrel with them. I am a fair man. I want a fair judgment. 757, 15th October. So predetermined. They have decided that order will remain. 755. Continuously debart contractor list. Abdul Matin. Can you see? It is very shocking. Unless there is a malintention on the part, it is impossible. It's my livelihood. So many persons are dependable on me. I have invested a lot of money. Of course, I cannot oblige any other persons. This is the order of the day. Oh, sorry.
Yes.
Number one thing, since my lord is rising, my lord, kindly see their contact. What I apprehend, they don't care for anything. Matter is sub judice going on. Maybe tomorrow they will publish the financial list. Kindly protect me for the time being. Please stay your hand, because matter is sub judice. I'll take hardly 20 minutes to 25 minutes. So at 2 p.m. probably my lord has fixed that. Please.
Yes.
Milord, your lordship may take it up tomorrow, Milord, subject to your lordship's business permitting.
Tomorrow already fixed है ना, matter fix है कल. कल fix matters है.
And at their instance, matter is fixed. So I may be protected, my lord. No financial bid should be open till that date. Mr. Advocate General appearing asking for time, naturally. I may lose, I may win. But how is it? Only to frustrate.
But kindly do not pass any interim order, rightly or wrongly. He is suffering a debarment order. If he succeeds, everything will be put back.
How can it be? Third party interest will kill. What is talking about?
But now the court is taking up Mr. Datto, let not to pass any order for the time being. I am not passing.
Very well. Milord, I'll ensure that, Milord, till your lordship
Yes,
hears it, Milord.
I am not recording. Please make sure that
Very well.
I am fixing
Very well.
tomorrow.
Very well. Very well.
I am fixing tomorrow.
Very well.
Tomorrow 2 p.m. खाली है.
No, backdate. They should not put any backdate there. I apprehend everything. Because I've got a bitter experience in open court. Advocate General assured they didn't care.
Learned counsel for the petitioner had argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow at 2 p.m.
Very well.
I'm grateful, my lord.
I'm grateful, Milord.
So, my lord, tomorrow, will you lodge it?
2 p.m.
2 p.m. Sorry to disturb you.
So since we'll reply tomorrow itself, Mulad,
Yes.
if Mr. Banerjee wishes to rely on any judgment, if it is given to us in advance, apart from Ramanna Dayaram Shetty, which he's leading to, so if it can be given, we can deal with it.
If any judgment, please tell.
If I find it, then give
because otherwise they will take tomorrow. Then Saturday.
Since they are in a hurry of,
I'm not in a hurry. You are in a hurry.
I am not in any hurry. You have failed to mention the matter. You have failed to.
Your contact shows you are very hurry to oblige someone.
When the matter did not appear on Friday, you did not mention it also.
Thank you.
Grateful, Mulad.
Your Lordship, may I make a mention?
Number 14, my lord, I am for the petitioner, led by Mr. Bhattacharya and Mr. Banerjee both. This is the affidavit of service. Well, the issue is very short in this petition. The petitioner.
Use microphone.
My lord, the petitioner before your lordship, my lord, is has been aggrieved by non-disclosure of the LOCs to the present petitioner. My lord, in this writ petition, we only sought directions to enable us to understand whether any LOC has at all been issued by any of the authorities in connection with the ECIR pending against us or not. If at all, my lord, the details thereof to be provided to the writ petitioner. That's all, my lord. That is all.
Yes.
But I appear for the respondents. Well, this is the instruction I have received from the order FRRO.
Right.
Now, if your lordship will not kindly see, my lord, that there are 3 LOCs open against the above mentioned subject at the behest of originating agencies. First of all, my lord, Director of Enforcement, MD and CEO, Bank of Baroda, Mumbai, and Joint Director, Ministry of Corporate Affairs. So, my lord, they are the my lord, originating agencies. My lord, we just acted on the basis of their request.
But my lord, subject to correction, my lord, this information that has been passed to your lordship, my lord, that does not contain the details as to when the LOCs were actually opened, upon whose request, the investigating agency, when did they request LOCs to be opened. Because, my lord, the procedure is very clear, my lord. They have to be informed by the investigating agency about opening of an LOC on the satisfaction that I had not joined investigation or had not cooperated with the investigation in any manner whatsoever. So, my lord, that not being there, my lord.
Appearing for whom?
I am appearing for the respondents, my lord.
All. So kindly come to the respondent number 1 is the Union.
Number 1 Union of India. Number 2 is Bureau of Immigration.
Yes.
And number 3, my lord, FRRO.
Then you come to the report which you have submitted
Yes,
now.
Yes.
Correct.
Yes.
The second part, it is pertinent to mention here that the Bureau of Immigration, Ministry of Home Affairs is the only custodian. So you disclose what are these details.
Yes, my lord.
My lord, so far as my lord, LOCs are concerned, my lord, we just my lord, implement the LOCs, my lord, issued by the my lord, originating persons.
Correct.
But Bureau of Immigration has nothing to do.
No, but Bureau of Investigation, kindly see.
Yes.
The Bureau of Investigation, Ministry of Home Affairs is
Yeah,
the only
Ministry of-
the custodian and LOCs.
Yes, they are the Bureau of Immigration, my lord, Ministry of Home Affairs, they are the custodian of LOCs.
Correct.
But they originating persons, my lord, issued, my lord, request, we issue LOC.
Correct.
This is the my lord, our function, nothing more, nothing less.
Correct.
Now, my lord, if your lordship wants, my lord, the details.
Yes,
So far-
details. You have to give the details. If they give details, then they will take appropriate
Yes,
steps.
yes, my lord.
Nothing else.
Yes.
And my lord, also, I will just request your lordship to see the last third line of the.
He has no objection to withdrawal of
Yes.
object in the petition.
Yes, yes.
That's why, if
Let them
they give
provide
the
us the details, my lord.
then you take
Yes,
appropriate
my lord.
steps. Then
My lord.
they will come. Yes,
Yes.
we are not
My
concerned.
lord,
Then
my lord.
automatically LOC will be
My
withdrawn.
lord, my lord.
Then you will be
Highly
free
obliged.
for that.
My lord, highly obliged.
The petition has filed the present date application, praying for direction upon the respondent number 2 and 3 for disclosure as regard the current pending lookout circular with the investigating agencies, institutions or authorities upon whose request lookout circulars have been opened, and full stop. Learned Counsel appearing for the respondents has handed over a communication dated 19th November 2025, wherein it is mentioned that there were 3 LOCs opened against the petitioners at the behest of number 1, Directorate of Enforcement, number 2, MD and CEO, Bank of Baroda, Bombay, and number 3, Joint Director, Ministry of Corporate Affairs. In this said letter, it is also mentioned that the Bureau of Immigration, Ministry of Home Affairs is the only custodian of the LOCs who maintains the LOCs and take action against the LOCs subjects at immigration checkposts at the behest of the originating agencies. Full stop. The only prayer of the petition before this court with regard to the details of the LOCs is required to be disclosed by the concerned authorities. Accordingly, who respond number 1, 2,
3. Your Lordship, Director 3.
respond number 3.
FRRO.
So you will disclose
Yes, yes. Direct the response number 3 to disclose all the
number 3 is directed to disclose the total details of the above mentioned 3 LOCs before this court on the next date fix. How much time will take? 2 weeks.
2 weeks.
And let the matter appear on 16th December.
As an
Or your Lordship may
urgent under the same heading if possible.
Yes, under the same heading.
or your Lordship may dispose of the petition by directing the response number 3 or 2.
Think that so that it can be. Otherwise, so if
Otherwise,
not
it
done,
will again we'll have to go in up again.
the affidavit of service is kept in the report.
Malad, the next matter is same, Malad, by two brothers, two different writ petitions by two
Same
brothers.
order.
Malad.
Same order.
The same report has been handed over with
Same
two writ
report.
petition numbers.
Same.
Same order.
Same date.
Malad, only the affidavit of service and the other writ petition.
Yes.
Deeply
next.
obliged, ma'am. Obliged.
I appear for the petitioner, Your Lordship, led by Mr. Shamim Mohammed. May I pray for a short pause over? He is in court number 18, Your Lordship.
Yes. The urgent motion you persons are mentioning when the matter is called, then again you
Yes,
taking
Lordship.
time.
He is on his way, Your Lordship. He is just running from court number 18, Your Lordship.
Paso.
Oblige, Your Lordship.
Next. Give. Upon mentioning, the matter is placed in the list of.
Item 79 I have for petitioner, my lord.
Yes.
Item number 79 I have for petitioner, my lord.
You are petitioner. Yes.
17. No, I'm extremely sorry, my lord. My lord, this matter relates to my lord. I am actually I own a vehicle, my lord. My work is to transport sand from one place to another. Now, my lord, for transporting this kind of sands, my lord, we need to obtain a license from the concerned sand mine, my lord. Now, my lord, for obtaining that license, if and license is obtained for a fixed period of time. If the sand is not delivered within a fixed period of time, the time is mentioned in the license. If the sand is not delivered within a fixed period of time, my lord, then my license can get cancelled and I can be penalized, and my license can be blocked. So, my lord, in future, I cannot transfer the sand from. I cannot continue my business. Now, my lord, generally the licenses are blocked on 3 grounds, my lord. First, if I do not generate a valid challan, license in this case is challan, my lord. I stand corrected, my lord. So, my lord, if I do not have a valid challan under the Mines and Minerals Act, and my lord, if I do not deliver the sand within that fixed period of time which is mentioned in the challan, and if I transfer overweight sand. Now, my lord, may kindly comes to first page number 9 of my writ petition, my lord.
Yes.
My lord will see this is my smart card. My lord will see kindly page number 10. My vehicle number is written as registration number WB19M 1382. Page number 10.
19M 1382.
1382. My lord, this is my vehicle number.
Correct.
And my lord will kindly see the owner name, that is Rejaul Mondol. He is a petitioner before a lordship, my lord. In the same page, my lord, page number 10.
What is your name?
Rejaul Mondol.
Rejaul Mondol.
And he is a petitioner before lordship, my lord.
Correct.
Now, my lord, kindly comes to the next page, my lord. That is the challan. Now, my lord will see the challan. It was issued on, my lord, this is a online challan, my lord. It was issued on 11/9/2025 at 8:48 p.m. And my lord, it was valid till 12/9/2025 at 8:48 p.m. 12 hours validity, my lord. And my lord, may kindly see the capacity in the second column, my lord. The capacity second column last part.
750.
No, my lord. In kg, my lord. That is cliff, my lord. My lord, may kindly comes down in the second column vehicle destination details, under the column vehicle destination details.
Yes.
My lord, may kindly see the last line capacity. 47,500 kgs. So, my lord, on these three grounds are basically, my lord, the licenses are being cancelled. Now, my lord, I had a valid challan. Now, my lord, there is no reporting of, still date, there is no reporting of me transferring the sand belatedly. And my lord, kindly comes to the next page before moving out.
This is the road e-challan.
My lord, this is the e-challan, my lord.
E-challan.
This is the e-challan.
Correct.
And my lord, next page, if next page, if my lord kindly comes, page number 12, my sand was weighed, and my lord, the weight, my lord, will see 46,400 kg.
Correct.
So, my lord, I was within that threshold limit of 47,500. So, my lord, there was no ground of my challan getting cancelled or my challan getting blocked. Now, my lord, kindly see page number 13.
Yes.
I find when the next day when I go to generate my challan, I find my challan was blocked. My lord, may kindly comes the last line. This is an online printout. E-challan cannot be generated against vehicle number so and so. Case initiated against vehicle number by checking officer. The vehicle owner may be advised to contact the office of the DLLR or Purva Bardhaman.
Correct.
Now, my lord, I do not know why the case has been initiated. There are no ground of an initiation of a case against me. That is my cause of action before your lordship. Because, my lord, I had a valid challan. I was carrying the sand within the threshold limit, and my lord, I delivered the sand within that reasonable point of time, my lord. Now, my lord, this writ petition came up before the coordinate bench by obtaining leave, and my lord, may kindly seize the order dated 26 September. ডিফল্ট করে দিচ্ছিল।
Yes.
My lord, Justice Sinha had given me liberty to approach before the jurisdiction DLLR. Now, my lord, on the next day, my lord, in the vacation bench also, I said that I had approached. They denied, no, they have no, they didn't approach. So, my lord, the Honorable Justice Pal was, Dattapal was pleased to transfer it before the regular bench. Now, my lord, how I will prove that I had gone to the DL and LRO Purva Bardhaman. For that reason, my lord, I mailed to the concerned DLLR that my client had visited you. You have not intimated me the reasons of blocking of my vehicle. Kindly intimate me. Still date, no reply has been received, my lord. That is my case before your lordship, my lord. And my lord, this is my fundamental right, my lord. My right to life and livelihood is being hampered in this manner. Till date, I do not have a notice of what.
So where is your vehicle now?
My vehicle is with me, my lord. I cannot load the sand, my lord.
Correct. Where is your bike? Vehicle is with
Vehicle
you.
is with me, my lord.
Correct.
So
Challan is blocked.
So challan is blocked. The vehicle is lying. I'm having to count my EMI charges. I'm having to count my EMI. I'm having to count all the maintenance charges and all. And my vehicle is lying from 26 September.
Where is service?
My affidavit service was given, and my lord, they appeared also in this matter. 2 times they have appeared, my lord.
No service is there.
No, there was a service earlier, my lord. 2 times they have appeared, my lord.
Yes. So, what do you want now?
I want, my lord, that my challan may be unblocked. My challan may be unblocked. I may be allowed to carry the sand, my lord.
So, after when you file the application requested before the PLRO?
My lord, I have 14th October 2025. I have given the email, my lord. 14th October 2025, my lord, I have given the email, my lord. I have given a copy. Till date, there is no reply from the DLLR. My lord, Justice Sinha directed me to approach with the DLLR. So, my lord, I have given a mail to the DLLR. And my lord, there is apparently no ground to block my challan. I had a valid e-challan. My capacity of loading, my lord, these are all government documents, my lord.
The petitioner is the registered owner. of 16-wheel vehicle having registration number WB19M1382, having the capacity of 47,500 kg. The concerned authorities have issued the challan for sand river bed material transportation of challan for transportation of sand river bed materials to the petitioner on by challan number 1109/26/110920254915 PS on 11 September 2025 at 8:48 p.m. 0848 p.m. and the validity of the said challan is on 12 September 2025 at 0848 a.m. 48 a.m. Full stop. The petitioner has disclosed the document which shows that the what is the date of this waiving slip?
My lord,
What is the date of this waiving slip?
waiving slip, my lord, the computer slip, my lord.
Yes, 12 number. Page
My lord, 13/9/2025. My lord, will find at the last corner, my lord. It is a computer printout, my lord.
11 September. Date of 11 September.
11 September is, my lord, the challan date, my lord.
No, no, this is also, where is that?
Oh, waiting slip, yes, my lord, 11 September.
12. That is
11 September at 8:42. My lord, it has to be wait earlier, then it has to, the challan gets generated.
Where is that?
My lord, here, my lord, in this portion, my lord. 11 September, 8:42.
8:42, yes.
8:40.
क्या बोला? Document that is the waiving slip of the vehicle along with the sand and as per the said document the vehicle was waived on 11 September 2025 at 20:42 hours and the weight of the gross weight of the said vehicle was 46,400. 46,000. The petitioner submit that all of a sudden the petitioner came to know that the petitioner also disclosed the document wherein it reveals that DLNLRO Purba Bardhaman has blocked the challan of the petitioner. He submit that the respondents have blocked the challan of the petitioner without giving any opportunity of hearing and without any notice to the petitioner. He further submitted the petitioner has no knowledge and for what reason the challan has been blocked. By an order dated 26th of September 2025, this court has given a liberty to the petitioner to approach the district land and land reform officer with regard to officer to ascertain with regard to the blockage of the e-challan of the petitioner and accordingly on 14th October 2020.
For this status, so kindly excuse me, I was engaged in another court.
Yes. What is the reason?
Well, decision, my lord, similar circumstances, my lord, similar order, another order passed by this honorable court, thereby, my lord, revert back the matter to the authority concerned for decision. Until that period, that, my lord, that impugned order was stated. I have that decision, my lord.
By this court?
No, my lord, this honorable court, Justice
Om Narayan.
I think, my lord, it will support the case of the petitioner because it requests for decision of the competent authority.
According the petitioner has approached
approach the, to whom you approached?
DLLRO Purbo Bardhaman, my lord.
LRO. But in spite of the receipt of the request made by the petitioner, no communication has been made to the petitioner. Police. Submitted till date, the petitioner has no knowledge under what circumstances the challan of the vehicle of the petitioner has been brought. E-challan has been brought. Police. Then at counsel for the state has handed over an unreported judgment passed by this court in the case of Zahir Ahmed Khan alias Zohir Khan and another versus State of West Bengal, passed in WPA number 8917 of 2025, dated 12 September 2025, and submit that if the similar order is passed, the authority will take appropriate steps in accordance. Considering the above, this court find that the respondent order have blocked each other. Without giving any opportunity of hearing to the petitioner and without passing any reason order. Accordingly, the writ petition is disposed of by directing the DLLRO. Who is the respondent number?
DLLRO, my lord.
Respondent number?
My lord, respondent number 3, my lord.
Respondent number 3.
Respondent number 3.
Respondent number 3. 2. To consider the case of the petitioner within a period of 2 working weeks.
3 weeks.
From the date of communication of this order. The period of 2 working weeks.
3 weeks.
Within the period of 2 working weeks, the additional district judge and district land reform officer Purba Madhyavan shall afford an opportunity of hearing to the petitioner and to pass a reasoned and speaking order strictly in accordance with law after considering the contention of the petitioner. It is clarified that if the additional district magistrate and the district LR and LR Purba Madhyavan is not satisfied with the writ petitioner's submission, the authorities are free to continue the blocking of e-challan facilities in respect of the petitioner's vehicle or to impose fine upon the petitioner as may be permissible in law. In the meantime, till the disposal of till passing of the order by the respondent number 3, the e-challan may be unblocked. E-challan with respect of the vehicle of the petitioner be unblocked. WPA number 77 is disposed.
Only one thing, my lord. In the event they do not give a decision within 2 weeks, my block may be lifted then at that point.
I recorded e-block will be lifted within 2 weeks. He will find that there is an evaluation. He will take appropriate.
My lord. Because, my lord, in the Justice Rai's order, I do not find that in Justice Rai's order, most humbly, my lord, I do not find that, my lord, the block is lifted, my lord. So, my lord, I was beseeching your lord.
I was thinking why you're not having that order. That is a good.
No, my lord, actually, I have our order.
Yes, next. No, follow me. Disposed of, huh? Writ petition disposed.
My lord, for the respondent number 9, my lord, I lead by Mr. Uday Shankar Chattopadhyay. I'm praying for 2 days accommodation, my lord.
No, last time also you have taken time, ma'am.
Yes, my lord, but he is on his legs at courtroom number 8, my lord. and
But
I'm
tomorrow is
praying
okay.
for
So Mr. Chatterjee told me he has a personal problem gone out of the court. So tomorrow can you fix it? Then no problem.
Not
There
today.
is a fixed matter.
Not today.
Great, my lord.
Next.
Nineteen and 20, I appear for the bank.
May it please your lordship, Lord. If the bank doesn't have any objection, I won't open the case. Milord, my grievance before your lordship, Lord, is that my current bank account has been debit freezed. And there is an amount of rupees, Milord, 98 lakh, which is lying there. Brief facts, Milord, quite interesting. Your lordship is aware that in several places we use small POS machines, the card swiping machines. Now, Milord, the petitioner before your lordship is running a diagnostic center. For that, Milord, the petitioner has opened a current account with Bank of Baroda. And these card swiping machines, Milord, are controlled by Bob Financial Solutions Limited, which is a wholly owned subsidiary of Bank of Baroda. So these card machines are, Milord, operated by Bank of Baroda. Bank of Baroda's wholly owned subsidiary, Bob Card in short. Now, whenever, Milord, any customer goes to this diagnostic center and swaps credit cards, the amount of money which is, Milord, being transacted goes through this particular machine into the account initially of Bob Cards. At the end of the day, assimilating the amounts which has fallen in, Bob Cards, Milord, will charge their rate, MDR rate. And on that very day, after settlement, will send the money to the current account of my client maintained with Bank of Baroda. So in this entire scheme, Milord, Bank of Baroda actually has no role to play because it is Bob Card who is going to receive the money, Bob Card who is going to take the transactional benefit of it, the percentage, and Bob Card is going to transmit the money to the current account which I have maintained with the respondent bank, Bank of Baroda.
What is the legal authority of the Bob Card?
Milord, Bob Card is Milord, a wholly owned subsidiary of Bank of Baroda Limited.
That's right.
And I have no grievance against Bob Card because Bob Card has already remitted 98 lakh, which he has received on.
Because you are telling that you have no grievance.
I have absolutely no grievance.
So, and Bob Card has done this. And
Bob Card, what Bob Card has done, Bob Card has received the money on 30th of April 2025. As Bob Card was receiving from January 2025. Bob Card has sent the money to my current account, but unfortunately Bank of Baroda, Milord, is holding on to this money despite repeated requests. Yes. Now, Milord, may I kindly take your lordship through the first grievance I raised? Because the transaction and these are daily transactions, Milord, happening in the...
Any case initiated?
No.
Any tax authorities?
No, nothing of that sort. That is my humble submission.
If my learned friend has finished, my lord.
No, I have not finished. I have not even taken my lord through the documents. My lord will kindly come to my first representation. And before that, my lord, may I kindly show your lordship one clause from the agreement which I have with Bank of Baroda, just to clarify what the situation is. Kindly takes up, my lord, page 24, which is the part of the agreement. Your lordship, my lord, will find Roman 2.
Yes.
Apart from rendering banking services, the Bank of Baroda is engaged in the business of credit card issuance through its wholly owned subsidiary, Bob Financial Solutions Limited, formerly known as Bob Cards Limited, and also a merchant acquiring installations of point of sale POS machines. These are the card swiping machines, and provides services for operations, transactions, processing systems, and settlement services solutions for credit card and point of sales on behalf of Bank of Baroda and or other banks or financial institutions and transaction settlement systems, solutions and related activities on its own or in association or collaboration with other organizations both in India or international.
So your lordship, my lord, will find from this that Bank of Baroda has given this responsibility for operating the POS machines wholly to Bob cards. Now, my lord, on 30th of April 2025, there is a transaction of amount 99 lakh in this card machine, and Bob card is supposed to receive it. I have shown your lordship the terms, but I do not, my lord, get this amount credited in my current account, which I am supposed to get on the very next day, as is happening from 1st January till 30th April, because Bank of Baroda has always done this, or Bob card has always credited it to my account immediately. But
So anybody will pay the amount through the swipe cards, so it will go to the Bob card.
Yes, this is exactly what happened. I also didn't know about it.
And it will return to the
credit. Yes,
credit, your
yes,
credit
ma'am.
account.
So even if
may I clarify this? There is a subsidiary in this entire system, that is National Payments Corporation of India. My lord, whenever a transaction happens, the entire amount goes and is stored in the server or the intermediary system of National Payments Corporation of India. They check each and every transaction, whether it is spurious, whether it is legal, whom it is being debited from and where it is being sent. Depending on the nature of the account from where it is debited from and to where it is credited, then it is sent to the Bob cards account. And thereafter, it is ultimately remitted back to the account who is the actual holder of the POS machine. And this is the system. And if my learned friend continues.
Yes, my lord. So, and these things happen, my lord, actually in lightning speed. Because the ultimate, my lord, the person who is rendering the services actually gets this money quite instantly.
What is the problem in this?
Yes, my lord, the problem.
Let's
Yes.
what is the problem?
There are two aspects to this. Well, first, there is an aspect of claim by the bank against the concerned bank concerned person, which is a violation of this MDR. There is a due, as I have been instructed. There is a due of around.
So you do one thing, you file the report.
Yes, another thing. Why? This is not the reason of debit freezing. The reason of debit freezing is otherwise.
What is the reason?
Yes,
The court
the reason of debit freezing is an instruction from NPCI, National Payments Corporation of India. They have said and instructed us that there has been a transaction of 240 crores within the financial year of 2024-25, which is not usual as far as his banking transactions are concerned. And there are transactions which exceeds 10,000 every now and then. And this is the reason NPCI has instructed us to put their account on hold to go through and check all the transactions through that financial year. Unless the NPCI gives us a clearance, we cannot allow them to operate. He has already made NPCI a party in this, as I find from the writ petition. Probably with regard to that, directing us to debit freeze or unfreeze, that has to be answered by NPCI.
Who is appearing for the NPCI?
I am not.
Well, first question arises that what my learned friend has informed your lordship should also have been informed to us. That has not happened. My lord will kindly come to that, but my first representation, then I'll take.
Whatever, now the NPCI.
NPCI has been served, my lord. And if NPCI has received the entire writ petition, now if NPCI would have had to, my lord, say anything which my learned senior colleague on instruction says, then they would have come up before your lordship and said it.
Standing counsel is there, NPCI.
My lord, I am not aware because too many matters are not filed against NPCI. I actually was of the view NPCI may not be state, but then I found out, my lord, that NPCI is actually a wholly funded by the central government under the supervision of RBI.
Okay, you do one thing. You file your report,
my lord,
and I am directing you. Again, you send in notice to the not notice, directing the informing the next date.
Yes, my lord.
And I will say that if on that day nobody will come, the appropriate order will be passed.
Certainly.
And you file the report.
In the meantime, I expect that my learned senior colleague will impress upon the bank not to take any coercive step against my.
There is no proceeding present.
No, my lord, I say this because in the next matter, which is almost having similar facts, coercive step, my lord, my learned friend has, my lord, very fairly said there is no mechanism under the contract which enables bank to, my lord, have a lien over my account, but they have unfortunately done it. So Lordship will kindly indicate that no coercive steps will be taken, and I will, my lord, serve NPCI once again. This is my apprehension, my lord.
The petitioner has
Ministry
filed
of Law and
an
Justice
application paying for a direction upon the respondent number 1 to unfreeze the current bank account of the petitioner, being account number 0628025 times 01092. The learned counsel appearing for the respondent number 1 bank submits that the bank has freezed the account of the petitioner on instruction of the respondent number 2, that is the National Payment Corporation of India. Though the petitioner has served the notice, but none appears on behalf of the respondent number 2. Full stop. Considering the above, this court finds that considering the above, the respondent number 1 is directed to file report by serving the copy to the learned counsel for the petitioner within 1 week.
2 weeks.
Within 2 weeks.
Milord, kindly make it 1 week, Milord. This is
Within 10
Milord, 98 lakh, Milord.
Within 10 days, the petitioner is liberty to take exception to the report, if any. Full stop. The petition is also directed to inform the next date of hearing to National Payment Corporation of India, and the National Payment Corporation of India is also directed to file report by the next date fixed after serving the copy to the petitioner. It is made clear that on the date fixed, if the National Payments Corporation of India, that is the respondent number 2, failed to appear before this court and to file report, the matter will be proceeded in the absence of the respondent number 2. This is the matter on 15th of December.
Lordship will kindly consider, Milord, for an ad interim prayer C, so that no, the next matter, Milord, they have taken this step.
Okay, let
That's
if
unfortunate.
it taken, you come.
Let us be believe that nothing is going to happen.
Yes, next.
Milord, in the next matter, similar order can be passed, Milord. I'm in a more difficult situation in the next matter because other than the money which is already there in the account, lien has been, Milord, charged over the account. So, Milord, nothing is going to, heavens are not going to fall apart, Milord, of course, in the next 10 days' time. But we can, Milord, come back.
Probably it will anyhow to the benefit of the bank if my lord grants leave to him to add Union of India as a party, because NPCI probably would not be independently represented unless Union of India is added as a party respondent, and through Union of India, Ministry of Law and Justice, he serves NPCI.
Milord, this is indeed a very holy advice, but NPCI is an entity by itself.
Let the submit report that we are not.
We have served. They have received the. They have received the writ petition.
The same order.
Similar order can be passed, Milord, in the next.
Only the
account number will change.
Account number লেখা নেই বলে।
The writ petition and prayer টাতে লেখা ছিল বলে।
Order এ account number লেখা নেই।
Next.
The account number, if it is mentioned,
yes, it is there.
Milord, with respect to the next matter, we had prepared a supplementary affidavit. Maybe kindly, Milord. The matter, Milord, there are two matters. The second matter.
20.
Yes, item number 20.
Keep it. Let.
No, I want to serve it, and your Lordship will kindly record, Milord. These are state involved.
Supplementary affidavit.
Oh, sir. We have served, Milord, and first time coming up. So, Milord, facts are already intact.
Yes,
I'm
next.
Deeply obliged.
My item number 1, my lord, I am appearing for the Union of India.
I
am appearing on behalf of the petitioner. My lord, the petitioner is a retired person. My lord, the petitioner also is a pension. He has a pension account which has been reflecting from the annexure P1, my lord, with the respondent bank, my lord. I was a government servant. I was retired, and thereafter this pension account, my lord, was active, my lord. But all of a sudden, kindly come to annexure P223, my lord. Page. This minus balance has been shown, and the next page, a message has been received by the petitioner to his mobile number that dear customer, hold has been placed on your account such and such for rupees such and such. This is the only information I could gather, that my pension account has been blocked or freezed by the respondent bank. Now, my lord, what I could find, the petitioner's wife is also a, my lord, government employee, my lord. She took a loan from the, my lord, respondent bank, which is the application or the, my lord, loan sanction letter is appearing at page 25p3, my lord. Now, kindly come to page 26. Guarantor not applicable.
Page 26.
My lord. 26 bottom.
Yes. Processing credit, cancelability, miscellaneous.
My lord. Guarantor not applicable. I was not the guarantor.
Where it is mentioned?
But page 26 bottom.
Page 26. Which
Bottom.
paragraph?
Bottom, my lord. Page 25 starts with the
Cancelability.
The loan facility issued to the
25 is the letter of the SBI.
Yes. 26.
26 is the clause 6. It starts
Clause
from
6, 7, 8.
8.
Yours faithfully, branch manager, received the original terms and condition accepted. Date, Moshuminak borrower. Guarantor not applicable.
That is not here.
My lord. At the bottom left, my lord, signature column is there, my lord.
Signature. There is nothing. There is a blank.
My lord, my lord, my lord, this is.
Not applicable,
Guarantor not applicable. This loan was exclusively, my lord, issued to the to my wife in her personal capacity, my lord. Page 25 has reflected such fact. Advances, personal loan, scheme, express credit, facility, term loan, my lord. My lord, my wife got my lord, injured due to some accidental issue, my lord, for which she could not able to pay such the EMI of such loan, my lord. And all the notices was, I have also annexed the, my lord, her medical papers. My lord, all the notices was addressed to my wife towards the default of such loan. My lord, what the bank has done, bank has freezed or blocked my account in default of the payment made by the my wife, my lord. This is the whole issue. I have made the representation, which is appearing from page, my lord, 31, but no, my lord, address, no reply has been given to me. And the petitioner, my lord, is a position, since his pension account, his only account is the pension account, that has been blocked.
What the wife is doing?
My lord, wife is also a government employee, my lord. Wife is also a government employee, and she took the loan on her, my lord.
What was the total amount of the loan?
My lord, the page 25, my lord. 38,800.
13,80,000.
My lord, my lord. So
you have not paid any amount.
My lord, since actually, actually she is hospitalized, she could not able to join the service, and that is why the amount salary has not been credited. So that is why the, my lord, she could not able to pay off the EMIs.
When she met with an accident.
My lord, I have. Page 35 onwards, I have annexed the, my lord, the condition of the fracture of my wife, my lord.
When she met with an accident, that is December 12, 24.
My lord.
December 24.
My lord.
And you obtained loan in 2022. What has done from 2022 to 2024?
No, that is only in respect of my wife, my lord. In such procedure, neither I am the party nor I am the guarantor, and my pension
Yes,
account, my
but-
lord, cannot be blocked in
Yes,
this
but
fashion. My
what is your instruction?
Problem lies somewhere else, my lord. The account in question is a joint account. My lord, this is the account statement of the account. It's maintained by, my lord, the petitioner Taposh Kumar Nag, my lord, sis, and Moushumi Nag. Now, the account of Moushumi Nag, the wife of the petitioner, it turned NPA on 1st July 2025. Her account of one account is NPA, my lord knows. All accounts are NPA. So she being the joint account holder, this account has also become NPA. And that has been informed to the petitioner. My lord, kindly see at page 24 of the writ petition.
Yes, I have annexed.
Yes, annexed. Kindly see, my lord.
Hold.
24. Through what? Through message. He was
Hold.
24. Hold for rupees for the
13 lakh.
NPA.
13 lakh 50,000.
13 lakh 15,000.
Yes.
Yes. Kindly see the extent circular of the RBI. My lord.
Yes, you are the joint account holder, so.
My lord.
My lord, kindly see.
So how it can be segregated? It is a joint account.
The last page of the circular. Page, para 2.2.
Which clause?
2.2.2.
2.2.2.
Last page.
Page 5.
Yes.
Is in respect, my lord, first clause 1, my lord, Roman 1. In respect of a borrower having more than one facility with the bank, all facilities granted by the bank will have to be treated as NPA and not the particular facility or part thereof which has become illegal. Might be the account of the wife has become irregular. Other account where she is a holder or joint holder, co-holder, that will also start illegal. According to the circular.
My lord, subject to your lordship's kind sanction, my lord, the wife has his own salary account, and since this is the submission made by the learned senior friend, that since this is the joint account holder with the petitioner, because my lord, kindly see the annexure P119, regular savings bank account pensioner, my lord. So what I request your lordship, my lord, because I am in a position to hand to mouth condition, my lord, because I could not be able to, my lord, purchase my medicine also. Because entire
government servant, the medical claim is not granted.
My lord, how the entire amount is lying, the pension coming, my lord, credited to this account, my lord, it is entirely blocked, my lord. So, my lord,
You are the government servant.
my lord,
You are the government servant. You met with an accident.
my lord, other expenses are there. Well, kindly appreciate a portion of the pension may be released, my lord, because they have. My lord,
I am not on that.
My lord, they have.
Saying that your petitioner is not having any source of income and not getting any amount.
No, except this pension amount.
This is the pension with regard to your wife. Your wife.
No, my lord, this is in regards to me.
But it's a joint. It is a joint
The
account.
pension account is joint, and she has another account that has been NPA and in pursuant to the
master circular.
And in my lord,
you do one thing, you file the report.
My lord,
so
my
the
lord.
copy you will take
My lord.
exception to that. Then the matter is to be decided on merit only.
My lord, in the meantime, a portion may be, my lord, kindly. A small portion may be directed to be defreezed, my lord. At least, my lord, kindly 1 minute. A minimum amount.
The authority of the bank can be taken by the court.
My lord, a
maximum
amount may be, my lord, directed to be defreezed so that I can.
You go to the bank and settle the issue as a one-time scheme. Let the bank give one scheme to you, and it can be settled. You go to the bank and approach the bank.
My lord, the Honorable Supreme Court has specifically stated, my lord, the pension, my lord, account has to be, my lord.
Why you kept the joint account, pension account?
Well, kindly ask them to defreeze my lord, kindly a portion, my lord.
The petitioner is being aggrieved with the action of the bank that the bank has hold an amount of rupees 13,50,000 from the account of the petitioner. The petitioner submitted the petitioner is a pensioner and the amount which has been freezed by the bank is the pension account of the petitioner. We further submit that the wife of the petitioner has obtained personal loan of rupees 13,80,800, but subsequent to 800, but due to the accident, the wife of the petitioner could not able to pay the loan amount. Accordingly, the bank has freezed the accounts of the petitioner. Though the petitioner is a pensioner, the bank cannot
Report to be filed. Report
freeze
to be filed.
the pension account of the petitioner. Learned counsel appearing for the bank has brought the attention of this court, submits that the account which has been freezed is the joint account of the petitioner as well as the wife of the petitioner. He has also drawn the attention of this court to clause 2.2.2 of the Master Circular dated 1st July 2011, wherein it is mentioned that in respect of a borrower having more than one facilities with the bank, all the facilities granted by the bank will have to be treated as NPA and not a particular facility or part thereof which has become irrevocable. Full stop. Considering the above, this court finds that the bank is required to file report by way of an affidavit. Let the report be filed by way of an affidavit within a period of 1 week. Within a period of report, why not? Within 10 days. Within a period of 2 weeks. A reply, if any, that will filed within a week thereafter. Please the matter on 17th December.
17th December.
December.
17th December. 17th December. 2 weeks.
Next.
My lord, I am for the petition. My lord, this matter is relating to one, my lord, the motorcycle garage under the Barasat railway station under Southeastern Railway Division, my lord. My lord, this petitioner, my lord, got the tender in the year 2018 for temporary period, my lord. Petitioner got the tender of motorcycle parking garage.
Parking garage?
Parking garage, my lord.
Or the parking place?
No. Parking. For parking motorcycle garage, my lord. Commuters are coming, parking their motorbike, and my lord.
So how it is garage? It is a parking place.
Parking place, my lord.
How it is a garage?
My lord, it is mentioned in the notice. That's why. My lord, now what happened, my lord?
File kata hai? Yes.
2020, my lord, 10th January 2020, my lord, an agreement was entered into with this petitioner and the, my lord, the respondent railway. For 3 years, my lord, petition was granted, my lord. It is very unfortunate for the petitioner, my lord, kindly come at page number 15. This 15? Is 15, 1-5, and it's P3, my lord. It is very unfortunate for the petitioner, my lord, as soon as he got this, my lord, tender due to nationwide, my lord, pandemic, my lord knows, my lord, this, my lord, he could not, my lord, do all these things, my lord. And my lord, what happened, my lord? Subject to the terms and conditions, this petitioner erected structures and the other things, my lord, infrastructure, my lord. Now what happened, my lord? Due to this agreement, my lord, as per this agreement, the terms expired in the year 2023. Thereafter, my lord, no tender, nothing was there, my lord.
So you are continuing with this?
Continuing. I am till, my lord. And my lord, I approached to the respondent authority, either till the tender process is, my lord, retender, my lord, I may be permitted, my lord. This is my honor. I have made this representation before
when your tender was over?
My lord, 2023. This is at page number, my lord, page number 18. 18. Validity of the license.
Yes, validity of the license.
License, my lord. My lord, thereafter, my lord.
Commencing from 19 to 2022.
2022. And this
yes.
My lord. My lord, then, my lord, thereafter, the petitioner again and again made the representation before the respondent authority.
Still you are
I am in possession, my lord. I am doing this business and making the payment.
To whom?
The railway authority, my lord. The respondent number, my lord, 3. But there is no dispute, my lord. But the thing is that, my lord, yesterday, my lord, I got one notice from the, I have been asked to vacate the premises.
Deposit due license fee, occupy charges and other charges. Fixed by so and so, so and so. 2,61,000. तो इतना इतना. Yes.
Malad, I have been in my occupation and I am ready to pay the charges, Malad, till Malad new tender comes, Malad. This is my humble submission and I have made the representation. Page number, Malad, kindly come at page number 27, P7 annexure.
Yes. Yes, what is the contents?
My lord, one thing, a writ petition cannot be treated as a tool for a masquerading person to claim a legal right in respect of an illegal action. What he has done, he has not read the validity of the license clause fully. May I just place that part once, page 18.
Page 18.
Page 18, clause 2, Roman 2. It has to be read in its entirety. May I place it, my lord? Validity of license subject to the terms and conditions contained in this indenture. The license shall for a period up to 3 years, commencing from 14 February 2019 and terminating on 13 February 2022. Further renewable after completion of 3 years with 10% enhancement in the rate of license fee thereafter at the option of the administration. After completion of contractual period, the licensee himself is responsible for peaceful handing over the possession of railway land to railway administration without any delay, failing which railway may take necessary action against the licensee, cost of which will be chargeable to the licensee. What has been done? His license expired in 2022. Thereafter, the license was granted in favor of another enterprise. We cannot part the position in favor of that enterprise because of their illegal occupation. No, their documents are there. Let me come up with those documents.
How soon?
May I just?
How soon you are coming? Why the court is wasting your
My lord, my lord, any day next week. Because what has happened, he is illegally occupying the premises.
Petitioner, the counsel for the respondent submit that after the completion of the tender period of the petitioner, the respondent authorities awarded the tender to some third party, but due to the illegal occupation of the petitioner over the premises, the person in whose favor the tender is awarded is not in a position to utilize the said place. Accordingly, place for time to file affidavit, it proving the documents. Let affidavit in opposition be filed within 1 week. Within 1 week, reply if any thereto be filed within a week thereafter. List the matter on 17th.
My lord, in the meantime, my lord, we have already initiated action under section 147 of the Railways Act.
This court is not passing any order.
No, we have initiated action under the Railways Act and 147. We are empowered to do that. Let that proceeding be continued.
The counsel for the respondent submitted that the railway already initiated action against the petition under section
147 of the Railways Act 1989.
147 of the Railways Act 1949. Yeah, the railway is free to take action.
I am grateful. I am extremely grateful.
Pending disposal of the present rate application.
I am extremely grateful.
My lord, next, my little submission, my lord. No coercive, my lord, since I am no coercive. In the meantime, my lord.
He is illegally occupying a government land.
Yes.
He is illegally occupying a government land.
All the next matter. All the. It's any matter? Which matter?
23.
All the 23.
My lord, item number 23, I appear for the petition. My lord, on the last occasion, your lordship directed the respondent authorities to file a report. My lord, they have filed a report. My lord, I seek 7 days time to file an exception to the report. And
I have
next
no
matter will
objection,
take
but I have no objection, but the difficulty one is let him file the exception after 7 days.
Yes.
But Lord, this is a case of renewal of passport. There are so many criminal cases pending, 8 cases. He mentioned one case, suppress this. We time and again issued notice to him to appear and produce documents. Very well, let him file the exception. But in the meantime, he should visit our office.
Yes, yes, yes. Certainly.
This is the copy of the report.
I will instruct my client to visit there.
Instruction form.
A report by way of instruction filed by the respondent number.
All respondents.
Respondents, be kept with the record. Counsel for the petitioner, prays for time to take file exception to the report. Let the exception be filed by
7 days. Not any
week, within a week. Please the matter on 9th of December.
9th December, 9th.
Under the same heading. No. Yeah, call. Original side.
Your Lordship, we need item number 28, Your Lordship. Item number 28, Your Lordship were gracious enough to fix the matter under the urgent motion, but Your Lordship, since a week the matter has not been taken up. There grave urgency in the matter, Your Lordship.
What is that?
Urgency, Your Lordship, the petitioner before you are poor farmers who are applied for a scheme.
Tomorrow it will be updated.
Your Lordship, kindly fix it.
Yes, tomorrow come, urgent motion will be taken. Today already we have reached 21 matters. So your number is 28.
Yes, Your Lordship.
7 it will come.
Highly objected.
If not, you mention in the morning if it is in the back.
Before, may I have your Lordship's kind indulgence? Well, item 16 of the appellate side was passed over. It is passed over for the day.
Tomorrow. Yes.
Well, may I be permitted to mention a matter? Sorry, I thought it was already. Malad, for urgent listing, Malad, for extension of interim order. Interim order to expire tomorrow, Malad. It was placed before another bench who just said that release because, Malad, it's not falling with the determination. So, Malad, the order has been passed.
Release, so why
not
this
release,
court?
but not release, Malad. I said that, Malad, let it go out of the list. I'll mention before the regular bench, Malad. So, Malad, the last order, Malad. The interim order is still tomorrow, Malad.
Listing?
No, it's not listed, Malad. It's listed
on the other side.
But Mr. Shubhankar Nag is on the other side, Malad. But he opposed.
listing হয়েছিল কি ছিল
Tomorrow to be mentioned.
I will inform him.
You oppose this for no reason.
Yes.
May I have my lord's
My lord, may I have Lordship's kind leave to mention, my lord. Upon notice to my learned friend, my lord, if your Lordship recollects, 18th November, 5 writ petitions heard by the regular bench. Then there was whether it will be heard by your Lordship or whether it will be heard by the bench which had substantially heard the matter. Your Lordship was pleased by the order of 11 November to send it to the Honorable Chief Justice. Now, my lord, the Chief Justice has said it will be heard by the regular bench.
Item number 2 and 3 is the matter. I'm just
So I am mentioning, please follow what I am saying. I am mentioning 3 matters which are not appearing today. I am mentioning those 3 writ petitions. Those are appearing in the list. Why should I mention?
3 matters.
Yes. So any day convenient to your Lordship, my lord.
No, I don't.
Well, I am not saying I just want to bring to your Lordship notice that the Chief Justice has said that the matters will be heard by the regular bench. That's all. Nothing more than that.
May I have my lord's kind leave to mention?
ले लो कनेक्टेड का साथ रख लिस्टिंग कर दो
May
आया डिटर्मिनेशन आया नहीं है आएगा तो कर
May I have my lord's kind leave to mention item 42 of today's appellate side list, your Lordship.
Appellate side?
Your Lordship. The only thing is the interim order is expiring tomorrow. We were hoping that it will reach, but it's your Lordship has fixed it for today. It couldn't be 42, your Lordship. I'm only praying for, I'm mentioning upon notice, I'm praying for extension of interim order.
Till tomorrow, na?
The interim order is there till tomorrow.
Tomorrow isko. No, इसको पास अपीलेट साइड একটা বলে 42 কালকে টু বি মেনশন করে দিন এক্সটেনশন অফ ইন্টারিম 42
last extension. Deeply obliged.
For actually help.
Item number 1.
I appear for the petitioner judgment dated in this matter, my lord. This is my application for recalling.
For this is for correction. This is the suit, not the execution. This is not the execution. This is the civil suit. The matter is
Is
listed
it not Anubandh matter?
as to be mentioned on receipt of the report. Just for correction of the master in charge
I thought
of
my
this court
application is.
dated 24th of that is item number down 24 number 22. It is from the report, it reveals that by an order dated 4th September 2025, this court directed the department to delete the names of the defendant number 2 and 3 from the cost title within a period of 1 week from date, but the order has not been carried out. It is further mentioned in the report that in the judgment dated, in the order dated 4th September 2025, page number 6, paragraph 19, line number 1, the word defendant is to be replaced as plaintiff. Accordingly, the department is directed immediately to correct the immediately to delete the name of the defendant number 2 and 3 from the cost title in compliance of the order dated 4th September 2025, and in paragraph 19, page 6, paragraph 19, line number 1, the instead of the word defendant shall be read as plaintiff. Grateful, Manor. These errors have come up during settling of the decree. Grateful. You also not mention. Manor, yes. This has come up on last Friday when we have. Next. Grateful, Manor.
Lord, Mr. Datta is leading me, Rajushri Datta.
My lord, these matters, my lord, we had
Pardon, my
mentioned
lord?
yesterday for extension of the interim order. The interim order is due to expire on 28, that is tomorrow. And now, my lord, Mr. Bose had also mentioned today, all the matters have now been, my lord, are required to be listed before your lordship's court. That has been clarified by the office of the Honorable Chief Justice. So, my lord, will kindly grant a limited extension and fix any day, my lord. All 5 matters can be tagged together, and my lord, it can be heard out.
Lord, I appear, Lord, for IDBI Bank. Lord, we are suffering an interim order, Lord, and as your lordship recalls, Lord, we had submitted that the hearing had been concluded, Lord. Lord, the hearing now has to start. Then, Lord, since we are suffering, Lord, if your lordship could not fix an early date, Lord, for hearing of the matters.
Counsel for the plaintiff.
Petitioner.
Petitioner.
Press for extension of press for extension of the interim order. Counsel for the defendant submit that due to the interim order passed by this court, the bank is facing difficulties, and accordingly, press for fixing the matter early hearing. In view of the above, कब देगा? कोई तो डेट नहीं है, जनवरी में जाएगा.
They have not preferred any appeal also, so it can, my lord, come back in January.
My lord, if not waiting for a matter to be heard by the court, Lord, if that's a crime, Lord, we have committed that. I agree with my lord.
So then all of us are facing the same difficulty.
Yes.
18, 19, 18th and 19th December.
Very good.
At 3 p.m.
At 3 p.m. Very grateful.
The interim order is extended till 23rd December 2025 or until further order, whichever is early.
Very grateful.
My lord, may I pray only for one indulgence? My lord, 18th is okay. 19th, I will be in some personal difficulty. Can it be either 17th or 22nd, the other date?
17th or
22nd.
22nd.
17th खाली है? नहीं. 22nd, 23rd. 22nd.
But then again, it will close and reply will not come. They will again
Booked.
change the stand.
Well, let it remain, my lord, so that we can complete, then we'll see if they.
Okay, let it remain, we'll see.
Because I am addressing, my lord,
My
in
lord,
two
it's-
petitions on behalf of the petitioners. Just in case, my lord, I
The
am
other
not there, my-
petition, let the other
Very
petition
well.
continue, we'll see to
Mr.
that, your
Bose is
junior
there,
will take.
In the other petition.
Mr. Mukherjee is there, Mr. Bose is there, not
Mr.
appear.
Mukherjee is
No,
there, Mr. Bose is
my
there.
lord, independently, I have two petitions.
Okay, no
Possibly-
problem, your case will be taken subsequent date.
Very, very.
Deeply.
Yes.
We appear for the respondent, railway authority.
My lord, this is my writ petition.
Yes.
My lord, I have instructions to withdraw this. May I just place the, my lord, instruction to my advocate on record? It's slightly vague in the sense that it doesn't mention the writ petition number. Oh, sorry, yes, it's there in the subject line. It's there in the subject.
The counsel for the petitioner has handed over a communication dated 3rd November 2025 and submit that he has instruction.
Thank you, sir.
From the submit that he has instruction from the plaintiff to withdraw the present writ application.
Writ petition, my lord.
Present writ petition. Any objection?
No.
Immediately submission made by the counsel for the
He apparently struck a deal with the railways. So
WPA number WPO 360 of 2025 is dismissed as withdrawn. Consequently, all interlocutory application is also dismissed. Interim order, if any, stand vacated.
grateful.
The written instruction be kept in the.
Grateful, my lord.
Next.
I'm appearing for the decree holder.
My lord, this matter is appearing at my instance, my lord. I had
Where is
mentioned
the
it
amount?
yesterday, my lord. Yes, my lord, we have paid the.
Scanning and receipt. Yes, the matter has been received. The amount has been received.
Lordship,
Decree
kindly
is satisfied.
Yes,
Lordship
my
will.
lord, the decree, my lord, and vacate the order as far as Reserve Bank is concerned, my lord,
No,
because
no,
that.
I'm not able to.
No, is only
Yes,
that
yes.
the Reserve Bank India is order is to be recalled.
Yes,
Yes.
Lordship will recalled in the sense since the decree is satisfied, Lordship, all orders passed in the meantime stands vacated, Lordship. That is.
Yeah.
Attachment, Lordship, there was a direction on
28th October.
28th of October. Order, Lordship will kindly consider.
Counsel for the judgment debtor submits that the decretal amount along with the interest.
Yes,
Yes,
Along with the interest has been
as
paid.
indicated in the tabular statement, Lordship, that amount has been received.
For the decretal amount along with the interest as indicated in the tabular statement has been paid by the judgment debtor to the decree holder.
The decree stands
Counsel for the
Lordship,
decree
kindly
holder
record the
also
decree stands satisfied.
submit that he has instruction that the judgment decree holder already received the principal amount along with the interest as in the tabular statement. In view of the above, the and the plaintiff and the decree holder is satisfied with the amount received from the judgment debtor. Accordingly, no further. What do you want? Nothing.
Kindly
is
record the
Well,
order of
there is
28th
nothing.
October.
In fact,
There was an order of attachment on 28th October.
Accordingly, the order dated 28th
Of
October
attachment, that way.
2025 and 17th November 2025 cannot be given effect further.
I'm deployed.
And what the decree may be kindly record satisfaction of the decree, my lord. The decree has been.
Yes, satisfaction of the judgment debtor. Decree holder.
decree holder.
Decree holder.
First time in my life, Lordship, I have noticed 16th April 2025 decree has been satisfied the same year, Lordship. By
You're
the state
lucky
of West
enough.
Bengal.
You're the lucky enough. And what year of the suit? 93, 97?
Yes, Lordship.
It's a-
97. 97. I'm
Yes,
grateful
my
to you, Lordship.
lord, we were satisfied with the decree, but we immediately applied, requested the.
Thank you for satisfied and giving the.
State only opposes when claim is in crores.
No, no.
Lakhs is not inches.
Okay.
I'm grateful.
We oppose inflated claims.
The EC Com 479/2025 is disposed of with the full satisfaction of the decree holder.
Very grateful to you.
I'm grateful.
Okay.
If this matter has come up on my instance, the interim order is expiring on 28th tomorrow, Lordship.
We are suffering interim order, my lord. We are suffering interim order, my lord. We are suffering interim order, my lord.
Lordship,
Can-
Lordship kindly sees the last
Acknowledge it.
order. So we were supposed to file an exception to the report that my learned senior friend has filed. Lordship, it is taking some time because the petitioner number 1 and 3's mother, she is 92 and she is not well. So some instruction we are awaiting for. Lordship, we'll file it shortly. And
How soon you will file?
Sorry.
Otherwise, I am vacating.
No, Lordship, we'll file.
If you are not filing the exception and taking time for extension and taking
No,
the benefit of
Lordship,
the
there is some difficulty.
The counsel for the petitioner prays for extension of the interim order. Police has also prayed for extension of time to file exception to the report filed by the respondent. Time to file exception is extended for a further period of 1 week from date. The interim order is extended till 17th of December 2025 or until further order whichever is earlier. Release the matter on 10th of December 2020.
I am grateful.
Yes, call the matter.
My lord, there is one matter, my lord, for extension of interim order, item 7 is because it's
Item
expired.
number 7, my lord.
To appear for the respondent bank in this matter.
Yes.
And for the petitioner, my
Lord,
lord,
the-
Mr. Rajesh, sir.
Yes, Mr. Datta.
My lord, the interim
Right,
order
my
is, my lord, expiring on 28th of November. Affidavits have been exchanged. I know, my lord, the bank is also possibly suffering the interim order. Any day convenient to the bench, lordship fixes it, my lord, we will have
Affidavits completed?
Yes, my
my
lord,
lord.
they have
Yes,
filed
my
it.
lord.
We have filed it.
Counsel
Only
for the
thing is, your
petitioner
lordship,
prays
this
for
impugned order has been challenged and the appeal is pending.
But
Where?
there is no stay.
Before the division bench, there is no stay.
That's nice.
No, your lordship.
The counsel for the petitioner prays for extension of interim order. It is submitted that the pleadings have been completed and the matter is ready for hearing. In view of the above, let the matter appear on. But I don't think hearing के लिए तो नहीं हो. Let the matter
First week January, my lord, if it is possible.
January. Let the matter appear on 16th December. Interim order is extended till 18th December or until further order.
Very grateful, my lord.
Right.
Next.
Sandeep Sethia.
হ্যাঁ
এখন বলছি তো কারেকশনের সময় I'll suggest that correction. তোমাকে দেখো নি তো suggested correction.
ম্যাডাম
Yes. Today you will complete.
I believe so.
Today there is
No
3:30.
3:30. Mr. Sethia, do you have any idea that the Central Bank of India London branch was closed in the year 2005-2006?
It was not closed in 2005-2006. It was closed on 31st of December 1986.
After the business closure of the London branch, all the assets and liabilities of the London branch
was transferred to the international division of the central bank, and as a result of which the lien which was created by way of Exhibit A by 3 was adjusted on account of the dues of two companies, namely SL Setia Liners and Drum Place Limited. What do you have to say to that?
There are two parts to my answer. The first part is that it is untrue that any assets and liabilities of the London branch were transferred to the international branch, to the international division at Bombay. The bank's witness has himself proved that the account of SL Setia Liners Limited was written off at London on 31st of December 1986. That is Exhibit 7. In Exhibit A26, the minutes of a board meeting are disclosed, dated 28th of March, 1987, reflecting a write-off in the account of SL Setia Liners Limited. If one reads the board resolution closely, one can see that the resolution reflects a write-off as at 31st of December 1986. In other words, the write-off is not taking place in Bombay, but it has already taken place in London. As regards the account of Drum Place Limited, it has already been proved that the bank obtained a winding up order against Drum Place Limited on 21st of October 1985. And the name of Drum Place Limited does not appear in the list of delinquent accounts, delinquent, D-E-L-I, delinquent, of 31st of December 1986. Therefore, it is to be inferred that the account of Drum Place Limited had already been merged with the profit and loss account of the London branch before 31st of December 1986. The second part of, sorry, one more point. It is common knowledge that the operations of the London branch were taken over by the London branch of the Bank of India. Therefore, it is completely false to suggest, as the plaint has done at paragraph 16, 16, that all the assets and liabilities of the London branch were transferred to the international division. As regards the second part of the answer, the bank tried to make an argument that because the accounts had been transferred to India, permission of the RBI became unnecessary. And this was the special leave petition of the bank before the Supreme Court, which the Supreme Court rejected. So it really does not matter whether accounts were or were not transferred to India. Permission of the RBI, and specifically prior permission of the RBI, remain absolute according to the Supreme Court. The plaint completely disregards the judgment of the Supreme Court to file a malicious prosecution.
Which order of the Honorable Supreme Court are you referring to?
I would refer to the dismissal of the SLP, and I would like to refer
Yes,
to the
yes,
SLP.
I'm showing you a first volume take to Devon. PD1, Exhibit A1 corresponding to PD1. PD1, 1. Page 1, first volume.
PD1. Document. After index.
It runs the
Yes.
Are you referring to this order?
Yes, I am.
Now, the answer which you have given, is it evident from this order?
It will be evident when I read from the SLP that is being dismissed.
So,
by this order.
So, do I take it that from this order, nothing is evident, 7 except the dismissal of the 2 SLPs?
It says the special leave petition is accordingly dismissed.
Kindly agree or disagree, and then you can be involved.
I disagree. When it says the special leave petition is accordingly dismissed, it is necessary to refer to, it becomes necessary to refer to the special leave petition, which I would like to do.
Please, what is the question is putting to you? Please give answer to that only. If you going by every case, want to explain all pleadings in the evidence, then it will never be ended.
I appreciate it.
Only give the answer.
Mr. Ghosh, then what will left for him to argue? I can give him a follow-on.
No, I am also thinking I have nothing to write the judgments.
Okay. It is not clear from
Because
the
it's
judge.
a specific question he has put to you whether in terms of this order it is recorded, it is dismissed or not.
The order simply records that the special leave petition is dismissed.
Dismissed. That's all.
I suggested to you that the claim of the bank is not barred under the laws of limitation.
Under the laws of?
Limitation.
That is the point of law. How?
So,
I do not know what the laws of limitation are.
Yes.
Very. आगे जो है एग्रीकल्चर वाला হ্যাঁ হ্যাঁ ওটা A70 ওটা পড়া ছিল গতকাল দেখা না হ্যাঁ Lordship will kindly allow Mr.
kindly come to the letter of lien. The certificate of lien, which is exhibit A by 4.
A by 4. Yes. I didn't say anything. Yes.
When this lien was created by virtue of this certificate, do you find therein any agreement to pay any interest? Do you find therein any agreement to pay interest?
No.
No. Was there, if I put it to you, that since the intention of the of RK agencies was to pay the money in respect of the dues of a foreign account, for that reason, this lien does not carry any interest.
I
Suggestion?
disagree. I disagree.
You want to add?
Just two things. First of all, it was not the intention of RK Agencies Limited to pay the debt of a foreigner. And the second point is that Mr. Khanna asked for interest to be paid on the fixed deposit in his letter of 27th of November, 1984. 27th November, 1984.
So, apart from that demand for interest, there is no agreement in writing between the parties regarding the interest or rate of interest. Interest or the rate of interest. Regarding payment of interest or the rate of interest.
The original agreement was to renew the fixed deposit periodically, but that agreement lapsed. Renew the fixed deposit periodically, as written by Mr. Khanna. But that instruction lapsed when Mr. Khanna made demand for return of the fixed deposit on 28th of May, 1985.
Now, now kindly come to your counterclaim, which is counterclaim to written statement.
Additional written statement. Written statement along with written statement with counterclaim of plaintiff. Sorry, the defendant. By RK agency.
ईमेल क्या चाहिए
Prayer. Page 35.
Page 36.
36.
I'm showing you prayer C of your counterclaim, where you have claimed interest, additional interest of rupees 2,49,07,218. Could you tell my lord what is the basis of this claim?
I explained it in my chief, and I also requested that there was a mistake in the calculation, therefore it may be ignored. And I have some, because it is a part of the overall calculation, so it need not be considered separately. I had attempted to calculate the interest that would have been accrued on the 1,10 lakhs that the bank allegedly appropriated in 2006 and build a claim on that basis, because the bank did not disclose throughout CS 297 of 1987, 297 of 1987, that it had paid any interest on the fixed deposit after the first 6 months. When the bank disclosed that it had accrued 90 lakhs of interest on the fixed deposit in 2006 and adjusted a total figure of 110 lakhs on 8th of August 2017, the date of disclosure, RK agencies decided to file a counterclaim for the interest on its deposit. Earlier, the bank had argued that it had not paid interest and it was not liable to pay interest. And now it was proved that the bank had paid compound interest.
Did you raise such claim of interest in the previous suit that was filed between the parties?
Yes, we filed a cross objection to the order of the single judge, awarding of the learned single judge, awarding simple interest. And the bank, in its appeal, ground 23, wrote that it had been prevented from paying interest by the blocking order of the RBI. And the division bench was deceived to give a decree rejecting the cross objection in terms of ground 23. We filed appeal again before the Supreme Court. We filed an SLP before the Supreme Court. And our matter was tagged to be heard with the primary SLP of the bank. And when I was present in the Supreme Court, when their lordships dismissed the SLP of the bank, the question arose about the secondary SLP. And their lordships confessed that they had not read the secondary SLP. And it was proposed
Not to say all the things, what is the court
So,
proceeding?
in short, their lordships said they may hear both matters afresh.
The court will go into what is on record.
Okay.
What has happened in the court, that cannot be.
So we were given a choice of having both matters heard afresh or having both matters dismissed. We agreed to have both matters dismissed.
So I put it to you that the basis of your claim on account of interest has been rejected by the Supreme Court, as well as by the has been rejected by the Court of Appeal and affirmed and not interfered with by the Supreme Court.
Both the division bench, the Court of Appeal, and the Supreme Court were misled by the bank's claim.
Sir, only the things is that simple, whether the appellate court has dismissed your appeal and the SLP,
Yes,
Supreme Court.
they were both dismissed.
That's all.
That's it. Now, so far as the decree passed by the learned single judge is concerned, did it direct the bank to return the fixed deposit amount with interest? Learned single judge is concerned. Did it direct the bank to return the amount with interest?
The decree of the learned single judge awarded interest, simple interest, on the principal amount. And therefore, the interest that is accruing or was accruing on the decree until 2017, when money was deposited with the court, was 3 lakh rupees per annum. About 3 lakh rupees.
I put it to you that the order of the learned single judge was partially, the decree of the learned single judge was partially set aside by the Court of Appeal on the premise that this money of which lien was created was to be paid and adjusted against the dues of SL Setia liners and Rumplis.
May I refer to the order of the division bench? Book 1, please.
It's a suggestion. You may first agree, disagree.
I disagree. And I disagree. The division bench of appeal gave an opportunity to the bank, but without any opinion of its own. Without offering any opinion of its own. I will just
Without any opinion
of its own. Of the court.
The court.
That's what he's trying to say.
It is on page 54, open inverted commas. We make it clear we do not express any opinion on the enforceability of the Queen's Bench judgment for the purpose of appropriation of the subject fixed deposit amount. Close inverted commas.
And Okay. And and I suggest to you that the observation of the division bench that the decision can be used to establish to be used as an establishment of nexus to the extent as discussed above cannot be disputed by you in this proceedings because your SLP against the same was dismissed. It's a suggestion. You may agree, you may not agree.
I disagree only for the reason that there were many falsehoods under which the learned judges were laboring at the time.
Many falsehoods,
plural.
False? Falsehood.
Falsehood. Yes, next.
I put it to you that since the order of the learned single judge was set aside to the extent that is indicated in the division bench order, your claim for interest was also set aside.
The order of the learned single judge was not set aside. It was upheld explicitly.
I suggest to you that your calculation of interest
I disagree.
being exhibit
I disagree.
is incorrect. Appearing at exhibit blank is incorrect.
I disagree.
I further put it to you as incorrect. I further put it to you that your counterclaim on account of to the tune of 40 crores, Naki? To the account of rupees 40 crore is without any basis.
I disagree. It is now 155 crores.
I further put it to you that your claim on account of additional interest of 2 crore 49 lakhs 07218 is also with 0 comma 49 comma 07 comma 218 on account of additional interest is absolutely without any basis.
I disagree.
I further put it to you that your claim on account of punitive damages for the sum of rupees 40 crores is also without any basis and has not been established before the court.
I disagree. For 38 years, I have been harassed by the bank with fraudulent stories, a different story for every judge, a changing story before every judge, and a contradictory story. So I do not think my claim is without basis.
That's all. Thank you.
The corrections are given by
A different story for every judge.
next day.
Therefore, I do not think my claim is without.
Any witness further?
So we don't have any further witnesses, but
there is another defendant, my lord. I don't know whether
Who is that? Or
Reserve Bank of India.
who is appearing?
no written statement.
Oh, I don't know.
As I know.
No written statement.
Never appeared.
Oh, Mr. Khan.
Okay, start.
No, no.
Then argument can we begin because our witness is gone last. Your lordship
Oh.
prefers the plaintiff to
Just one.
Defendant adduce evidence.
My-
Defendant.
If your lordship gives me a minute.
My lord, I had one more question.
Just a minute.
I had one more.
Just a minute.
I further put it to you that the defendant number 3, Mr. R.K. Khanna, is the best witness possible, is the best person to give witness in this proceedings. Do you agree?
No, I don't.
Okay. I further put it to you. Are you aware whether he is alive or not?
I heard he's alive.
I further put it to you that that the defendant has not come, Mr. R.K. Khanna, that the defendant number 3, Mr. R.K. Khanna, who was the solicitor of R.K. agencies, has purposely not come forward to give evidence because the case that you are running before this court is incorrect.
I know nothing about that, and the matter is 40 years old.
That's all. Okay, sir. Yes.
My lord, my witness is over. If Mr. Ghosh doesn't have.
Now your witness. So with regard to the deposition you have gone through, what is the character?
We'll correct it. We'll get back. And
No argument.
For arguments.
Oh,
Argument and reading of deposition.
Yes.
2017, man.
On the
After vacation. Yes. The defendant witness is present. Full list of cross-examination resumed and concluded. Counsel for the defendant submitted. They will not adduce any further evidence. Accordingly, evidence on the side of the defendant is closed. Let the matter appear.
A week after that.
Already got 12th and 13 है खाली है 13 खाली है 12th and 13 January 2026 for argument.
Mr. Ghosh is to start.
Yes. Defendant's argument.
Obligation.
At 3 p.m. Yes, call the list.
Time for the 26 and 7.
My lord, I'm appealing for respondent number 1, Reserve Bank of India.
My lord, this is a matter concerning, my lord, there have been several orders passed in this repetition. My lord, I have challenged, my lord, my civil report in effect. My lord, the civil report. My lord, I am an individual citizen, my lord. I have admittedly, I've stated on oath in my writ petition that I have not taken any loans from any financial institution. I have taken certain credit cards which are there, which I have enclosed. And apart from that, I have total two credit cards. Suddenly, I find, before filing the writ petition, I suddenly find that my civil report has deteriorated because of certain information showing loans which I have never taken and credit cards which I have never availed. Under section 21 of the Credit Information Companies Act, CIBIL, being a credit information company, is obliged to maintain correct records in respect of a person's financial history. Now, I challenge that by way of the writ petition, saying that CIBIL has to correct their CIBIL report so as to show that there is no outstanding loans since I have not taken those loans. An order was passed initially by the Honorable Justice Shobhoshachi Bhattacharya, directing all parties, or rather all the financial institutions, to file affidavits. But some affidavits have come forward. Lastly, it turns out after that my civil report has been rectified largely. Only one problem remains in respect of the respondent number 4 in the writ petition. Mullah will kindly, I won't take Mullah through the entire thing. Mullah will kindly have Mullah's last order, the last order passed by the coordinate bench. Now that will clarify it. Mullah will see.
Yes, who is
one
appearing
respondent number 4. Yes.
PAU?
I appear for civil matter.
4, pay you.
And for 6 and 7. Code had not appeared initially.
Mr.
Application they had appeared.
On
Sudhakar
29th of October, they had appeared, Your Lordship.
Sudhakar Thakur.
Yes, my lord. We had also served during the hearing itself. We handed over a copy of the writ petition and all the application that was done in court itself. Thereafter, my lord, apparently he is not come. My lord, it is really for the respondent number 4 only to update, because today CIBIL has come forward and my lord provided certain documents which shows yes. They've shown CIBIL is now saying that respondent number 4 has intimated the CIBIL that a 66-year-old lady has taken some loan and her name happens to be the same name as the petitioner, but the PAN details, her age, her residence, all is separate. Now, that is why, my lord, we had taken a stand that at least an affidavit should be brought before court, or respondent will intimate this, my lord will kindly direct us, because we don't know where he says we'll intimate respondent 4 once more, and if not, my lord, we'll proceed with the matter. Because there was a categoric direction upon the advocate appearing, because he sought to file a vakalatnama also before this court.
Yes.
My lord, I am appearing for Reserve Bank of India. They had made complaints which were catered to. There is no dispute with regard to that. The
Reserve
complaint
Bank
was
we don't
initially lodged against Axis Bank. Axis Bank had resolved. So it is only now with PayU to come back.
PayU Finance has to, my lord, will kind.
CIBIL does not update any suo motu, my lord. It is based on the information received from the financial institution and banks, my lord.
May I?
So we have, as per their requirement, we have also supplied the documents on the basis of which this updates has been made, my lord. Now this is PayU has to give the correct information, my lord, in order to resolve this.
May I pray, my lord, for only this order, my lord? My lord will direct respondent number 4 to file an affidavit. My lord will direct them to file an
On
affidavit.
29th October 2025, the respondent number 4, namely PayU Finance Limited Private Finance India Private Limited, appeared to the learned advocate, and a writ application was served upon the respondent number 4 for taking appropriate instruction and for filing vakalatnama. Today, when the matter is taken up for hearing, none appears on behalf of the respondent number 4. No accommodation is sought for. This court finds that the report from the respondent number 4 is necessary for adjudication of the present date application. Accordingly, full stop, the petition is directed to inform the next date of hearing to the respondent number 4, and the respondent number 4 is directed to file affidavit in opposition within a period of 2 weeks from the date of receipt of the communication. Let the matter appear on
within a week, my lord, we'll do it. We'll do it immediately, my lord.
16th December.
My lord, only one humble submission, my lord. My lord, could a date and time be fixed, or a time be fixed so that
we come on that? Let the service come.
My lord, because if they don't appear, we'll proceed ex parte. My lord, we'll kindly indicate that.
It is made clear that even after receipt of the notice, if the respondent number 4 will not appear, the case will be proceeded against the defendant number 4 ex parte.
Obliged. Deeply.
Lord, item number 11, Lord, I oppose the writ, and item number 12, my Lord, it's my writ petition.
In item number 11, my Lord, I am led by Mr. Suman, my Lord. Basically, my Lord.
My Lord, my writ petition is for a new connection, LT connection. It was rejected by the CSC authorities on the ground that existence of an HT connection, LT connection cannot be given. Well, I approach this honorable court. The private respondent who used to holding the HT connection, my lord, they are taking the plea that I did not pay the electricity dues and the other charges. We took a specific point that other charges cannot be stand in the way on the getting, my lord, electricity charges, because electricity charges we have paid there are a lot of disputes, because that will take your lordship's time. Just to nutshell is that they kept on raising the parking charges. They kept on raising the other maintenance charges of the property. They are maintaining the property. It is pertinent to mention, your lordship, that they are not the owner of the property anymore. At present, they are not holding any line, any property. I am a tenant as well as owner in respect of the property, and ownership I have got from the private respondent. There are two private respondents. One is Prabha Devi Sharaf and another is Niket Sharaf. The Prabha Devi Sharaf, who got the property by way of deed of gift from her husband. Husband was the owner. The son, Niket Sharaf, he is not the owner of the property. In no way connected with the property. He got the meter HT connection which was existing in the name of his father. That is the original owner of the property, who was the 50% of the entire property owner. Got the connection transferred in his name. Niket sir. And I am told that by way of
the property from whom?
From Prabha Devi Sharaf. And other 50%.
When you purchase the property?
I have the deed also, purchase deed.
And the bill which they are raising, that is in your possession or prior to that?
Well, prior to that and even after this also.
So you are continuing with that?
They are continuing with
that connection which has been provided to Niket. You are continuing with that connection.
I came to the picture after the Niket got the line transferred in his name.
Correct, whatever it may be. So you are continuing with that.
Yes, I am continuing there.
So you have an access.
The premises is a two flat side by side joined together. 50% I have purchased from the Prabha Devi Sharaf, who became the owner, and other 50% I am not a tenant under this Sharaf family. I am a tenant under one, my lord, the Hajari, one Hajari. But they are not claiming any, my lord, rent from him. But that is a dispute which this Sharaf, Prabha Devi Sharaf and Niket Sharaf, they approached the city civil court with a prayer for injunction that I will not be allowed to use the car parking space. That was rejected. Went to this honorable court. Thereafter, that was also remanded to the court below so that matter can be heard out, and that is pending for adjudication. So their claim in respect of the other heads, including the electricity charges, they themselves approached the civil court for recovery of their dues. Recovery of their dues, alleged dues. From me. This is one aspect of the matter. But in this situation, my lord, my approach before this honorable court, the earlier bench, was that I am paying the electricity charges till my connection was disconnected in way back in March 2025. I am still in dark, without electricity. But
yes,
yes.
You don't
no,
hear all these things. Opposite party may say anything.
Senior member, his comments should be taken care of.
Yeah.
So, my lord, the other heads, my lord, there are dispute because they are not the owner of the property. They are collecting. They used to collect the rent. They are collecting the other heads, which they are exorbiting the amount. We protested. What happened, my lord? That whenever I make any amount payment is made, they are adjusting with the entire dues. The record will show that they are collecting. Yes.
CSC?
No, not the department. CSC is nowhere in the picture.
Private respondent.
The private respondent who are holding the HT connection. Well, thereafter, we went to the earlier bench. The honorable court, this honorable court specifically inquired. The learned advocate was advocate record of the CSC was given in charge to see whether any charges due on account of electricity or not. But why this segregation could be done? Because in their opposition, that matter is ready for hearing, the first matter. The opposition filed by the private respondent, they have categorized that these are the heads, this is the money due. So from there, it can easily be understood that what is the amount due on account of electricity. So it was a task was given by this honorable court to see whether I paid the entire electricity or not, electricity charges or not. It subsequently revealed that I paid the entire electricity charges, because it would be my contention, because it should be verified. It has been verified. The last order will speak so.
So you got the electric connection?
No, my lord. Thereafter, the honorable court was satisfied with the contention that I paid the electricity charges, directed the private respondent to see that the electric connection is reconnected. My connection is reconnected.
Restored, yes.
Restored. And if it is not done, directed the CSC authorities to disconnect the entire HT line, because it is their duty of the my lord, the HT connection, my lord, the licensee, to see, because their agreement is for my lord, for subsequent my lord, the distribution. My lord, if the electricity, if any sub consumer is my lord, is paying the electricity charges, it is not desirable that his connection will be disconnected. So on that score, this order was passed. My lord, they went to the this honorable appellate court, my lord, the division bench. The division bench specifically held that since the disconnection has already been done, CSC has already inspected the property, so nothing remains. You make a prayer before the learned single bench. The matter is returnable on a particular date. My lord, the private respondent, my lord, they did not file any application with a prayer the liberty given to them. Instead, that they file a separate writ petition with the same context. They file the appeal that they are the HT connection holder. They are paying they are distributing the electricity to others. There are more than 70 to 73 persons they are affected. My lord, as on that, I must point it out to lordship that since there was no electricity, the other persons, they have also applied for LT connection in that premises. Now there is no word. So far as I am being the writ petitioner is concerned, without HT connection, that the existence of HT connection, LT connection cannot be given. That is the contention. That was the contention of the CSC. That contention is no more there till the date. There is no HT connection. And my lord, regarding, since my lord is taking up both the matters together, but I will be taking up demerit, my lord, point in respect of maintainability of the subsequent matter, the item number 12, filed by my lord Sarab.
Take the demerit, because he's arguing that he will argue the demerit.
But as per the last order, CSC report, where is your report of the CSC?
My lord, I'm taking a lawsuit leaves to file them. Copy আছে গো দাদা? Then form আছে? Yes.
So that also disconnected.
No, we have disconnected on 13th October 2025.
So thereafter it is not restored. Whether any restoration?
No.
No.
My case also.
Disconnected means not my learned friends.
Other
HT supply,
connections.
entire premises.
It is disconnected. So they have not challenged this.
Second writ petition.
That is
the challenge. It's not a challenge, man. Effectively, I want restoration of the connection. That is what.
You want the restoration of HT line. What about his content?
Yes, ma'am. I will address his issues. Because his issues will not, he has perhaps not indicate the two correct facts.
My lord, the demerit which I am taking, my lord, regarding my learned friends, the second writ petition regarding the restoration of the HT connection, my lord, the point is that, my lord, this appellate court, this honorable appellate court given them the specific liberty, that is at page 369, volume 3 of the second writ petition.
Page
369, my lord. May I read it out? This appeal is directed against the judgment and order dated.
Where is the operative portion?
Yes, my lord. My lord, operative portion, my lord, kindly see the next page also, my lord, is recorded, my lord, being aggrieved. My lord, here, my lord, Mr. Sanyal has stated so. Last paragraph of page 371.
Yes.
We therefore see that the order impugned has worked out itself out. The petition is still pending before the learned single judge. The matter has been directed to be listed by the learned single judge 1 week after Puja vacation. In the view of the aforesaid, we are not inclined to interfere. It will be open to all the parties, including the appellants, to make appropriate prayer before the learned single judge. So instead of filing any application for this prayer which my learned friend is trying to seek, my lord, they filed a separate writ petition which amounts to multiplicity of proceeding and bypassing the issue because they have.
What is the temporary in that?
But the matter is that they are trying to make out a case now that 73 persons, none of which the writ petitioner is, that means the Saraf 1 and Saraf 2, none of which they are not drawing connection, my lord, from that HT connection. This is not their case in the writ petition that they are the owner of that property. My lord, may I indicate only one thing before your lordship, that this 63 Rafi Ahmed Kidwai Road has 2 buildings which they consciously omitted. One building is a mix of the residential and commercial, where this HT connection is given. And there is another building, I am told, that is an existing LT connection is there. So far as the block.
So you're in which building?
HT connection, that block containing block was getting supply of HT from HT connection. I was there. 50% owner, 50% tenant under that Hajari. My lord, that particular block, my lord, having HT connection. Now, in the writ petition, they have not stated. They simply stated they are the co-owners. So far as that block is concerned, none of the writ petitioners in the second writ petition is the owner or a lawful occupier. My lord knows, for the purpose of giving electric connection, one has to be owner, other legally occupied, or a tenant, or something is to be shown. Nothing, no averment, no document to show that they are the owner or they are occupying a particular portion of a property. So, in nutshell, they are espousing the cause of the other persons from whom he used to supply. This is not a public interest litigation. My lord, they are, my lord, the background of the story is that they are
Prayer they wanted to
restoration, my lord.
HT connection.
HT connection as on
been disconnected in terms
yes,
of the
as on date there is no connection.
Correct.
They failed to discharge their duty as a HT connection holder to give supply to other persons who used to draw electricity, in spite of court satisfaction to the fact that each and every electricity charges have been paid. And the other charges, my lord, I have just submitted, that is subject matter of a civil dispute before the learned city civil court. So they have failed to discharge that. And not only that, as on date, if the question of restoration comes for adjudication before your lordship, my lord will consider whether they are entitled to get an HT connection at all, as on date.
Whether you challenge that as HT connection in your writ application?
No, because that I will be taking the point in the opposition if my lord so pleases to give me in the second writ petition. Because now the question.
In the second writ petition, you are taking whether you wanted to file a counter claim by way of an affidavit.
I can anyway take. My lord knows this type of litigation, my lord will examine, and the CSC authority will also answer to the point whether HT connection to a person will be given or not in the given event scenario. Just because one person has got the HT connection and it will be continuing for a long time.
No, that's why.
My lord will consider it, my lord.
You file the WPO
On a
296.
simple context that my application for LT connection, let me give LT connection because the HT connection holder licensee, they have disconnected and I am without electricity since March. My scope and ambit of the my writ petition is only that much to get a
That's
HT
why.
connection. Only this much. Absolutely, I'm developing.
That's your contention in the writ petition.
That was my contention, and that
In
is
the
my
writ petition, they wanted in terms of this order, the electric connection has been disconnected, that has to be restored. That now it has to be adjudicated on facts.
my lord, that is, my lord, that they could have done it by way of an application in my because the app.
Where there is no prayer for restoration of electricity of the entire building. Subsequent fact, I'll file an application and seek an order which is beyond the writ.
My lord, because the liberty is given by the Honorable Appellate Court.
Make the prayer. Liberty is
Okay,
not
let the court decide.
That I leave it to your lordship.
Now, my lord.
So far as my writ petition is concerned, because my lord will examine their case also, that as on date, there is no electric connection, and as on date, there is no HT connection as well.
Where is the rejection of your request for grant of electric connection?
Rejection, my lord, আমার রিটটা দাও, ফার্স্ট রিটটা। অ্যাবারমেন্ট একটু বলে দাও, ওই যেখানে ডকুমেন্টটা দেওয়া অ্যানেক্স করা আছে। Paragraph 19, my averment is there, and the letter and the submission before this honorable court, that was also there.
Where is the document where your
CSC authorities inspected my premises.
Where is the rejection order of the CSC declining for giving electric connection to you and demanding the dues of the earlier pending bill?
No, my lord. CSC authorities has not gone into that aspect. They simply addressed to my application for LT connection.
Where is that?
Yes. Page 46, my lord, of my writ petition. That is their notice of inspection.
46.
My lord. Thereafter, my lord, kindly come to page 47.
Yes.
Page 47, my lord has got it.
Yes.
The next paragraph, second paragraph. The finding of our site inspection indicates that HT supply exists in the above premises. We are not in a position to entertain your request for LT supply, such and such.
Yes.
My submission is that, but there is no rules or regulation which specifically indicates that existence of HT connection. Because of existence of HT connection, LT connection cannot be given. Because I could not find any judgment in that regard also by past this honorable court also, my lord, that it cannot be given. They are taking the point of hazard, electric hazard. Because of electric hazard, this cannot be given. My lord, if that be so, my lord, if my connection is disconnected for a ground of collecting other amount, which is being adjudicated before a civil court, my electric connection, they will disconnect. Though the suit is filed.
So that's why I'm asking who is claiming the earlier amount, the pending dues?
The Sarafs and family, the private respondents.
Where is that?
My lord, that is their opposition. Their opposition in the writ petition they have filed.
No, in your writ petition, you have to make out your case in your writ petition.
Yes, my lord. Yes,
where is that?
My lord. দেখো writ petition paragraph. Page 7, paragraph 13 of my writ petition. And all subsequent paragraphs. That is, I have addressed the disputes which, my lord, caused, my lord, their charges. In their opposition, they have categorized the heads under which they are charging.
Yes. Yes.
Here I have made out my cases that because of, my lord, the document also, my lord, if my lord so pleases, I can show your lordship the document, how exorbitant amount is being charged from annexure P1 onwards. 75,000,
Where is
59,000,
that?
page 25,000. A person is managing a property and holding a flat over there. They are charging how much money they are charging. My lord, kindly see page 25, annexure P1.
75,592.
My lord, kindly see. That all have been paid. My lord, kindly see. But first heading is the electricity 5,137.
Yes.
My lord has got it.
Yes.
Thereafter, utility charges 7,000. Maintenance charges 3,400. Rent is not categorized here. In their opposition, just may I point it out how they have categorized their payment, their demand at paragraph.
When it was issued to you?
Paragraph 14. 14 in their opposition to the first writ petition. Either of the opposition, same averment, same document. My lord, kindly take either of it.
From where? From whom you have taken the electricity connection?
Electricity connection I am taking from my learned friend's client, that is Mr. Sarafs, the private respondent.
If you have taken the electric connection, so who will pay the electricity bill?
I am paying electricity. I paid the electricity charges.
When?
Well, I paid the electricity charges to the private respondents. Well, kindly see the to the Sarafs, to the private respondents. Application
Why is this dues?
The due they are charging on the other heads. They are charging the property tax, they are charging the parking fees, and they are saying their stand is very clear. Unless you pay those charges, I will not adjust your amount on account of electricity. I am paying the amount on the account of electricity charges. They are adjusting against the entire charges. That they cannot do, with due deepest of respect. That is the arm twisting method, because they have subsequently they have resorted to civil court also for recovery of the dues of the other charges. Printed copy though.
What is the prayer in the civil suit?
Civil suit for recovery of the amount including electricity charges.
This amount is also there. 2,33,000.
Yes, my lord. Yes, in their opposition also they have my lord. In their opposition, they have annexed the suit at page 37 of the opposition. My lord, kindly see. 37 is the prayer.
37 of?
27 is the starting of the, opposition, my lord. I stand. Opposition. Their opposition in my writ petition. First writ petition.
Prabhadevi.
Prabhadevi, can kindly take Prabhadevi.
37.
Just a minute.
No, 37 is the notice. Final demand notice. Where is the suit?
My lord is taking the opposition of Prabhadevi Sharaf.
Yes, 296, WPA 296.
WPA 296.
Yes.
Just a minute. Prabhadevi Sharaf, Sriti Sharaf. If my lord takes the other opposition, kindly. Because respondent number 6 opposition, Sriti Sharaf. That is Nik's wife, who my lord.
37.
Kindly take page 27. Page 27.
24. Paragraph 24. Yes.
My lord, page 37 is the, my lord, running page 37 is the, my lord, prayer.
Yes, yes.
So this is there, that is for pending for adjudication regarding the other dues. So on that account, they cannot cut my electricity because of electricity. And my lord, this honorable court have already found that electricity, on account of electricity charges, we have paid the entire money. Yes, we have paid the entire money because the learned advocate on record of CSC, he was given charge to see whether money is paid or not. As per their opposition, the head electricity is given. That is at, my lord, page, my lord, paragraph 14 of any of the opposition. My lord, kindly would see page 7 of the opposition. Excellent. Yes, that is, my lord, kindly see our opposition there. The rent, parking, electricity, utility, maintenance.
Correct. The
Total.
same thing.
So they have themselves categorized the electricity dues.
Correct.
So on that basis, the earlier bench, this honorable court specifically directs whether electricity amount which is.
That's why I'm asking from which till which date you have paid the electricity.
Yes.
Show me the bill.
From a document.
There might be a demand from them, and you have
Yes.
paid the electricity. Where is that demand?
My lord, the amount I have paid is
Demand.
given.
Where is the demand? Without the demand, how you have paid? Where is the demand of the electricity? Where is the bill of the electricity?
Electricity, it is my lord, categorized in their entire bill. Like they have issued a consolidated bill. They never.
That's why. So you have paid the bill. When you have paid the amount?
I paid the amount. Kindly see page 25 of my read petition. Kindly see one by one. I am showing page থেকে দেখো কত কবে কোনটা পে করেছি পেজ গুলো বলো। If my lord sees side by side,
yes,
that pay their opposition, their demand.
Correct.
Their demand of 4,428 for the month of March 24.
Correct. So
That
this
is-
page 25.
Page 25 is one of the cases of 5,175.
Page 25 of which month?
Page 25 is of my lord September.
September 2024.
September 24.
Now come
That
to
is at
September
page
20. September 2024. 4,000.
5,000 my lord. 5,000. এই পেজটাই দেখাও না।
No, electricity. They have recorded the 4,000.
July
804. 805. That is not here. As per this, the electricity 5137, and what they have
This is,
given.
my lord, this is in August because my lord, this bill was generated in September, page 25.
Yeah.
That is for the month of August.
Hmm.
But kindly see page 7, last entry, August 24.
Correct.
This amount is telling 5,137.
35 of the writ petition.
Acha, bill dated, okay.
Yes, my lord.
5,137.
So, my lord, kindly that is telling with page 25.
Correct.
Now the payment is at.
No, 5,700, 5,137.
Yes, the
7,336. Then 3,448 maintenance. Come to that.
I am satisfying your.
So whether this bill which they have raised, have you paid or not?
But kindly comes to page 35. বাকি অ্যামাউন্টটা কবে পে করেছি দেখো এই বাকি অ্যামাউন্ট
এই যে আমি তোমায় বলছিলাম 26 অবধি হচ্ছে কনসলিডেটেড অ্যামাউন্ট
ইলেকট্রিক নয় স্যার জজ স্যার জিজ্ঞেস করছেন যে এই অ্যামাউন্টটা টোটালটা কি পে করেছি
টোটাল
That's why because they are claiming this amount, they are claiming the amount from March 2024 onwards. Correct.
Yes.
They are claiming the amount from March 2024 onwards.
Yes, I'm
February 2024 you have paid. Where is the bill of February 2024?
No, February, my lord,
February
that was not consolidated payment was made. My lord, I am satisfying your lordship. My lord, they are claiming electricity charges and other charges. My lord, kindly see the bill of page 25, the bill.
26.
Page 25, yes.
The bill.
Yes.
Here, my lord, kindly see the entry. Previous month's dues and penalty. Previous month's due and penalty. My lord has got the point. That is just above the maintenance amount 3,400, just above it.
Previous reading 32549.
Previous month's dues and penalty.
Correct.
So up to that month, that yes, I'll try to satisfy. Up to that month, the due was 59,000 odd. My lord, kindly comes to page 36 once. Page 36 once.
Yes.
But kindly see the amount, kindly tally it.
Yes.
This payment was made in 15th of August. So the amount, whatever be the heads, whatever be the exorbitant and my lord, the arm twisting method, whatever amount they have charged, I have paid that amount.
So this paid, when you have paid this amount?
But kindly see page
15th August
36 toward
2024. This paid an amount on 15th August 2024. Correct. So that's why I'm asking. So this was raised September 2024. August bill, you have paid that. No problem. So this bill which you have admitted, where is the previous bills?
No, my lord,
Where are the previous bills?
bills does not come into the picture for the simple reason there is no dispute about it. My lord, kindly see.
Dispute about the court has to see.
My lord, it
whether
is
the
my duty.
previous-
It is my duty to bring those
Correct,
bills.
because the
Absolutely,
court has
my
to
lord.
see
Absolutely.
the prior also the same maintenance and property utility charges and electric charges been claimed by the private respondents or not. If it is been claimed and you have paid, now you cannot revert back. If the earlier only the electricity charges is claimed, no utility, no maintenance, then the matter is clear. So you show me the bill.
That is the point, my lord. I'll satisfy your lordship. But kindly see the page 25, the last entry here, my lord, right hand side. The amount just my lord has read 59,681.
Correct.
The right hand side, the total amount due such and such is 75,000.
Within 16 years. 75.
So the bill is being generated. My lord, kindly see the bill date at the top. At the top, bill date 4th of September 2024.
Correct.
4th of September 2024 is the bill date.
Correct.
Where the money paid on 15th August, page 36.
Correct.
Money has already been paid.
Correct.
In spite of that.
So that's why I'm telling. That's why I'm telling the bill generated 49. You have paid the said 59,681 prior in the month of August 2024.
Yes,
That's why I shown the date of 15th August 2024. Correct. So before getting this bill, you have paid that. So where you got that the 59,681 is due? Show me the previous bill.
Previous bill, I'll bring it. I'll definitely bring it, but it is also lying with my learned friends, clients also.
They will say, you will say that this is the fabricated or forged one because you have paid the amount. So you produce the bill whether they have claimed the amount.
The issue is that as on
There is
September.
no issue, sir. It is totally clear. If you prove that prior to the September 2024 bill, they have not claimed the utility and maintenance. Only from the month of September 2024, they started claiming the maintenance. Then then I am opening the mind herein now. Then I will direct you to restore the connection and claim before the money suit.
So immediately I want, my lord, restoration.
Correct. One thing. If this court find that since the beginning they are claiming the utility and maintenance, then you have to pay the amount. This is
That I'll address.
clear-cut case here.
Yes, that on the next day I'll address your lordship on that, and I'll bring the bills also. I'll bring the bills also.
May I just pray for one small indulgence? Let him deposit 1 lakh in court. Rest of the dues, I want to put in 50%. I want the reconnection done. Let him put in 1 lakh at least. I have no difficulty.
That I have to take instruction because
I am effectively, my lord, 73 people are out of electricity. I am running the premises on generators. Whatever, my lord, CSC says, 10 lakhs, 15 lakhs, whatever. 50% I'm putting in, rest I'll put in installments. Let him put in 1 lakh, my lord, so that I can at least have the
latest that I am for licensing authority. We cannot supply electricity by installment.
I understand, but my
So
lord, they
you have enjoyed, according to the HT supply connection, our
What is the amount
7
due?
lakhs 36,000.
What is the amount due?
7 lakhs 36,387.
Where
Last, that will not be getting your lordship. That will not, your lordship will not be
They
getting. That's
can
we have to.
raise this invoice. They can raise this.
We have already raised.
And my lord,
You have got the bills.
lordship only consider this, my lord. My lord, there.
So
this
see,
wouldn't-
do one thing. 7 lakh. You raise the bill.
We have raised the bill. Apart
Got
from
your
that,
bill?
one more.
So how soon you will pay?
Apart
I'm
from
praying for this. Lordship, kindly have a look at this order, my lord. It has happened. I know Mr. Chanel will absolutely oppose this, but he knows that these orders have been passed regularly before this court, my lord. Where, my lord, there have been restoration which has happened on 50% immediate payment and the balance 50%.
No, that's your losses. That's your losses in case of theft of electricity. That was once I tell your losses. I tell your losses once.
But he's put in 1 lakh for at least to establish their rights.
That's different issue.
They are,
I'm
they
not
are
on
going
that.
in a scot-free way.
I am without electricity since March till date. No. That's a person. A person with in a scorching heat of April and May. April, May, and June. No. It's a no. It's a new thing. It's a new. No. No.
There are no
Absolutely not. Absolutely not.
Single building and there are no two buildings. This statement has come
But
to the
apart
there are
from,
no two buildings.
Super, I'm
Do one
concerned.
thing, you pay the 50%. When you will pay the 50%?
Within 7
No, my lord,
Just a minute. 50%, and you also restored them. And you also paid the 1 lakh deposit the 1 lakh in the registry.
No, my lord, subject
With the
to my
rest- and
only.
the remaining amount, how will how
3 installments I'll put in.
3 installment means
My lord,
3 months.
Yes, my lord. Give me 2 months, I'll put it.
Yes.
My lord, I tell you losses. Apart from the dues, it's a monthly energy charges. My lord, there should not
That
be.
may continue. That he continue.
No, there should not be any installment as my humble submissions. Then second, this is amount monthly due, 7,36,387 from July to October 2025. Apart from that, security deposits run short. This is amount 1,64,653. Unless he secures the deposit, there cannot be any supply in the premise.
That's correct. Bill amount of 50% levy and the security amount also you deposit that. Further the remaining amount within 2 installment within 45 days you pay that.
60.
Kindly do not allow restoration with an installment, my lord. That's
Supreme Court has permitted.
No. Supreme Court is not. This is not the law.
He deposit the 1 lakh rupees in the registry and you also restore the connect.
Let him deposit 1 lakh.
But only one.
Now I tell you losses further. No, my lord, both the writ petition should not be entertained. Since my learned friend answering the second one, your losses kindly consider this. This is, my lord, virtually against an order of the learned
By
sanction.
this court. Yes,
My lord, this is right from 1963 is maintainable when he is not a party, but the order was passed against him. He was argued, he was heard.
Because appeal already appealed.
That's your losses. So therefore, my lord, that should not be. And your losses, my humble request to your losses, kindly do not give any concession to these sort of petitioners who enjoyed the supply and asking for installment. We are not at fault. This is oh no. This is a habitual defaulter.
Regularly agree before certain benches.
No, my lord, this I tell your losses. This was once being done. No. That's a different issue. This is not the law, my lord, either.
This is exactly in case of discontinuance of supply. Paragraph 4, my lord, demand notice of 28 lakhs would have been issued. Questions whether court was right in directing payment of 5.6 lakhs. The High Court.
That's only another issue.
2.6 at the same time directed respondent because 5.6 without adjudicating normally in matter of monthly could be directed.
That your lordship doesn't lay down any law. Second, my lord, there is a dispute. There is no dispute.
With regards to this.
Exactly. Then why should there be an installment?
I am praying, my lord, I want to put in
647.
balance, my lord, what you kindly permit.
Because he is an habitual defaulter. He is defaulting since April. Then he deposited certain amount. Then accumulated this. This will encourage the
when the disconnection was made.
13th
October. Because of this order, because of the order. Not with regard to the due. Not because of
the right also because that matter was pending and we have to issue the disconnection notice then. So that was the situation.
So you do one thing, you pay the 50%, come here, then I will pass the proposal.
Very well. I do
when
that.
you pay. And along with the security charges.
Yes, I will.
When you
and my lord, what you kindly take counts.
No, only one thing. No, only one thing. But they have resorted to civil court. I know your lordship's my lord, approach to resolve the issues once and for all. That my lord is without goes without saying. So my lord, their civil court, their adjudication for the other charges are pending. My client is very serious about the asking for rent because they are not at all the landlord.
That's why
That's why, my
that's
lord.
why this court is wanted to see the previous bills. If the previous bills
Yes,
are the
but that I'll
so nothing else.
previous entire amount is paid, my lord. Entire amount is paid. I'll satisfy your lordship. No, my lord.
That's why 59,000. That is including the utility and the maintenance.
Everything, including everything till date. No, yes, obviously till date that has been paid. So up to that that date, 4th of September, when the bill was generated, up to that date there was no due. So we have paid.
Okay, Mr. Sanyal, let it deposit the amount. How soon you will deposit? Today we are
within 7 days.
not 7 days. I
Oh, very well. Lord, any day
you deposit by Tuesday.
I will.
You deposit by along with the, what is the security deposit?
Now, I tell you, look, there are 3-4 accounts of
Give the
deposit.
details. Give the details. I will pass.
Tuesday is the date,
tomorrow
my
for
lord.
orders. Give the details.
I will bring the details. We'll also take it up.
Tomorrow for orders.
Yes, tomorrow.
Mal. But the amount of 1 lakh, well, that will be very high because the other heads they are charging because electricity charge I have paid. That is no dispute about it.
I am making the for the interim. Then I will hear if I that's why I'm telling you, if you are having the bill file, we have supplementary affidavit. I will decide. This court will find that automatically.
If that is I'm very much
I will direct the, you will.
I'm very much obliged to your lordship. If my lord is clear about your lordship's view and that will be indicated in the order itself. My lord, I can right now I cannot pay 1 lakh.
That's why I'm come tomorrow.
Yes,
Please see
with
so that
the
you are-
instruction so that I can some amount to honor the court, not to honor my lord.
Humble request, your kind.
Yes.
Speak at 2 p.m. tomorrow. Because 3:30 is very vulnerable.
No, 3:30 2 p.m. now. Kal 3 baje hai. 3 p.m.
And kindly pass.
Top maker.
3 hole time pabe
It will be a matter at top under the ND order.
Yes.
Your Honor, may I mention, I had mentioned the matter in the morning.
The
Your Honor, may I just make a mention?
Just a minute. Counsel for the parties have argued the matter at length. Full stop. Let the matter full stop. The counsel for the petitioner waits for time to take instruction. Full stop. Counsel for the CSC is directed to give the details pending against the private respondents by tomorrow. This is the matter tomorrow for under the heading orders.
Ma, your lordship is passing the order item number 11 or 12.
11 and 12.
Both.
Then my lord, one order is to be required when both the matters to be heard analogously. Yes, my lord will take care of it.
My lord, item number 85. I'm sorry. I'm so sorry to disturb your lordship at this hour. My lord, item number 85, just extension of interim order.
No, my lord, well, extension I can't oppose. Well, it is that matter where I have been mentioning.
That you mentioned it after.
Well, if your lordship could, well, this lordship.
I request the bar to make a resolution, make a request to the chief. The time court time is to be extended.
The lordship is
Your Honor, can I now mention the matter? Your
But
Honor, I mentioned in the morning
thing is-
earlier.
I will take.
Please, Your Honor.
84.
85. But only thing is, when I had mentioned this matter when previous week, lordship said to observe how it goes.
After 1 week.
No, that is why I have waited for 1 week. If your lordship could,
No, you mentioned just day before yesterday.
it feels like a week.
No. Lordship judgment is to be given due to them.
The counsel for the plaintiff.
Yes,
sir.
Petitioner.
Plaintiff petitioner.
Plaintiff slash petitioner prays for extension of interim order. Counsel for the respondent contemner raise objection.
Alleged one.
Raise objection.
Alleged contempt.
Huh?
Alleged contempt.
Alleged contemner raise objection. Police. This court find that the petitioner is enjoying the interim order for the quite some time. Accordingly, the interim order is extended till 24th of December 2025 or until further order. Let the matter appear on 23rd December at 3 p.m.
Grateful.
Mention this matter, my lord.
Yes.
Due to appear tomorrow for update, my lord. That is content matter, my lord.
Which one?
My lord, that is due to
WPF, this original side matter?
My lord.
Give the note.
But
Yes, madam.
I'm sorry.
Please, Your Honor. Your Honor had mentioned the matter. Your Honor had directed me to go to court 5 and mention I've made a mention they have allowed. Your Honor, I'm only requesting to release it so that I can file its writ
So
petition
this
number
matter was mentioned in the morning. This matter was mentioned in the appellate side matter.
But my
27195 of 2025, writ petition appellate.
but my appellate side
Your Honor, I tried mentioning at 1:15, however, I could not. Your
Yeah,
Honor,
you
I have
don't-
urgency. I have to get my matter taken up on
tomorrow
Monday.
morning. You mentioned the matter. I will release tomorrow itself.
Your Honor, I had mentioned today itself in the morning, Justice Ghosh is allowed to be listed on Monday. So I'm just asking
Monday.
for
Okay, tomorrow
release.
I will release tomorrow. I will pass an order. Ma'am, and
Please,
the
Your
first
Honor, I am deeply obliged.
you mentioned I will pass an.
Lordship may
Please,
have
Your
the
Honor.
Item number is 35, and I appear for the petition. 35 is Lordship's original site list. I appear for the petitioner. Affidavits have been exchanged. It is ready for hearing any day. My lord. No, there is no urgency to 35. But
You are appearing.
no, no.
if it could be,
35 it is in the list. So
it is in the list. But if it could be way down in the list,
yes.
very great.
Lordship, item number 116. My interim order is expiring today, so it may be extended. I have served notice to the other side. They are here.
For the other side. So you are objecting? No. As per the prayer made by the counsel for the petitioner, interim order extended till 19th of December 2025 or until further order whichever is earlier. Let the matter remain in the list.
Much obliged, Lordship.
Alright.